Call to order this June 22nd, 2020 continuance of the Seattle Waterfront LID assessment hearing. Today, as planned, is the first day for cross-examination by objectors of city witnesses. As a reminder, only the city and objectors planning to cross-examine the city's witnesses will participate directly in the hearing today and the following days. Other objectors in the public may listen to the hearing via listening line established on the Office of Hearing Examiner website front page. Callers will be able to listen to the hearing but will not be participating in the hearing for any other purpose. There will be no Seattle channel broadcast for this segment of the hearing. The lack of broadcast will give us a slightly more flexible opportunity with the schedule. We will try to take a 10 a.m. break for 15 minutes, a lunch break for an hour and 15 minutes at about noon, and another break at about 3. However, since we're not stuck to the Seattle channel trying to stop at a specific time, I will stop generally about when I see a good opportunity for us to do that around those times generally, depending on where we are with the witness and questioning. Remember that this is a remote hearing, that if there are problems with the technology, there may be cause for a continuance. I believe everyone's been on the line for a couple of days now solid, so I shouldn't have to go back through the participation protocols, which you've all received as part of the sign-in and have been read for the past 2 days. If there's any questions about that, we can go over them, or I can remind you as we go forward if anybody has a problem with that. I see that a number of objectors have submitted their exhibits in advance, and I have those available. I'll check now to see if there are any procedural questions, just general procedural questions that any party has before we get started.
Mr. Hearing Examiner, this is Mark Filippini for the city. 2 procedural minor points. One, I believe that we've failed to move to admit C23 through C32 last week during our live direct examination, so I would move to admit those exhibits.
All right. Any objection to exhibits from the city, C23 to C32, being admitted? Anyone have an objection to any one of the exhibits numbered C23 through C32 from being admitted? Exhibits 23 to 32 from the city are admitted.
And the only other thing, you had asked us on Friday if we could look this weekend at any parcels that where Mr. McCauley would need to submit a reevaluation due to additional information gained through this process. And there are 4 of them, and I can identify them by case number.
Okay.
One is the United Way property, and that is case number 0417. And we had, I believe we mentioned that last week, but that's 0417. One is Century Square parcel. That is at case number 0423. The third is the North Arcade parcel in the Pike Place Market. That is case number 0392. And another is City Parks parcel, Urban Triangle Park. That is case number 0184. And that was it.
Okay, thank you. Are there any other procedural items that we need to address, general procedural items, before we start today? All right. I did receive, and thank you, I did receive a list of objectors, how they'll proceed in questioning, and we're starting with Robert McCauley. I think we can just work off that list. Is there any objector that's on the line now who's not coordinated with the other objectors and is not identified in the list that I received today from Mr. Moses. All right, then I'll assume that all objectors have had an opportunity to coordinate through the promptings that I've indicated in pre-hearing orders, our pre-hearing conference that we've had, and discussions last week with the during the hearing with the city's case in chief presentation, and that you all understand that we're proceeding in order here. Otherwise, we need an indication to either my legal assistant or myself that you haven't had an opportunity to ask questions. Just as a quick reminder before we jump into it, and I think you're all aware of this now, the group that I've got on the line now, it does understand that the process is one of elimination as far as questions. So once a question that is going to elicit the same response has been asked, subsequent questioners should not ask the same question again. It's already been established in the record. Similarly, I would encourage you on a similar vein, this is as much the attorneys as the pro se participants, try to not fall into a cadence of conversation with the witness. That's common, particularly with attorneys, to ask a witness if they actually said something, or did you say this, in order to set up the next question. If it's already in the record, it's in the record. I've heard the testimony from the witness, you've heard it. We don't need a witness to keep repeating themselves. When we've got time, when we've got space, and not the inefficiencies that we may run into with technology, maybe I allow those types of questions. It's no harm, no foul, but it really is an unnecessary waste of time. We've got a lot of people waiting to ask their questions, and rather than falling into a conversation where you ask the witness to repeat what they've already got in the record, please save that for your closing argument, where you can simply reference the point in the record earlier where they said it and where the response was elicited in response to the cross-examination. So again, I'm looking for as much efficiency as possible. I want to make sure that everyone does get their questions asked. In order to do that, we do need to be efficient. I don't want to lose the opportunity to question to efficiency. You want to make sure you get your questions asked, but I am going to emphasize that we do it in a manner that gets everyone a chance to get the questions asked they want. With that, it sounds like we don't have any further questions and we're ready to go. Do we have Mr. McCulley on the line?
Yes, Mr. Hughes.
All right. Mr. McCulley, you remain under oath or affirmation from the earlier portion of the hearing. And it looks like we have Ms. Lynn asking questions first.
Correct.
Yeah.
Please proceed. Your witness, Ms. Lynn.
So we'll start with, good morning, Mr. McCulley. We'll start with Exhibit 117. And just so you know, we named our exhibits CWF 233, exhibit, and then attached to number. In fact, we have a lot more case numbers than that. This is just a shorthand. So we'll start with CWF 233, Exhibit 117, which is the lid manual. And we're going to be at page 52, which is actually page 62 of the PDF if you're on an electronic version. And Mr. McCulley, if you could just let me know when you're there. And that's chapter 5.
So excuse me, Ms. Lynn. So exhibit 117?
Correct.
Okay.
Ms. Lynn, can I ask you to share screen for that item, please?
Sure.
Some of the larger ones, I run into problems opening with the wireless here, so I assume if I'm running into that same issue, others may as well. I assume everyone's received copies of the exhibits at this point, so I feel like we're getting more efficient as the participants get used to the process. So if someone is not able to open exhibit, please let us know and we'll ask to share screen.
And can you let me know, can you see my screen right now?
Not yet.
Okay, let's see what just happened then.
May I ask that Mr. McCauley activate his video?
Is that, can you?
Yeah, so I'll help him with that.
Thank you.
All right, we have the share screen showing. Thank you, Ms. Lynn. And yes, Mr. McCauley, you should be visible.
Oh, gotcha. Okay, yeah, there we go.
Okay, I think we're all set to go. Thank you, Ms. Lynn. Please proceed.
Absolutely. So, Mr. McCauley, can you see my screen right now?
I'm got it up on my own
Okay,
computer.
perfect. And so you see Chapter 5 assessment methods, right?
Yes.
And
Or
then we'll just
maybe
kind
I
of,
am using yours. Okay, great.
perfect. And we'll scroll all the way down to the bottom of Chapter 5. And it looks like you are named right here as a contributor. Is that right?
That's correct.
And does that mean you helped with developing this content in Chapter 5?
The only part I didn't write is what Ralph Rodriguez included, which was regarding different methodologies other than special benefit studies.
Okay, but you reviewed this entire content?
Well, I wrote the entire content except for what Ralph Rodriguez wrote.
Okay. So let's go back up to page 52. And if you're following along in the electronic exhibits that I circulated, they are not highlighted, but this is my version.
I see your version now.
Okay. So this says a final special benefit study is an assessment method that documents the proportionate amount of the total lid assessment to be levied on each specially benefited assessable property. The special benefit estimates and resulting recommended assessments are designed to comply with RCW statutes and case law precedent. So when it says special benefit assessments must comply with RCW statutes, that means that means state law, is that right?
That's my understanding, yes.
And do you know which ones?
I'm not an attorney, so no, I don't specifically, I've looked at them over the years, but I couldn't cite them sitting here.
Okay, but you are familiar with them.
Yes.
And do you know if any of those statutes authorize use of a hypothetical before and a hypothetical after value in order to determine a lid assessment?
I don't. That is standard appraisal practice, which would be normally used in the appraisal of property. Whether they're specifically stated in the statutes, I do not know.
Okay. The statutes do address certain appraisal methodologies like the zone and termini method. Is that correct?
That's correct.
Okay, but do you know whether the RCWs address this particular approach where you have a before hypothetical value and an after hypothetical value?
I don't know if the statutes do. I mean, case law would most likely. I mean, I've done every formation study I've done over 30 years has been based on a hypothetical condition because the LID isn't built.
And so when you say case law, do you know, can you point to any cases?
Well, the last one we had was for the city of Edgewater, or Edgewood. And that was ruled on by the Court of Appeals, and the formation of that LID would have been based on the hypothetical.
And that's a hypothetical before and a hypothetical after?
The after the construction was built.
Oh, okay. So the before values were current values and the after was based on a hypothetical? Is that correct?
No, the before value was based on a hypothetical, and the after value, the improvements were constructed.
I see. So the Edgewood lid, you completed the final study after the elements were already constructed.
Correct.
Understood. So do you have any examples of lids you've worked on where both the before value and the after value are based on hypothetical conditions?
The City of Pasco LID we finalized last year was based on the hypothetical. In the after, the LID had not been constructed, and we closed out the LID prior to construction. Then I know the Lake Union Streetcar, which I did not work on that special benefit study, but that was closed out prior to construction of the improvements.
And do you know for Pasco, and that's the one you worked on, correct?
That's correct.
Okay, so for Pasco, Do you know how far in advance you completed, what was the time difference between the completion of your final study and completion of construction of the lit improvements that you were looking at?
I don't know if the project has been constructed yet or not. So I think the time frame was 2 or 3 years to get the project constructed.
Do you remember what design levels you were at when you did the final study for Pasco?
I don't recall.
Do you remember if they were at least at 30%?
I would imagine so. They were, as I recall, they were fairly far along.
Do you know if you've ever done a lit assessment where you've had less than 30% designs other than the one at issue here?
We did well, the number of feasibility studies we've done certainly have been well below 30%. Formation study we did for the Port Hadlock UGA, I think some elements of that study were below 30%.
And those feasibility and formation studies occur before the final study, correct?
Correct. Those LIDs, well, the Port Hadlock LID did not get formed or has not yet been formed.
Okay. And feasibility is not actually recommending any assessment.
It can. We've used it in the context where the city's used the feasibility for assessment purposes, but typically not.
So have you ever actually determined special benefit assessments based on designs that were less than 30% other than the lid at issue here?
Well, like in the after situation?
Yes, correct.
Not that I recall.
For Lake Union Street, you said you weren't involved in that one, but do you happen to know what the time difference was between completion of the final study and completion of the improvements?
Not specific. No.
Do you know if it was more than 4 years?
I honestly don't know.
Okay. So I'm just going to read out a quote from a Washington Supreme Court case that you may or may not be familiar with. It is Heavens versus King County Rural Library District, 66 Washington 2D 558. It says, all such assessments, and they're talking about lit assessments, have one common element. They are for the construction of local improvements that are pertinent to specific land and bring a benefit substantially more intense than is yielded to the rest of the municipality. So when it says benefits must, quote, bring a benefit substantially more intense than is yielded to the rest of the municipality, does this suggest that the benefit must be special and not general?
Well, any measurable increase in value in the state of Washington is a special benefit. That's my understanding.
And so you agree that special benefits must be measurable?
Yes.
Okay, so that's actually the next sentence in this Washington Supreme Court case. It states the benefit to the land must be actual, physical, and material, and not merely speculative or conjectural. So you agree that it must be measurable and must be actual, is that right?
Well, measurable difference creates a dollar amount, and that's an estimate of special benefit.
And how do you define measurable?
The difference market value without or before the LID compared to the market value with the LID completed. And if it creates a measurable difference in value, in my professional opinion, then it's special benefit. If it gets to a point where I don't feel it's measurable, then it becomes more general in nature and not special or specific to an individual property.
And so you've testified before that in your deposition that point is at about 0.25%, I believe 1/4% is what you said, is that at 1/4%, benefits cease to be special and turn into more of a general nature. Is that right?
No, I think you'll find in my deposition that when we got out to Denny, we were at 0.05. We were very, very low, a very low point where when you got on the other side of Denny, we just felt that it wasn't measurable. So in this case, it just was I think 0.05 is what I testified to. I think I corrected myself in the deposition.
Do you know what the lowest special benefit percentage that you calculated in this lid is?
I believe it was 0.05.
So if a property experienced a benefit of 0.049, it would have been immeasurable. Is that right?
Well, when we get to a point, that's why oftentimes when we're looking at boundaries, we're looking at physical elements as well. So when you got on the other side of Denny from where our lowest estimate was, it was not measurable. Therefore, it would be something. It just wouldn't be measurable. It'd be zero, or there'd be no measurable defined benefit there.
So what about 0.045?
Again, in this case, when we got to the lowest point, anything beyond that was immeasurable, and that would be something that would be zero. It just wouldn't be measurable in the marketplace.
So you've testified that anything lower than 0.05 is typically not measurable and therefore would be categorized by you generally more as a general benefit and not special. Is that right?
No, you're misconstruing what I'm saying. In this certain LID, when we got to the lowest point, I believe it was about 0.05, and that is the lowest measurable amount of benefit we had. Anything on the other side of Denny from that lowest point was more general in nature rather than special.
Okay, and I apologize. Seems like we're probably talking past each other. That is essentially what I think I said, but if you want to put it in your words, that's perfectly fine. So if you could, actually, I'll just scroll. So we'll scroll down to page 58 for those of you who are following. And so page 58 talks about utilizing a special benefit analyst to resolve issues. So it talks about making a preliminary investigation, recommending a lid boundary. Number 3 says, consider general benefits as well as special benefits. So can a property receive both special and general benefits?
Well, general benefits probably occur to the LID area and extend out to just an unknown amount of area. But what I'm saying here on item 3 is that I'm talking about we're more. This is more in the context of recommended boundaries, where you've got to consider general benefits in the sense where special benefits end. You've got to understand that anything beyond that's general benefits, and that's what I'm referring to in line 3 there.
So just talking about properties within the lid, do any properties within the lid experience both special and general benefits?
Yes, I think general benefits would include properties within the LID boundary and then extend out to an undefinable area, and that's why they're just not measurable by their definition. They're general in nature to the public at large.
Okay, and so did you consider and attempt to distinguish between general and special benefits within the lid boundary?
You can't. A general benefit is not measurable just by its definition. It benefits the public at large. I've never been asked to do a general benefit study. I don't think it's something it's not discernible in the marketplace. It benefits the public at large. And where that boundary would extend, would it stop in Edmonds or Bellevue or SeaTac? It's an undefinable area where general benefits would stop or start.
The next line, so this line says, the next highlighted line says, consideration may also be given to those construction costs related to meeting design standards, which may be general benefits, as distinct from construction costs emanating from requirements of the LID project. What does this mean?
Well, typically though, and there may be, you know, for instance, Alaska Way is not part of the LID, so it's more general. It's more general in nature. In that context, it's a right of way. So if it was part of the LID, then I would consider it as part of my analysis. Just like the viaduct. I mean, if it would have been part of my analysis, I would have considered the benefit to that. And so we're just basically saying if it's in the LID project, then you really need to look and see if it's specially benefited, if the property specially benefited or measurably benefited from that improvement.
So what does it mean, construction costs related to meeting design standards? What are those design standards?
Well, design standards are just what we're dealing with here, just the level of design that the city has the project at the time you're doing your analysis.
Okay, so does this mean that if there are construction costs relating to meeting basic design standards, those may be general benefits?
No, if they're in the LID and to be considered by the LID, then you'd be looking at them in the context of whether they're measurable or not, and create a special benefit. And if they don't create a special benefit, then they'd be more general in nature and not special. So I'm just dealing with elements that are funded by LIDs. I'm not dealing with elements that aren't funded by LIDs.
I'm going to ask a slightly different question. Would construction of the before improvements have given rise to general benefits?
Possibly.
Are the before improvements, are those considered construction projects that are related to meeting design standards?
Again, I'm only concerned with the design standards that are focused on the LID and what the property rights that I'm valuing before and after.
You also testified previously that some of this content needs to be updated. Can you point to exactly what content needs to be updated?
Well, I just think that was a general comment in the sense that this article was written in 2009, and there have been changes over time. I mean, like this project and other projects I've worked on that I just think it would be beneficial to have a more updated version of this study. And we've talked about that over the years with the MRSC, and it just hasn't happened yet.
Okay,
And
so
it would be from the legal standpoint, from the finance standpoint, and you know the whole context of the study.
And so from a legal standpoint, do you know if that comment, is it due to any actual changes in the law, like in the RCWs?
No, not that I know of. I just think I've had a lot more experience since 2009, and it would be beneficial for the reader to understand maybe some different issues that have arisen over the years. You know, the Edgewood case, for instance, you know, dealt a lot with giving property owners due process. And the city of Seattle did a really good job with that as far as outreach and whatnot. And you know, that's one element that comes to mind that would be very good to have in this study, just to show that, and that is one the courts ruled on, that's a very, very important element to really accentuate when you're doing LID, is to really have a good outreach program.
Can you think of any other examples of where you think there might be updates might be either necessary or helpful?
That's just something that comes to mind. I think just the general restructuring of the comments and adding experiences that I've had in other LIDs would lend a little more um, substance to the article.
Okay. So we're going to move on to Exhibit C18, which is the addenda. I do believe that some people have been having issues with the addenda, so I'll continue to share screen for this one. Let me see if I can get that up. There you go. Okay. Can you see that?
Yes.
Okay. Just, yes. So for everybody else who maybe can't see my screen, I'm going to be scrolling to page A1, which is titled A, Lid, No Lid. I'll also just note that I'm using the designation C18, although I was unable to open C18, so this is just a local copy of the addenda that I pulled off of the online link. So you testify that this section provides a very detailed description of what the before condition would consist of and what the after condition would look like. Is that right?
Well, the whole purpose of the addenda is to provide a high level of descriptive before and after language and also renderings.
So scrolling down to page A3, which I believe you also looked at during your direct testimony, and we'll just use the same examples that you all used. So this is the before description of the rebuilt new surface roadway, and then on page A3, you get to the after conditions. Is that right?
Yes.
Okay. And it says in the after condition, all of the improvements listed above would remain with the exception of the following. And it looks like there are 5 bullet points here. And the first one talks about increasing the caliper of approximately 377 street trees up to 4 inches. The second one talks about adding approximately 16 additional street trees. The third one talks about planters and landscaped areas and the fact that the city would upgrade the ground cover and shrub plantings for a greater diversity of plants. The fourth one talks about how crosswalks at the intersection of South King Street and Pike Street would be upgraded to 6-inch curbs, sorry, and the intersection would be raised 3 inches. And then the fifth one talks about sidewalks that are immediately adjacent to the east side of Alaskan Way, which would be upgraded from scored concrete to exposed aggregate. So can you explain to me, and you looked at this, this addenda includes the information you use to understand the before and the after condition, is that right?
Yes, and the property was looked at as an entity. So all 6 elements were looked at as an entity. We didn't pull elements apart and try to value them separately.
Understood. But you did review this, correct?
Yes.
And so when you reviewed this, what was your process for determining what the value add would be due to these types of improvements?
Well, again, we're looking at the LID as one entity. So there are 6 elements that have been discussed. We're looking at the promenade improvements. We're looking at the Pine improvements. We're looking at the Overlook Walk improvements. We're looking at the Union Street connector improvements. And all of these elements are looked at as an entity. And so again, we're looking at other similar projects that have similarities to this. None are going to be exact, but they have similarities to this in the marketplace. So we're not just specifically looking at this as one particular element and saying, okay, how much in value is that language going to increase value. We're looking at the whole picture of the project as one entity.
Okay, but you did say you reviewed this, so I guess my question is, what did you do with this information, if anything?
Well, it goes to the bigger context of all the other elements that are in the LID.
So there's nowhere in your report where someone might be able to determine how you looked at each of the after conditions described in the addenda and attributed value to those after conditions, to specific after conditions?
That was not the scope of the assignment. The scope of the assignment was to look at the project as one entity and not as 6 individual LIDs.
So talking a little bit about valuing everything all together, all 6 components all together, you've testified that the LID components encompass a variety of projects and improvements, and these include, like you said, the 6 components, and those include things like open space, walkways, running paths, streetscapes, parks, bike lanes, overlook walk, which you've said is unique. Have you ever done a special benefits study where the improvements are so varied?
I'm trying to think about this. This would be at the top of the list of what I can think. The Tukwila one we did had a number of components. The new interchange at Klickitat and I-5, arterial street improvements, the parkway type improvements. So elements similar. The Point Ruston project looked at a lot of different variables, utilities, lighting, promenade walkway, things to that nature. So that had a lot of elements to it before. So this would be at the top of the list of LIDs we've done with a lot of different elements.
For Tukwila, do you remember how many properties were included in that LID?
I believe there are about 280 or so. Included the Westfield Mall, all of the abutting commercial property, and then the industrial property further to the south, and then over to the river, and so it was a fairly large LID.
And you mentioned a new interchange and some street improvements, both of which sound to me like street improvements, and then also a parkway. Can you describe the parkway?
Yeah, I believe it was Strander Boulevard. Well, it was just a lot of enhancement to landscaping and sidewalk improvements and things of that nature.
And then for Point Ruston, you mentioned utilities and lighting and the promenade walkway. Can you describe what the LID covered with respect to the promenade walkway?
It was a walkway that was required. Point Ruston is right on the water there in Commencement Bay. It was a walkway that was required as part of the design and construction of the improvements. It was part of the LID.
And do you remember how many properties were part of that LID?
Point Ruston was interesting. It was one owner, and then that has subsequently been subdivided into numerous entities.
And can you explain why you said that this one is at the top of the list with respect to the variety of improvements involved?
Well, just as I mentioned, it's typical in an LID to have a number of elements. This one obviously is challenging given the nature of the improvements in a major CBD market. So it just had as many or more elements as a lot of the other LIDs we've done.
So when you're treating all 6 components as one for for purposes of analyzing special benefits. Does that mean that properties at the northern boundary are essentially also part of their assessment includes the cost for improvements for the Pioneer Square improvements, for example?
We don't look at it that way. We just look at it where it exists in the before and where it exists in the after, assuming all of these elements are in place.
Miss Lynn, if you're done
Yep.
with the if you're done with that exhibit, you can take it off share screen.
Oh, I have a few more questions about it.
As long as you're referencing something on the page, share screen is welcome and invited. But when you stop using the document, being able to see you and the witness more enhanced is preferable.
Sure. I'll stop sharing and then I'll reshare when I'm talking about.
That would be preferred. Thank you.
Okay. So there's sorry, my last question was about and so there's nothing to preclude the use of, sorry, let me back up. When you're looking at a particular assessment, that assessment could essentially take into account benefits from all of the 6 improvements together.
Yes.
And so properties, let's say along the southern boundary, are being benefited by all 6 improvements together.
Again, the LID isn't pulled apart, so we're not looking at 6 separate LIDs. So if a property at the southern portion would be benefited to the context that it is benefited by the 6 elements.
Okay. So those 6 elements include, let's say, the Pike Pine improvements.
Well, again, the properties looked at, the LID project is looked at as one entity. So we're just simply looking at the property in its given location in the before and again in the after. And that's why a lot of properties vary in value, because they may benefit more or less than other properties depending on where they're at within the LID boundary area.
Is there anywhere in your report where one can see how you valued any of the specific components of the lid improvements, like those after that bullet list of after conditions that I showed you?
No, again, we didn't pull the LID apart into 6 elements. We looked at it as one entity.
So I'm going to reshare screens. Sorry. Okay, share. So we're still on the addenda here, and I'm going to go to page 29 of the PDF, which is actually page A26. So what is this a picture? What is this a picture of? And just to give you context, this is one of the first, I believe, this I guess is not the first one, but it's one of the renderings. What is this a picture of?
Yeah, I can't tell from the exhibit there what you're, if you're.
Oh, what is this showing?
That's showing Alaska Way.
Okay. And did you review this rendering?
Yes.
Okay. And then what is this one showing?
Yeah, again, Alaska Way.
And then going back up to A26, is this showing Alaska Way in the before condition?
Yeah, I can't see on your screen there whether that is the before condition.
Okay, right here it says the following 2 slides depict one view of Alaska Way in the east-west sections of right-of-way between Yesler and Marion in the before no lid and after lid conditions. Is that right?
Yes.
Okay, so scrolling back down. So this is the before condition, is that right? On A26?
Yes,
And this is the after condition on A27.
yes.
And you reviewed these in order to help you determine special benefits, is that right?
Yeah, they were created to help have a visual aid in appraising the property in the before and after.
And can you describe how you use these renderings?
Yeah, just for general observation to help visually see what the differences would be.
And can you describe what the difference is between these two renderings that you saw that you believe created value for the properties in the lid? And I'll just, there you go. That's the
Sure.
after.
In the after, you've got a promenade walkway and no driving area up near the Great Wheel in Pier 55, 56. You can't see it from that slide, but the Overlook Walk is in the background, and Pier 58, Waterfront Park, and other amenities to the right would be the start of the Pioneer Square improvements.
Yeah, so I do understand, and there are renderings of Overlook Walk and the Pioneer Square improvements. I'm asking just, you reviewed these renderings as well, and I'm wondering, did you see any value lift from between these two conditions? Any basis for a value lift between these two conditions?
Yes.
And what was the basis between these two?
Well, I just think aesthetically and from a market appeal basis, the after condition is an improvement to the before condition.
And why is it an improvement?
Easier pedestrian access, more trees. You can't see a lot of the running paths and things of that nature. I mean, that was the difficulty they had trying to recreate all of the amenities in an aerial like that. It's difficult to capture all of the attributes of the LID looking at this, which I would imagine this is the type of aerial you would use. But it's hard to really depict all of the elements of the promenade area looking at an area like this, but it does help as an aid. I mean, but again, it doesn't show a lot of the walkways, the bike paths, and the things of that nature that would help improve the promenade appeal.
Well, it does show some walkways right here, but those look to be the same. Is that right? And here's another one, but that also looks to be the same.
No, I was there's walking, jogging paths and whatnot that aren't shown on there. You just can't visually see them very well.
Okay. We'll go to page 34 of the PDF, which is page A31 of the addenda. So here's another rendering, and I believe now we're further north, correct, on Alaska Way?
Yes.
Okay. And this is the before on A31, and this is also the before on A31, giving some measurements. And then this is the after on A33, and then the after on A34, giving some measurements. Is that right?
Mm-hmm. Yes.
And so I have similar questions here. So I'll sort of click through those one more time. So before, after. Can you just tell me, when you reviewed this rendering, what was the basis for your belief that this particular area would contribute a value lift to properties within the lid?
Again, the vehicle access component is removed. You've got a lot of open space and walkway area that it's hard to discern by looking at this aerial and this angle. Just much greater appeal through the promenade and the artwork and other elements that will really set it apart from the before. Again, this isn't one of the better views. There's a lot of other aerials that you can look at that more clearly depict and other renderings that depict in better character what those differences are.
Okay. And I'll ask you to point me to those renderings in a moment. But if we can just, you talked a little bit about vehicle and pedestrian access. So if you look at the measurement here, it looks like pedestrian stops at about 24 feet. And then, and again, there's like 3 feet over here. In the after condition, it's 24 feet, and I guess it's third. So is that what you're talking about right here? Is this one of the bases for the benefit?
Well, more so there, in the context there too, there are bike lanes, there's jogging paths and things of that nature that aren't there in the before, that are very appealable in the marketplace.
Okay. And would you like to point me to a rendering that you feel like really helped inform your understanding of the specifics, the specific benefits that would arise from these improvements?
Well, you know, I think all of the renderings do to some context. It's just when you're looking at different elevations and different angles, it's difficult to really capture the before and after. So I think you really need to go through, you know, all of the renderings, and then there were a number of other just individual points of reference that may have not all of them gotten into the addenda that have been done over time, looking at various other elements of the project. So those would be in our files, our backup files. But we had many different renderings looking at a lot of the different components of the LID from different angles and whatnot that assisted us in our analysis.
Okay, I'm going to stop sharing. Fortunately, we don't have time to go through every rendering in the addenda right now. So we'll move on. We're going to switch topics a little bit. Typically, when you're conducting an appraisal based on a hypothetical condition, do you explain the difference between the current condition and the hypothetical condition?
Well, in this case, we do. I mean, we recognize that the viaduct's removed and that the Alaska Way is built. It's summarized in the addenda there as well.
And then do you explain how that difference produces a difference in valuation between, let's say, the current and the before?
When you say the current, for us, in this context, the scope of our analysis was to do the before analysis. So we did the before analysis based on the hypothetical conditions that were set forth in the scope of services for us to consider. We did not do we didn't do a current value and then do a before hypothetical value. That wasn't the scope of the services of what we were doing.
So it's correct that your report states that you did not consider any enhancement from removal of the viaduct as part of the special benefit, correct?
Both in the before and after the viaduct was removed, yes.
And you also didn't consider any enhancement from the before street improvements that would have had to occur without the lid, correct?
We assumed that Alaska Way was rebuilt in the before condition, yes.
Okay, so can we actually go through some of those before street improvements? You talked about Alaska Way. So one of them is the new Alaskan Elliott Way surface street. What is that? Can you describe that?
The new Elliott Way.
Mm-hmm.
Yeah,
Yes.
So the street that'll extend off up into Belltown from the current Alaska Way.
And then the next one is a new and improved seawall. Can you explain what that one is?
Well, the seawall construction was already largely completed or completed in the before condition. So we'd assume that it would be done both in the before and the after.
And then another one is the State Route 99 tunnel. Can you describe that one?
Yes, that's obviously the tunnel that was done under 99 that was completed to start this project.
And then the Pier 62 rebuild. Can you explain that one?
The Pier 62 rebuild would be an upgrade to the existing structure.
And that's forthcoming?
Yes, it's planned.
Okay. And then, right. And the Bell Street improvements, can you explain that one?
The Bell Street improvements were some elements up where Elliott Way meets Bell Street up in Belltown. The enhanced landscaping, streetscapes, I think, type of elements.
Okay. And then there's these parking spaces that WashDOT planned fronting the piers of Pike and Madison. Is that right? As part of the before improvements?
Well, correct.
Okay. And as a shorthand, I'll just be referring to all of these together as either before improvements or WashDOT improvements going forward.
Okay.
So these are all improvements assumed to be complete in the before scenario, correct?
Yes.
Is there any market value enhancement from viaduct removal and the WashDOT improvements included in the before value?
Again, our before value is just looking at how the market would buy and sell property, how it would rent property from an income standpoint in the before condition, assuming the viaduct's gone. So the viaduct's already gone in our analysis.
Do you agree that the viaduct removal and the WashDOT improvements have some estimable market value contribution to each of the parcels?
If we were to have been asked as part of the scope of our services to estimate the value before and after the viaduct removal, then yes, there would have been enhancement to the viaduct removal.
And there's some enhancement due also to the WashDOT improvements. Is that
Yes.
right?
Having the new road rebuild is a positive amenity.
So can I infer that you used some way to account for the increase in value due to the viaduct removal and the WashDOT improvements across the lid in order to come to your before values?
That was the basis for our before value, that the viaduct was removed and the Alaska Way was rebuilt.
And is there anywhere in the report where I can see where you went from current values to the before values, accounting for this increase in value due to the viaduct removal and the WashDOT improvements?
No, as I previously stated, that wasn't the scope of our services. We didn't do two independent values in the before. We just did what we were hired to do, which was just value the property, assuming the viaduct's gone and Alaska Way was rebuilt.
Do you believe that the before value for each parcel is actually higher than actual current values as of October 2019 due to the hypothetical completion of the WashDOT improvements and the removal of the viaduct?
Well, as of October 1st, under the conditions that we're looking at, if the viaduct were still there, which again isn't part of what we looked at, there would be some impact to the property. That's just not something we considered. With the viaduct was gone, what would the market sell for? What would the market rent for? As you do an analysis of the after, what are the benefits of these LID improvements?
And that impact is that before values are greater than the current values.
Well, we didn't estimate the current value. Again, if that was a separate scope of services and we were looking at it, certainly if you take a view amenity like that and were to do a before and after in that context, there would be a change in value, certainly under that scope of services. We're looking at it just in the before condition as the assignment required us to do.
So you testified in your direct testimony regarding Brian O'Connor's conclusion that ABS valuations before value for harbor steps was overstated by 88 million. That's what Brian O'Connor believed. And you suggested that this could be because Mr. O'Connor was looking at current income and numbers, whereas ABS was accounting for removal of the viaduct and the WashDOT improvements. Do you remember that?
Yes. Yeah, so our rent, I don't know, he provided no market evidence to support what he's saying. He's just doing an appraisal review, but I don't know what I was saying is I don't know what their current income is and whether it's accounted for the viaduct being removed or not.
So in your analysis, how much value did the WashDOT improvements and removal of the viaduct add to that property's value, if not 88 million?
Well, again, it was just done on a parcel by parcel basis. We didn't, we just looked at what we felt rent would be and what sales would be under that context. We didn't look at a before and after type of context.
Right. And in that parcel part, I'm actually asking specifically only about that parcel. So in that parcel, the Harbor Steps property, how much value did the washout improvements and the removal of the viaduct add to that property's current value, if not 88 million?
Well, I don't know. I mean, all I'm saying is that I don't know what his income inferred. And so he's saying I'm wrong. And I don't, he doesn't even provide any evidence to prove that. But I'm saying that our valuation was looking at it under a different condition, perhaps, than what the income that he has or is comparing to considers. So.
Do you not know because you don't remember, or do you not know because that analysis does not exist?
Well, I didn't do a current before and after value of the viaduct gone. That wasn't the scope of my services.
So sticking with the Harbor Steps property, you also testified in your direct testimony that that property being about 4 to 5 blocks from the Overlook Walk would provide some connectivity benefit to this property. Do you recall that?
Yes.
Okay. So what exactly is the additional benefit from connectivity above and beyond this property's existing access to the waterfront via the Harbor Steps?
Well, if you were just down on the waterfront, you'd have the additional connectivity of the Union Street connector. The property does have good connectivity to the waterfront now, but also the promenade will provide a good connectivity point, easier pedestrian access just throughout the waterfront area.
Did you value this existing connection, this harbor, the actual Harbor Steps? How was that existing connection valued in the before condition as compared with the after condition?
Well, again, each property is looked at individually, and we value the property in the before, and then looking at how an investor would look at it in the after, having a $346 million improvement project fairly close in proximity to it with different connectivity points, easier pedestrian access up and down the waterfront, somewhat close proximity to the Overlook Walk and really unique amenities. We looked at again at the property, assuming all those amenities were done, and made an estimate of value with that in place.
Okay. So in this property, as you've emphasized, it's a parcel by parcel approach. Did you assess whether Harbor Steps would increase their rents because tenants would have a second alternative waterfront access several blocks to the north?
Well, it was one of the elements we would have looked at in the context of the six elements. If they had a little bit better connectivity, just more desirability in the marketplace, better market appeal from an investment standpoint to an investor with, again, this type of improvements done in the after. So we looked at any relative market-based consideration that would have been given by an investor, by a buyer or seller in the marketplace in the after.
Did you consider whether it's potentially a disamenity that Overlook Walk and the other points of connection might draw people away from Harbor Steps retail?
No, I think the whole flow of more people coming into the waterfront will be the opposite, that it'll help retail components like that.
And where is this analysis, this specific connectivity analysis with respect to the Harbor Steps in your report?
Well, again, we looked at each property individually and prepared a worksheet. So we don't prepare individual appraisal reports where we go into an extensive written summary of all these factors. It's just not cost effective to do that in the context of a mass appraisal assignment.
So the worksheets do explain the basis for your belief that connectivity will increase the value of Harbor Steps property?
Activity is one of the components that I think the market would look at. The market's going to look at just general market appeal, similar to other studies we looked at in other markets. Investors look at the long term and just their general investment decision would consider it to be an improvement from the before condition.
Examiner Vansel, we're at 10:05. I just want to be mindful of the time. Would you like to take a break, or?
I'll
Would you
let
like
you
me
know
to
when we're
continue?
ready to take a break. You don't necessarily need to ever stop for that. So just keep that in mind, everyone else, when you're asking. You don't need to ask me. Since you have stopped and asked, then we will take a break now. But I'm keeping track of it. So we'll take a break and return at 10:20. 15-minute break. Thank you. We'll return to the record with Mr. McCauley on cross.
Okay, so just picking up where we left off. So you did not do any analysis to determine the effect on value of properties in the lid specifically due to removal of the viaduct. Is that right?
Correct. Yeah, we did no before and after analysis of the viaduct removal.
And there's no separate analysis of any value lift due to the projects assumed completed in the before condition.
The assumed completed in the before condition is just the basis for which we value the property in the before condition.
But there's no separate analysis of the value lift due to those before projects.
It wasn't the scope of our services.
Have you or anyone on your team reviewed any designs or plans of the before improvements?
Well, the before condition improvements are outlined in the addenda and summarized in the report.
Okay, and so those are the designs and plans that you reviewed?
Yes.
So you didn't do any of these a separate analysis of the effect of the viaduct or the before improvements. And this is the case even though your before values are not current market values. They are current market values as of October 2019 plus the value of the washed-out improvements and removal of the viaduct. Is that right?
That defines the before condition, yes.
Okay. Why didn't you just use current values for your before conditions so that you could just use market data, and then you could have made the after condition the lid improvements minus the washed out improvements?
Wasn't the scope of our services, and that's not how we've ever done anything. We do it the way it's outlined in our scope of services.
Wouldn't that be more consistent with your approach with the other lids where you've got an actual in either the before or the after, and then a hypothetical condition in the after, let's say?
No, I mean each project we do is different, and the scope of services is different. So we're just simply complying with the client's request, no matter whatever the context of the assignment is.
If you had used a current values and as your before value, and then the lid improvements minus the washed out improvements for your after values, do you have any sense of what that percentage would have been?
No, that's not something we did.
You testified that one of the differences between a direct appraisal and a mass appraisal is that the level of detail in a direct appraisal is typically greater. Is that right?
There's more verbiage, more discussion of your analysis, things of that nature.
And you explained that a parcel by parcel direct appraisal would not have been economically feasible here, right?
Well, most clients probably would have looked at it that way. That's just my thought process. I mean, most LIDs we do, or all LIDs we do, have been done on a mass appraisal basis, and one of the reasons for that is that it's very time consuming to do individual reports on each property, and it would be considerably more expensive.
Is it more time consuming because the process for a direct appraisal is more in depth?
It's not necessarily, well, the same amount of thought process would go into it. It's just that you have to write it out in the context of a report. And typically in a LID, it's done through oral examination, cross-examination, if property owners have questions.
So for a mass appraisal, do you typically have the same level of data and information regarding a single property that you would have if you were doing a single property appraisal for that particular property?
Sometimes not. In this case, property owners had the ability to provide us any information they wanted us to consider, and we would have considered it. If not, we base it on the best market information available. But typically, when you're hired by a specific property owner, you're going to get more detail. They'll give you their income analysis or their current rent and expenses and things of that nature. And in this context, a lot of the properties didn't have that, so we have to use more market standard based approach.
And as between income information from a property owner who's asked you to do a direct appraisal and market data, which one of those would typically result in a more accurate market valuation?
Well, if we had actual information from the property owner, it's helpful. Obviously, again, it depends on the assumptions of the analysis you're making, both in the before and after in this case. But it would certainly be helpful.
And so, for example, also with a direct appraisal, you might do an interior inspection, but you didn't do that for all of the properties in the lid. Is that right?
That's correct. Just an exterior inspection. Although I've been in a number of the properties over the years, especially
Sorry, continue.
Go ahead.
And similarly for residential condos, if you were doing a direct appraisal, you might actually go view the individual condo unit, but here you didn't visit any individual condo units. Is that right?
That's correct. We based our information on the King County Assessor's records.
And you've testified that for certain properties, you didn't actually have all of the relevant information that would allow you to make an accurate valuation. So for example, with United Way and Century Square Retail, both of which have development restrictions. Is that right?
Yeah, we had a list. I thought we had all of the properties that had sold their development rights. Those two we either missed or we didn't catch in our research that it sold their development rights. So we would need to correct our benefit estimate for those properties.
We also presented evidence that for the Helios apartment complex, and that's property E-044-001, you used the incorrect distribution of unit types, which resulted in an undercount of studios. And because studios tend to rent for a lower rate, your analysis overcounted the more expensive, larger units. If this is true, should your before valuation and should your special benefit analysis change for that property as well?
If that's factual information, been provided nothing to support that what you just said. But if that's factual information, then yes, we should go back and look at it if it's factual.
And have you reviewed John Gordon's analysis regarding hotels?
Yes, I read through his reports.
Okay. And so you're aware that the average room rate information you use for hotels varies from actual room rates. Is that right?
That's what he reports.
Okay. And he had access to actual room rate information. Are you aware that he had access to actual room rate information?
That's what he's indicated, yes.
Any reason to doubt that he did?
Other than I haven't seen it.
And his use of actual room rate information led to before values that were significantly less, sorry, your use of that were significantly let me rephrase this. His use of actual room rate information led to before values that were significantly less than what you concluded. Is that right?
Typically, that appears to be the case, yes.
Okay. I'm actually going to switch gears a little bit right now and pull up Exhibit 130. And this one was sent out later in the evening last night, so I will go ahead and share it if that would be helpful.
That would be helpful.
Okay. Okay. So this is Exhibit 130. Is this a typical assessment notice?
They vary. It's not something I typically get involved with.
Does it appear to be an assessment notice related to the waterfront lid?
Yes.
Okay. And are you aware that the state statutes require notice of the assessment roll hearing to be sent to each property owner, quote, for each item of property described?
I'm not aware of what you're referring to.
I'm referring just to a, oh, sorry.
My understanding
Go
is
ahead.
that each under the state law that each tax account number needs to have a special benefit and therefore an assessment amount.
Okay. It needs to have notice of that assessment amount as well?
I believe so, yes.
Okay. And on the third page of this document, there's a box that says waterfront lid number 6751, proposed final assessment. And this is the proposed final assessment for the identified King County parcel identification number. Is that right?
Yes.
And then the first sentence after the box says, as shown on the tax rolls of the King County Treasurer, you are the owner or reputed owner of the described lot, tract, or parcel of land listed above and located in the city of Seattle, Washington. Your proposed final assessment is the amount of the cost and expense of the waterfront lid improvements to be borne by and assessed against your property listed above. The assessment notices are against specific parcels of real property carrying a specific King County parcel number. Is that right?
Yeah, correct. As I said, under state statutes and all the LIDs I've done over the years, that each property that has a tax account number needs to have a special benefit and assessment amount.
Do most businesses have a separate parcel number for personal property, like IT and like I'm talking right now about commercial properties?
Well, business value or personal property value in the context of that nature, if it's not part of what we would typically value for the real estate, would just be considered within the tax count number.
Does this notice include notice of personal property being assessed?
I don't know. I don't know what property you're referring to.
Well, I'll point you right now to, first of all, this language that says the described lot, tract, or parcel of land. And just so you know, this is the Seattle Marriott.
Okay.
So I'll ask the question again. So in case you have a different answer, does this notice include notice of personal property being assessed?
The only information the city was relative to our special benefit estimates that would reflect the fee simple interest and how the market buys and sells property. We did not send out any other information on any other thing other than what was in the King County Assessor's records, identifying the particular property, and that consisted of the real property of that particular property.
Okay. Sorry, put another way, does that mean that ABS valuation valued the land and real estate improvements for purposes of determining special benefits for this parcel?
Based on the King County information, yes.
Okay. So I've got to redo my screens. And so for the Marriott and for the rest of the hotels, ABS valuation was not including personal property. Is that right?
Well, they typically buy and sell in the marketplace with their furnitures, fixtures, and equipment. So it was both in the before and after that would have been considered in our analysis. In our sales sheet, when we had the information available, we separated out the personal property from the real property. But oftentimes, certain properties function differently than others, and that's just a market norm with hotels.
So when you say it was considered in your analysis, does that mean you separated out personal property and did not include it in your before value? Or you separated out personal property and also included it in your before value?
Because hotels typically sell with personal property included, it was considered in our analysis. So the sale price and how the market functions typically includes the personal property, and so that was we're just reflecting the market, and that was included in our analysis, both in the before and after.
And this was the case even though the notices of assessment did not specify that personal property would be assessed. Is that right?
We're looking at it as part of the fee simple interest in the context that that's how the market functions. So any personal property would have been included in our tax account number that was provided to the city for purpose of mailing out notices.
So your final study states, and you've explained, that an extraordinary assumption is something that, if false, could alter your opinion of actual market value. Is that right?
Yes.
And then you testified in your direct testimony that an extraordinary assumption here is that the before and after projects are complete as of October 2019.
That's correct.
But this is false, correct? Because the before and after projects are not complete as of October 2019.
Well, it's based on a hypothetical condition that they're completed. So it's just standard practice to report to the reader that I think in this context that if some elements of the project were not to be included or were never done or whatnot, that would alter our opinion. The basis of our analysis is done on a hypothetical condition.
So is that a hypothetical condition or an extraordinary assumption?
They're kind of interchangeable, but it's an assumption of our analysis that's inherent in our study.
What is the difference between an extraordinary assumption and a hypothetical condition?
They're similar. I'd have to look at the definition to give you a defined answer, but they're very similar. When the hypothetical is the extraordinary deals with more from a legal nature, and I'm just drawing a blank as to define the hypothetical as I sit here.
And And this extraordinary assumption and hypothetical condition forms the basis of your entire analysis, right? The fact that both the before and the after projects are complete as of October 2019.
That's correct.
But in fact, neither of these projects are complete as of October 2019. Neither of the conditions, sorry.
That's correct. We're assuming they are for purposes of our analysis.
And so by assuming that the hypothetical before and after projects are all complete as of October 2019, you don't have to consider a number of development impacts and issues and risks, right?
We would assume they would be completed and those elements would have been taken care of. They would have been approved.
So for example, you don't have to consider project delays.
Correct. We assume that the project is done as of that date and time.
And you'd assume that all project components would obtain all necessary permits without any required changes or mitigation, right?
It would be implicit in our assumption, yes.
And part of that assumption also is that the design of the lid components are not going to materially change for any other reason, right?
Yeah, when we were working on getting to the level where I felt, in my judgment, we had enough information, the analysis based on that would be the minimum that would be done. And so if they changed the project and added more, we're just looking at the bare minimum of what would be done based on those after conditions.
And for most of the projects, that bare minimum was over 30%, right?
Yes, I think the Pike Place Market, the Pioneer Square improvements and the Pike Pine corridor improvements were slightly less than 30%.
And for those slightly less than 30% design, you testified that you were able to proceed anyway because in discussions with the city, you were assured that you received some sort of assurances. Can you describe those assurances?
Well, we were assured that at a bare minimum of what was described would be constructed.
And what was described as something less than 30%.
Yes, but I felt, given review of what was done and in talking to them, that I had enough information to proceed to finalize my analysis.
Typically, do you wait for projects to reach a 30% design milestone?
It's desirable. It depends. I mean, most of the time we're doing these types of analysis. It involves the formation process and not both the before and after. Or excuse me. I mean, it doesn't typically involve the after conditions. So this is unique in that aspect.
Why didn't you if there's just two components that were almost at 30% design, why didn't you just wait for those to reach 30% design?
Just working with the city, they had some time elements. I think they wanted to get moving ahead with the project. I felt I was at a level of understanding and design that it was reasonable at that point in time to move ahead, so they could start their process, and they had provided me enough information where I was comfortable to finish the study and they could continue to move forward with the project.
So did the city's timeline have some impact on your choice of a date evaluation?
It was something that was talked about. I felt that I had sufficient information to do my work. We had looked at trying to get the study done at an earlier date and time. So this was a date and time that I felt that I had enough information to move forward, and the city then could move forward with their end of finalizing the LID assessments.
Going back to the hypothetical assumption that projects both before and after are complete as of October 2019, part of that assumption also is that budget issues will not affect the timeline or delivery of the lid improvements because they're all complete as of October 2019. Is that right?
Yes, I think that was one of the main appealing points to property owners, is that the amount of assessment was capped. So if they would have waited till 2024 to finish the project and there was a huge cost overrun, that wasn't going to be assessed against the property owners, that it took a lot of risk out of any equation for property owners to be assessed, because the city could assess up to 100% of the benefit amount. That it capped the amount of assessment, and any cost overruns wouldn't be considered.
And I'll ask you a little bit about that cap and some cost overruns, but I'll finish this, a few other questions on this topic. So another assumption that goes along with the fact that everything's complete as of October 2019, aren't going to be any major economic disruptions that affect funding or schedule for the improvements, correct?
Sorry, Ms. Lynn, could you repeat that?
Sure. Um, Another assumption that goes along with your hypothetical assumption is that there aren't going to be any major economic disruptions that might affect the funding or schedule for the improvements. Is that right?
That would be correct. We would assume that the project's done, both in the after situation, the project would be done.
Right. And then going back to your testimony and your final study states that if extraordinary assumptions are false, they could alter your opinion of actual market value. So if any of these assumptions prove incorrect, would your opinion of market value need to be revised for
Yes,
any of the parcels?
yes, very well could. I mean, if one of the elements wasn't completed, then as I've stated, the city would need to readjust their estimates of benefit.
And that would also change your analysis of special benefit?
Yes, most likely, yes.
So turning to hypothetical conditions, which you said is also, which you've explained, there's some overlap in that you have the same hypothetical condition here, which is that the before and after projects are complete as of October 2019. In your final study, it says that a hypothetical condition is that which is contrary to what exists. Is that your understanding?
Yes.
Okay. So in fact, there are no lid projects that are in fact complete.
Correct.
If the lid improvements are not built, do you know which of the washed out before improvement, sorry, if the lid improvements are built, do you know which of the washed out before improvements will not be built? Because there is some overlap, right? Some of the before improvements are going to be constructed no matter what. And so I'm wondering which of the ones are, which of the washed out before improvements do not occur if the lid improvements are built?
Well, I just looked at it in the before that Alaska Way, Elliott Way, and the railroad walk from South King to Century Link Field area there would be constructed both before and after the LID. So
I see. Okay. Okay, but again, none of the projects are actually complete right now. So is any property owner in fact receiving any special benefits right now?
well, the LID has been formed, so there could be some anticipation in sales out there in the market that they're aware of the LID improvements. They may have factored into their purchase decision if they bought the property near or after the LID formation.
But tourists are not coming in larger numbers in anticipation of the lid improvements, is that right?
As of the valuation date?
Correct.
Well, again, we're assuming that it's done, so it would have some influence on the tourism market.
Right, but I'm asking you right now in reality, putting aside assumptions, are tourists coming in larger numbers due to that anticipated lid improvements to be delivered in 2024?
Not right now, no.
And are hotels charging higher rates because of those anticipated lit improvements in
Well, I mean,
2024?
again, it's irrelevant to my analysis because I'm assuming the project completed as of October 1,
I
2000.
understand. I'm asking you to set aside the hypothetical assumption for a moment here.
If you
Are,
if you set aside the hypothetical conditions, then the market is where it's at. The LID has been formed, and the waterfront is as it currently exists. And so whatever the market would bear in that condition, that's what the market would reflect.
and as an appraiser in the Seattle market, have you seen any increases due to anticipated lit improvements in 2024 in either rents or hotel rates or property value sales, in anticipation of the lit improvements in 2024?
Well, again, I am valuing those project elements as of a different date and time and not 2024. So I can't answer that because we're not in 2024 yet.
Oh, no, I'm asking currently, as an appraiser who works in the Seattle market currently, have you seen any property value increases in rent, things like that, in anticipation of improvements to be delivered in 2024?
Yeah, I think some of the sales, like the Maritime building sale, sold for an extremely high price, right down on Alaska Way. It was purchased in confirmation of the sale. They recognized the potential benefits of the LID, and it factored into their purchase decision. That sale comes to mind. And some of the as we were doing our study, some of the viaduct was coming down, so you had some elements of that, where maybe some rents were being adjusted for that. But because the improvements weren't constructed yet, that the market's not going to fully reflect that in their decisions at that time. So that's why we do what we do when we're appraising it as of a date and time. We have to make estimates for how the market would react as of a given date and time.
And so the market isn't fully realizing the special benefits that will accrue to properties when the lid is actually delivered, correct?
If you're examining the market's behavior in the before condition, that there are some elements of the viaduct removal and whatnot that would be indicative of some higher rents or that type of thing. But that's again, we're making estimates based on a given time, based on certain conditions. So if you're looking at today and taking off the hypothetical conditions, yeah, there's the market is what it is, but that wasn't part of the scope of our assignment.
Are appraisers capable of discounting benefit if it's not going to be received immediately? This is a general question.
In 30 years, we've never been asked to do some sort of future value for an LID.
Oh, I'm not asking for a future value. I'm asking if you're capable of discounting the future benefit if it's not going to be received immediately.
Well, technically, I guess you could try to do that. Again, that's why you set a specific date and value, so you can measure as best as possible what the market's reaction is going to be to the before and after conditions at that time.
And I'll just give you an example. For example, a lending appraisal might consider discounts to account for future proposed improvements. Is that right?
That may be a scope of assignment you would get from a financial institution that you would consider.
Is it reasonable appraisal practice to consider and discount the value of a future condition not in place at the date of value?
Again, it would depend on the scope of assignment. If that's what somebody asked you to do, and you had the capability to do so, then you would undertake that assignment based on those assumptions.
Okay. Relatedly, do commercial appraisers discount a future benefit if it's not going to be received immediately, simply to account for the time value of money?
Again, given a specific assignment and a specific request from the client, you can do that certainly. Like in a subdivision, you're looking at a number of lots and what the gross allowed time is, and if there is a time element involved, you may discount it back to a present value. But that was not the scope of the assignment for this project.
Okay, so let's turn to this assignment then. You testified that the difference between your treatment of recently developed apartments, for example, and vacant land slated for development was that no labor, capital, or risks associated with the development had gone into the vacant site yet, and therefore the vacant land is not valued as highly and received a smaller assessment. Do you recall that?
Well, the vacant land's valued proportionately, like an adjacent property would be that's improved, because because we're valuing it as of a specific date and time. We can't assume it's constructed. We don't know what's going to happen 4 years down the road. We're asked to look at current market value as of a specific date and time. So that's what we did.
And you specifically explained, though, that the reason for some differences between similarly situated vacant sites slated for development and already developed sites with apartment complexes on them was that the labor, capital, and risks associated with development had not yet been borne for those vacant sites. Do you
Yes.
recall saying that?
Yes, because we're valuing it as of a specific date and time.
Okay.
And then
So just taking that concept, would that concept be true for the lit improvements? The fact that the labor, capital, and risks associated with development have not yet been borne makes these improvements less valuable currently.
No. Again, it just gets back to our assumptions and what we've been asked to do. The client specifically asked us to do evaluation of a certain date under certain conditions, and we did that. So we're just reflecting the market and not discounting it.
Okay, so I'm going to ask you to set aside that assumption for one moment and just answer the question as if that assumption did not. And I understand that that is not the scope of your assignment. But my question is, setting aside that assumption, does the fact that the labor, capital, and risks associated with development have not yet been borne make these lit improvements less valuable currently, setting aside all hypothetical assumptions? And I know that I'm asking you a hypothetical because I'm now in a world that does apparently not exist to you, but that's the question.
If you could rephrase that, I'm
Sure.
so.
Hypothetically, if the hypothetical assumptions do not exist, does the fact that the labor, capital, and risks associated with development have not yet been borne make these lit improvements less valuable currently?
So if we're valuing the property in the after, and we're assuming that the LID improvements aren't built in the after condition,
You're assuming that they're going to be built in 2024, and you're trying to figure out what the value is currently.
well, if that was, again, if the client asked us to as a scope of services to look at it that way, then we could do that. And yes, you'd most likely be like a subdivision, depending on the market's perception, you'd be discounting it back to a present value.
So as another example, you talked about the 2&U property in your direct examination, and you noted in your testimony that the final special benefit for the 2&U property was over 5 times greater than the preliminary estimate, because at the time of the preliminary estimate, the property was under construction. Is that right?
Well, I don't know if it was 5 times greater. I don't remember saying that. It was the the amount of benefit from the formation to the final was higher.
Okay, so it was higher between preliminary and final, and it was because the property was under construction at the time of the preliminary assessment.
Correct.
Construction of most of the lit improvements had not commenced as of October 2019. Is that right?
Yes.
Okay, I'm going to switch gears a little bit. You've previously testified that you did not do any independent due diligence to determine the reliability of the city's estimates for completion of the waterfront lit improvements, and that you relied on the city's information for that relative to the completion and design elements. Is that right?
Yes. The scope and purpose of the assignment was to assume that those factors have been completed and were taken into account in our analysis.
Okay, so you didn't do any independent due diligence to ensure that proposed designs or cost estimates or construction schedules you relied on were not going to materially change.
It wasn't the scope of our assignment, so we weren't asked to do that. We just made an assumption that the project was completed as of a specific date and time.
And that assumption also resulted in the fact that you didn't consider the risk that design changes or even cancellation of project elements could be imposed as part of environmental review or the permitting process.
And that was not part of the scope of our study.
Are there in fact any uncertainties related to delivery of the lit improvements in 2024?
I don't know. I'm not involved in that aspect of the project.
You testified in your deposition that, and you've testified here as well, that it would be difficult to conduct an appraisal now to value a property in 2024 because you couldn't possibly know what the market and property conditions will be like in 2024. Do you recall that?
Yes.
And so inherent in the delay, there is some uncertainty related to valuing property, valuing the future delivery of property. Is that right?
Well, all I'm saying is that I can't read the future. I mean, when I was doing my analysis in October 2019, who would have thought that this COVID issue would happen? I think when I was being deposed, I think your thought process was that the market was going to continue to go up, and so you know, the markets go through cycles, and you know, we're capturing market's perception as of a given date and time, as we were asked to do as part of the scope of our services.
Okay, so talking about COVID a second, would you agree that current market conditions have changed due to COVID?
They may have, and they may not. I mean, you know, you look at the King County housing market, and it's remained stable. You look at how the stock market's increased. I haven't been asked to do any appraisal work downtown, but you know, the market seems to be looking at it on a pretty short-term basis. So I don't know if I was asked to do an appraisal today, whether I would see a change or not. You know, the exposure period that investors are looking at may have been extended due to this COVID issue, but it may not have affected the market much, if at all.
Are you aware of John Gordon's testimony that hotel values may have dropped by up to 15%?
I've heard him say that they thought they would be less. I don't recall the specific percentage.
Do you have any reason to doubt his opinion that hotel values have dropped due to COVID?
Well, I don't know what he's basing on. I mean, if you're looking at a willing buyer and willing seller, why would a hotel knowledgeable, well-informed owner investor sell in a depressed market or it's not you're not valuing a panic price or a distress price. So, you know, I haven't valued any of the hotels recently. My valuation was October 2019. So I don't know what Gordon's basing his thought process on.
And just speaking about willing buyer, willing seller, do you have an opinion on whether COVID has affected investor sentiment positively or negatively?
Well, I think it's probably changed their outlook again on how long this is going to continue. So their exposure period is probably longer. Again, I haven't done any appraisal work in conjunction with this COVID issue to say. I really haven't looked at the market that way to know.
If actual completion of the lid improvements does not occur according to designs you were provided, and not until after 2024, would that impact your analysis of special benefits?
Well, again, I mean, that question is kind of irrelevant because I'm looking at the property as of a specific date and time, and that at least at a minimal, the plans and the design elements that I've been given have been completed at a minimum. So that's how I value the property.
Is the fact that you do not discount for present value and you do not discount for permitting, construction, and economic risk, do those facts increase your estimated special benefit estimate, the fact that there are no discounts?
I'm just looking at the market would react as of a given date and time. I'm considering the project's done. So any construction delays or anything like that are irrelevant to my analysis. It's done just as a specific date and time, assuming the project's been completed.
And speaking about construction disruptions, you've testified that you did not discount any of the lid benefits due to construction disruptions and time lag, and you base this on an analogy to eminent domain practices. Do you recall that?
Yes, I believe in eminent domain that it's the construction aspect of a project isn't compensable when you're doing right-of-way appraisal.
Okay, so let's talk a little bit about eminent domain. In eminent domain cases, sometimes there's a special benefit analysis if property is partially condemned for a public improvement project and the remainder benefits from the improvement. Is that right?
That can happen, yes.
Okay, and are you aware of these sorts of situations?
They're pretty rare. I haven't done a lot of right-of-way work. I don't know if I've ever encountered it. There have been a couple large right-of-way projects that were done, but they formed LIDs to estimate that factor because it was clear that the properties were going to benefit. So they did a separate benefit study to reflect that. And so the appraisers that were doing the right-of-way, the before and after right-of-way appraisals weren't considering. They were instructed not to consider the special benefit element, and that was done separately.
Okay. So it sounds like you don't have a lot of experience with the special benefits in the context of eminent domain, but you're aware that this can occur.
Yes.
Is that right? Okay.
Yes.
So we're going to turn to Exhibit 118.
Are you going to put that on your screen, Ms. Lynn?
Would you like me to share screen?
Yeah, if you could, please. Yeah, it's just easier for me.
Okay, this is Exhibit 118, and it is an excerpt from Nichols on eminent domain, which is a treatise. Are you familiar with the Nichols treatise?
No.
Okay, well, that's all right. This chapter regards something we've been just talking about, which is when a property is partially condemned for a public improvement project and the remainder benefits from the improvement. And I've highlighted here um, this sentence: the special benefit increases the market value of the remaining land. Is that consistent with how special benefits are defined in the LID context? That is, as an increase in fair market value as a result of the improvement?
Yes, if it's the difference in fair market value before and after the improvements are completed, and if there's a measurable difference, then that is special benefit.
Okay. So moving down here, a special benefit must be conferred by the condemner, result in a permanent increase in market value, and be capable of monetary measurement. So consistent with what you just said, it's got to be actual, it's got to be measurable, it's got to be an increase in fair market value due to the improvement. Is this consistent with how special benefits are treated in the LID context?
Yeah, more or less.
Okay. And then scrolling down, this is talking about condemner must establish all the following to lay the predicate for a claim of special benefit. And 9 says that benefits are not, I'll make this a little bigger, that benefits are not speculative or remote, and that prospective benefits cannot be considered if they constitute only future possibility and do not enhance the present value of the property allegedly benefited, but they may be considered if it is sufficiently certain that they will be realized. And 10, that the benefits are special rather than general. Are these also consistent with, do you agree that these principles are also relevant in the context of a LID?
Well, the context of a local improvement district is different than eminent domain, and we have certain state statutes that we base our benefits on. So the definition of a special benefit is being measurable before and after, in my case, a local improvement district, specifically a local improvement district funded element is what I'm looking at. So I'm not looking at a special benefit in relation to a condemnation issue.
I understand. I'm wondering if there are overlapping principles. And it seems like in
Yeah,
this,
yes, there would be some as I've read this, I mean, there would be some overlapping terminology, yes.
and so do you agree that estimated special benefits must be actual and measurable
Yes,
and non-speculative?
yes.
Are you aware that state statute provides property owners the opportunity to elect a bifurcated proceeding in the eminent domain context, under which valuation of special benefits is separately determined after construction of the improvements, and that the purpose is to avoid speculative special benefit offsets that are unfair to the owner?
I'm not aware, and I'm not an eminent domain expert.
Would you agree that that type of process, that is valuing the special benefits after construction of the improvements, would tend to make the estimate of special benefits less speculative?
Ms. Lynn, again, getting back to the context of what I did is all I'm concerned with in this case. I'm not concerned with eminent domain cases or any other issues like that. You know, the LID law is different than eminent domain law, and it's got a long history, and that's what I follow. So yes, is there similar verbiage between the two? Yes. For me, that's where it stops. I mean, I don't follow eminent domain law in doing my local improvement district special benefit studies.
However, it is true that you did borrow from eminent domain principles when deciding not to consider the interim disruption from construction. Isn't that right?
I don't know if I borrowed from anything. It's just an assumption that was made and asked to me by the client to perform an appraisal of the before and after based on certain conditions.
And when you explained it to us in direct testimony and in your deposition, you explained it because as you explained one of the bases for your non-consideration of construction impacts was, for example, because in eminent domain, those sorts of impacts are non-compensable. Is that right?
Yeah, it was just, I mean, just an example. It's just not something in an LID that we consider. We assume that the project's completed, so construction noise and things of that nature just aren't part of the property rights or the anything that we're appraising. I mean, it's as simple as that.
So you've heard testimony from our experts that for direct appraisals, it's generally accepted that it's reasonable for two appraisers with access to similar data and information valuing the same piece of property to arrive at values that are 5% off. Are you aware of this testimony?
Yes,
Would it be reason? Have you done direct appraisals?
certainly yes.
Okay. Would you agree with this statement?
Well, I've been in situations where we're almost identical in appraised value, where one's lower, one's higher, where there's significant difference. I mean, an appraisal is an estimate of value; it's an opinion, and the old saying, "Everybody's got an opinion." But I mean, ours is based on our experience and our judgment. And I have a considerable amount of that when it comes to doing LIDs. I've been doing these for over 30 years.
So given the same quality of data and information, right now we're just talking about direct appraisals. Given the same quality of information data, would it be reasonable to be 50% off?
It would just depend on how an individual appraiser was looking at the market, how they were looking at the data.
So if two appraisers,
You could be the same, you could be slightly higher, slightly lower than another appraiser. And there's no set norm or margin of error that you may encounter in the market. I mean, it's based on each individual appraiser's opinion, given the data that they're looking at and how they perceive the data in the market. So again, you could be the same, higher or lower. And to what extent, it would just depend on the property and the data and the scope of the services and the menagerie of things.
so let's pretend that the scope of services is the same for two direct appraisals and both appraisers are experienced and have access to similar quality of data, and they come up with values that are 50% off. Would you want to understand the reason for that inconsistency?
If I was asked to, it was part of my assignment to ask them why they were that much higher or lower, then yeah, certainly I would try to find out.
Typically, if that occurred, would there be an attempt to reconcile those appraisals, perhaps through a reappraisal?
Again, that would just depend on the scope of services, who the client is, what you were asked to do.
Do the appraisal standards and process provide for any certainty and uniformity in assessing property values?
Well, there's no standard of margin of error or anything like that, or any in an LID, I often derive very, very low benefits when I'm getting out towards the edge of a boundary, and very much higher benefits closer to project elements. And so there's no like standard of margin error in that. I don't know of any standard in USPAP as far as the margin of error goes.
So in a direct appraisal, it would be reasonable for two appraisers to be 50% off.
I don't know if it'd be
in your
reasonable.
opinion,
I don't
given
know
the
if it'd be
same scope of
reasonable or not.
service.
Again, it would depend on the scope of services and the type of property you're appraising, and if one appraiser was that much higher than another, then perhaps they're considering different elements. I don't know. That's just an unanswerable question.
If that happened to you, let's pretend you were doing a direct appraisal of a property, and you were asked to do a direct appraisal of a hotel downtown, and you found out John Gordon was also doing a direct appraisal, and you were both given the same assignment. They just want to get a fair market value estimate of their hotel, and you found out that your valuation was 50% off from Mr. Gordon's. Would you want to figure out the reason for that inconsistency?
If I was asked to, sure.
How about this? Given the same information and the same scope of services, would you expect another experienced appraiser to come up with similar special benefit amounts that you did for the lit improvements?
Again, it would just depend on how they were perceiving the market. They may perceive it differently than me. There are a lot of variables in an assignment like this. So again, it would just depend on the individual appraiser and how they're viewing the market at that time.
Let's pretend that they're given all of the same information that you were given, and they came up with special benefit estimates that were 5 times as high as yours. Would that be, do you think that would be reasonable and consistent with a mass appraisal approach?
Again, I mean, I can't read people's minds or what they're going to be, how they're going to be utilizing the data or how they're perceiving the market. So it would just depend on the circumstances at the time.
So is there any standard of deviation before you believe reconciliation should occur?
Well, again, it's up to the client. If somebody's vastly different opinion than me, if the the client wants it reconciled, then you can go in that route. Again, it's just assignment specific.
So this is up to the client. It has nothing to do with USPAP standards.
No, I mean, I think if I do an appraisal and I've got a client and I've got specific assumptions and basis for doing it, that's my appraisal. If another client hires the same appraiser to do the same property and they come up with a different value estimate, then that is what it is. And if I'm asked to review what they did and look at what they did, and then I would do that. If I'm not, then I wouldn't.
So you have not tried to assess or determine the margin of error in your report?
Margin of error from what?
And I'm talking about how about this? What have you done to assess the relative accuracy of your individual conclusions?
We do a lot of internal review to make sure that we're proportionate in how we're applying how our benefit estimates are derived, and that similarly situated properties are roughly proportionate to each other. So we do a lot of internal review before we finalize the report to make sure that we're being as fair and honest and proportionate as we can between properties.
And what did that internal review look like exactly? And it'd be helpful if you could just walk me through what it would look like for one particular property.
Well, for instance, in this case, we've got a number of different appraisers working on different elements of the project. So, towards the end of the assignment, we all just sit down for hours on end and go through each property and talk about the different elements that we're considering for that property before and after, given the scope of our assignment, and just work through and make any appropriate changes if they're needed, so that we're being as consistent as possible and roughly proportionate as possible.
And when you say appropriate changes, did you recalibrate any individual before or after conclusions after your initial work was done?
Not after the initial work was done, but that's part of the internal review process, is to do that before you finalize your analysis, so that you looked at everything and considered everything within a reasonable basis, and then at that time finalize your report.
And so I guess, were there any of these sessions where you've sat down with the rest of your team and you've had to recalibrate individual conclusions?
Oh, sure. Yeah. When you're going through the internal review process before you're finalizing the report, there are often changes made to different properties, just based on a variety of factors that one person may see that the other didn't consider, and things of that nature. It's just part of doing due diligence and making sure that you're being as fair and proportionate as possible when you're finalizing the report.
So you mentioned fair and proportionality. Are those the bases for those individual changes, or were there other bases for the individual changes as well?
Well, it would just depend on the property. There may have been, various elements that weren't considered, or maybe one person looked at an area slightly different than another, and we'd talk about it and reach a conclusion that we were all comfortable with. We felt that it would be more reflective of the market, and if changes were needed at that point in time, then they were made.
And about how many required some sort of recalibration? How many properties?
I don't know, Ms. Lynn. I mean, it would just I can't remember exactly how many properties when you go through a process like this, you work through the properties many times. So there's constant changes going up, trying to refine your analysis. So it's a very time consuming and intensive process to get through this type of study.
Did you look at any matched paired, or did you look at any actual sales as part of this internal review?
Oh, certainly. I mean, if you look at our information we provided, all our background information, we've got the significant amount of sales and rental information. So certainly, yes, we looked at sales. Trying to do a matched pair in relation to a project like this is it's very difficult to get like a one-on-one type of a scenario. Ideally, a matched pair type of analysis would be great, but it's very seldom applicable, especially in a project of this magnitude where you've got a lot of different elements and you're comparing them to other similar projects that have similarities of elements, but there's nothing exact that's out there that you're going to find in the market to do some sort of match paired analysis that we could find in the market.
Okay, so if there was nothing exact, when you're looking at these actual sales as part of your internal review process, how did you make adjustments in order to check your own numbers?
Well, we would look at other similar projects, how the market reacted to those, and just like in any appraisal, you try to bracket your low and high ranges, just like we've done in our worksheets. So our worksheets are a good example of kind of the mental exercise we went through to derive our special benefit estimates.
Let's actually turn to one of those worksheets right now. Let's look at the exhibit C19, which is the maritime building spreadsheet. And if you'd like, I'll just go ahead and share screen because it seems like that is. So this is exhibit C19, which is the maritime building spreadsheet. Do you recognize this?
Yes.
Scroll over. So you testified regarding this spreadsheet in your direct testimony, and you walked us through. And is it correct that for each of the commercial properties within the lid, you prepared a similar type of spreadsheet?
That's correct.
Okay. And scrolling down to this bottom where there's a special benefits summary, the ranges you have here for special benefit range from 2,087,000 to 4,617,000. Wait, yes,
Actually, they range
617,000.
from 2,087,000 to
Right, 6 million, right,
2,504,000. Yeah,
right. Sorry about that. Sorry, let me repeat that. They range from 2,087,000 to 6,504,000. Is that right?
that's correct.
And you testified that you used your professional judgment to arrive at this final figure of 3,848,000.
Correct, right. And we're also trying to be proportionate with other similar properties that have similarities to that property in the marketplace. When we're reconciling that, we're looking at the current state of the property and how hypothetically it would react before and after these LID improvements.
Would anything, based on these ranges, would anything between 2,087,000 and 6,504,000 have been reasonable as an estimate of special benefit for this property?
Well, again, we're doing this to try to reflect what an investor, what a typical market participator would consider, and this property is right on Alaska Way, so it's probable that it's going to see a greater change than say properties 3 or 4 blocks further away from the improvements. So in this instance, that's most likely why we had a fairly wide range, because we're looking at, well, what's really a worst case scenario and what's a best case scenario, and then looking, well, what's kind of reasonable, what's more in the middle of the market. And so and we're just simply trying to reflect how the market would look at something like this under the types of economic elements that we see as far as vacancy change, rent change, and capitalization rate change.
Okay, but for this particular property, looking at this spreadsheet, would anything within this range have been a reasonable estimate of special benefit because these are the ranges you came up with?
Well, in an appraisal, you always try to bracket your estimate. So is it reasonable? It would be 6. Well, no, probably something less than 6.5, and something probably higher than 2.07. And so you've got your high and low range, and then we're looking between that when we're reconciling our benefit and what would be reasonable, and what are other similar properties like this, although this one was unique. What are other similar properties like this? What's proportionate to what we're looking at in other properties? So it's just a reconciliation process you go to try to reflect the market and to reflect a proportionality amongst other properties in the market area based on our before and after assumptions.
Okay, let's actually change to another spreadsheet. Actually, let me make sure I don't have any other questions on this. If another appraiser was looking at this and was trying to determine how you came to this conclusion, how you came to this final conclusion, how would they determine that?
Well, I think they would, if they have any experience, they would see what I'm doing. They'd say, okay, yeah, he's bracketing the property. You look at his conclusion, he's saying, okay, it's something higher than 2.87, it's something significantly less than 6.6504, and okay, he's reconciling it somewhere between those numbers, and making a judgment call on what that amount is. And then also, as I've mentioned, in the context of doing benefit studies, that needs to be proportionate to other similar types of properties, so that we're being fair from one property owner to another.
So if another member of your team at ABS Valuation had come to you with this spreadsheet with these brackets between 2 and 6 million, 2 and 6.5 million, and came up with a final special benefit amount of 6 million, would you have asked them to recalibrate? Would
Well,
this have triggered an internal review? Sorry, let me
yeah, situations like that did come up where, in going through the internal review, we felt proportionately that we may be high on a particular property, and then when we'd go back and look at the worksheet and reconcile a different number, whether that be higher or lower, or maybe we stayed the same.
And when you were looking at these spreadsheets, aside from proportionality, were there ever any things that stood out to you on based on absolute numbers that triggered a further internal review?
Based on absolute numbers, what are you?
Right. So I guess let me just explain. So you said, something that would trigger internal review is if this percentage was very different from another similarly situated building, this 2.10%. I'm wondering, in your review, was it ever the case that you just saw this special benefit number, you saw these ranges, and you said, actually, I think based on these ranges and this number, we would like to engage in additional internal review of this property?
Oh, whether it be this or other properties. I mean, any significant amount of the properties we did in the LID were done over an extended period of time, and adjustments were made just to get the level of confidence that we had before we finished the report. So, some, like I said, some properties were changed because they were felt that they were disproportionate, or they had a higher or lower benefit than a similar property, and maybe the analysis was refined, the rent was refined, or the cap rate was refined, or the vacancy was refined, so that there were a lot of those changes that went on through the course of doing our study to get to the point where we were comfortable to finalize the report.
Thank you. And did you and your team members ever disagree on this final number based on a reason other than proportionality?
Well, there may have been instances where the dollar figure just seemed way too high for that property, and then we would look at, okay, what else have we done to that are we being proportionate or not? And if we were, then maybe no change was made. If we weren't, maybe another one, maybe a change was made. But proportionality is a main factor in what we're trying to do. So when we're narrowing our analysis down, it's the primary consideration we're looking at. But there are other elements that we may have changed to get to that number, such as the rent, or the vacancy, or the occupancy, or the capitalization rate.
And there's over 6,000 properties in the lid, right?
Yes, there are about 5,000 or so of them are condominiums, and there are, I think, about 1,050 individual, or 1,100 or so in kind of what I call economic entities, and about 50 or so of those economic entities are comprised of the condo projects, and then the rest of the tax parcels are comprised of the Belltown area, the downtown area, the Pike Place Market, and Pioneer Square, and the Stadium District.
Did you and your team so for these 6,000 some odd properties, which are very varied, as you just explained, did you and your team set any criteria for either internal review or recalibration? For example, if you're such and such off from actual sales, it triggers an internal review. That's just an example, but my question is much broader.
Well, it's really just on a parcel by parcel basis. I mean, it was a methodical critique, review of what we did on a parcel by parcel basis. And so, it was an extensive internal process to get to the point where we were comfortable to finalize the report.
So there was no criteria governing that process no overarching criteria that governing that process. It was more just a parcel by parcel approach.
That's what complies with state statutes. Yes, I mean we did it on a parcel by parcel basis, and that's the best criteria you can have to internally review what you've done.
Right, let's switch over to Exhibit 119, which I'll go ahead and just pull up and keep sharing because it's a spreadsheet. I'll wait a little bit for the rest of the objectors to get. So do you recognize this as your spreadsheet for the Hyatt Regency?
Yes.
And right here, you assume an occupancy rate of 80%, is that right?
Yes.
And you assume an average daily room rate of $365 per room?
Yes.
And you based this number, this $365 dollar number on sources such as Expedia.com, Booking.com?
That's correct.
And so this is based on rack rates, which are generally higher than actual rates?
Correct. Yeah, we also consulted with Mark Lukens, who reviewed all these worksheets for reasonableness.
Okay. And John Gordon, who had actual numbers for this hotel, explained during our objection that the actual room rate for this hotel was $205. Do you have any basis to dispute that?
No, I have not seen his actual information that he's basing that on.
So you have no basis to dispute that?
No, other than I have not seen the information.
And John Gordon stabilized his actual room rate at $222 based on actual room rates as well. Are you aware of that?
Sounds close to what I've reviewed.
Okay. So which figure, John Gordon's figures or your $365 figure, is more consistent with historical performance for this hotel?
Well, again, I mean, if I was privy to that confidential information, which I haven't been, it hasn't been provided, I would put more reliance on after I've had time to review it, and I felt it was reasonable. I would put more relevance on the actual reported revenue that the hotel's generating than based on what I had to rely on, which was market-based evidence. I wasn't provided any of the hotel's confidential proprietary information.
And that's because this hotel proprietary information about actual room rates, it's giving you the historical performance of the hotel, and therefore so helpful to project anticipated performance. Is that right?
Yeah, Ms. Lynn, you kind of cut out there a little bit. Could you please repeat that?
Yeah. So this actual room rate information is important because it is based on historical performance and helpful to projecting anticipated performance for hotels. Is that right?
Yes, I would agree. If I had the actual historical performance, it would have been very helpful in doing this assignment.
Okay. And correct that you're using the income approach here, right?
That's correct.
And the income approach takes revenue and operating expenses to come up with a net operating income and then capitalizes that to come up with a value. Is that right?
Correct.
And room revenue, as you can see, is the largest source of revenue for hotels. Is that right?
Definitely, yes.
Okay. So it's pretty important that you get a reasonably accurate room rate. Is that right?
Yes, and we tried to do that based on the best information we had available to us, and I think what anybody else in the market would look at.
Are you aware of what a star trend report is?
Yes, I've heard of it.
And what do you know about it?
Oh, that it breaks down a group of properties relative to room rate and that type of thing.
And are you aware that you're able to purchase a star trend report for a group of hotels in downtown Seattle, for example, and those trend reports would be based on actual room rates?
Yes, I'm aware of that. I mean, we didn't use the STAR report. That's why I brought Mr. Lukens on board. He's got 30 years of experience in doing these, and we didn't even I didn't even consider the STAR report at the time I was doing my analysis. I thought it would be better to bring somebody in that specializes in hotels more so than I do, and have him review everything that we've done relative to the income approach and also relative to comparable sales.
So how does it affect your analysis or your view of your analysis now that you know that your estimated room rate for the Hyatt is over 175% of the actual average room rates?
Well, assuming that what Mr. Gordon's saying is he has a basis for it, it would affect both our before and after values if we were to use a lower rate, and it would reduce both the before and after values, and then we would compare that with comparable sales to see if it was reasonable and really indicative of what's going on in the market.
And that same thing is true now that you know that the room rate you used of $365 is over 150% greater than John Gordon's stabilized room rate of 220.
Well, I don't know that. I haven't seen the information. That's based on what he's provided. I have not, like I said, I've not seen it.
Are you aware that John Gordon has testified under oath that he received this data from hotels, and that the numbers he presented were based on actual room rates from the hotels he looked at?
Yeah, I'm not, he's being dishonest. All I'm saying is that I haven't seen it. I mean, Mr. Lukens said that, oftentimes you'll look at the STAR reports as well, and they take a certain degree of estimation to arrive at the daily rate based on comparison of that data. So it was unclear to me whether he's using actual confidential income room revenue rates, or if it was a hybrid of that and the STAR report. And in talking to Mr. Lukens, said, well, the STAR reports require judgment just as looking at information that, that's online. And at the end of the day, we're looking at the difference of market value without and with something. So perhaps if our room rates a little higher, you may have a different cap rate or changes in the market. So again, I would need to see what Mr. Gordon has and how he came up with his figures, and if they were different than ours and relevant, then they would affect both our before and after values. So the ultimate difference, the delta, the benefit, it may be affected some, it may not be affected a lot. I don't know. It's just an analysis that I haven't done.
So it's possible some of these hotels might require adjustment as well?
I don't know. I mean, you're looking at the difference in market value, before and after, and if the room rate's lower, maybe the depending on how we looked at things, maybe the judgment of myself and Mr. Lukens would be different. Perhaps the benefit amount would be similar or slightly less. I don't know. I mean, that's not an exercise that I've done.
And scrolling over here, sorry. So I'm going to scroll out. You've already explained what these three columns show, so I won't have you do that again. Let's just zoom right into the second column. So in these first two scenarios, low, high, you assume that room rates and other sources of revenue will increase by 0.2%, and 0.45% in the low-high scenarios, respectively. Is that right?
That's correct.
And you're holding occupancy static at 80%.
That's correct.
Okay. How did you come up with this low percentage of 0.20%?
Just an adjustment based on market information, discussions with Mr. Bird, who helped me and did a lot of the hotel analysis, and Mr. Lukens, and looking at the before and after of the elements, the location of the property, is it reasonable that they could get a little more revenue with the LID completed, and if so, approximately to what percentage range. So just a judgment based on a review of the market.
And is there anywhere in the report where we can see this work, or see how you came up with these two percentages in the low and high scenario?
No, again, we didn't write a separate report for this this property.
Is there a model or an equation you're relying on?
Just our judgment, and trying to be consistent with how we're looking at the changes in other hotels in different areas of the LID.
Are there any studies or data that inform this analysis?
Again, it's just looking at other market studies in other areas we looked at, where the change in the project elements that we're looking at reflected an increase in their revenue. So, it was discussions that Mr. Lukens had with other property managers, would have been part of the input that went in there, and then just looking at the location change of the property before and after the LID. What would be a reasonable, similar to the reconciliation we did at the bottom of the page, the same kind of mental process goes through to looking at the high and low range, what would be reasonable in the market.
And so for this particular property, the Hyatt Regency, can you walk me through kind of exactly what the process was for arriving to 0.20%? It's a very specific percent.
Yeah, again, I mean, there's what we do isn't an exact science. I mean, we're making judgment calls based on looking at other similar projects that are out there, like in New York and Boston, and the impact that had on revenue, and just making judgment calls, looking on location differences of the property before and after the LID, to arrive at what we felt a reasonable range was.
I understand that it's not an exact science. I would like to know your best description of what that process looked like.
I just told you.
If someone on your team had said, actually, I think the low percentage should be 0.25%, how would that have been received?
I don't know. Like I said, in a lot of these analysis, we like on this particular property, we probably went through scenarios where we changed both the occupancy rate and the room rate. I mean, it's got we're looking at how the market would react to something based on different variables. So, at the finalization of what we did, this is what we came up with. But we probably looked at different variable element changes. And in this case, we just felt, given where the property was located, that the occupancy rate probably wouldn't be impacted as a result of this. Whereas a property like the Marriott, just given its proximity closer to the promenade and the Overlook Walk and the waterfront area, that they may see a little change in occupancy as well as room rate. So it just depended on where the property was located at.
Yeah. And I understand you do start with these general principles like location of the property and whether or not you think that it'll draw additional tourists due to proximity to some of the lid improvements and other things. I guess I'm wondering how these general principles boil down to an exact percentage.
It's just a judgment call. We bracket a high and low range. And again, even on the room rate change, we would have looked at different variables, and is this reasonable? Or is this one more reasonable? And at the end of the day, just make a determination of what we think would be an investor's perception of what kind of change you would anticipate in a property like this, given its location.
Okay. And it looks like you use these same percentages, so that's 0.2% and 0.45% to increase food and beverage revenue and parking and other income revenue. Is that right?
Yes.
And so for food and revenue, you go from $40 in the before, right here, to $40.08 in the low scenario and $40.18 in the high scenario. Is that right?
Yes.
And is this based on an assumption that hotel managers will charge between 8 cents and 18 cents more for food and beverage items based on the lid improvements?
No, it was just based on discussions with with Mr. Lukens and looking at the market that it'd be reasonable that that amount of change would flow through the different revenue sources. There was no individual information about that the food or beverage revenue would be different than that. Would there be some change? Yes, it's reasonable. Is it reasonable? It would be similar to the change in the room revenue. Would it be applicable to other elements of the hotel? And we felt it would be a reflection of the market, and that's what we based our opinion on.
So is there any data that actually goes into these, or I guess any data or studies that go into the increase in the food and beverage revenue?
Well, I know Mr. Lukens looked at a number of, he has more studies and looked at other revenue information, and that's a lot of where we got a lot of these figures. So we relied on his judgment too on how much it would increase. So
Okay.
he would have looked at sources like that.
And so parking and other income also gets increased by these same percentages. Were there different studies and data for parking than there was for food and beverage?
I don't know if we looked at any separate parking studies. Obviously, we knew what the published rate was for parking and things of that nature. So that would have been a consideration. And then again, we just felt that revenue stream would be roughly similar through the parking revenue and the food and beverage revenue.
Okay. Did you do any reliability testing to determine whether these two percentage estimates, 0.2% and 0.45%, were reasonably accurate?
Well, reliability testing in the sense that we had these reviewed for reasonableness, for reliability. That would have been our testing.
And that was Mark Lukens?
Correct.
And just to reiterate, these increases are all hypothetical, correct? They're based on your hypothetical condition that that the after improvements are in place as of October 2019.
That's correct.
So it looks like the formula here is E18 times 1 plus Q17. So E18 is 365. That's the before room rate. And then Q17 is the percentage amount. Is that correct?
Yes.
And so this figure is the before value times 1.20%. Based on this formula right here, 1 plus Q17.
Yes.
Okay. So this figure right here is your before value multiplied by a special benefit percentage.
We're just showing that for purposes of information, so the reader can see what percentage change that we applied to the room revenue, the food and beverage, and the parking revenue.
And again, this room revenue, food and beverage revenue, parking and other income revenue ends up getting capitalized into an after value. Is that right?
Yes.
And so you did the same thing. If you look at the equations on top right up here. It looks like this one is the before room rate times the after percentage. This one is the before food and beverage revenue times the low percentage, and likewise with these other numbers. Is that right?
Yes.
Ms. Lynn, we'll take a break there. We'll return at 1:15 after our lunch break. Thank you.
Thank you.
We will return to the record. Is Mr. McCauley on direct?
And this is actually on cross.
Sorry,
and
correct. Yes.
Should we go ahead and admit the exhibits that we've already talked about?
If you like.
I guess we can just, I guess let's go ahead and admit exhibits 117, 118, 119, and 130. And with the clarification that exhibit 130 is actually the notice of assessment for the Sound Hotel and Arrive Apartments and not for the Marriott.
Right. Any objections to 117, 118, 119, or 130 being admitted?
No objections.
117, 118, 119, and 130 are admitted.
Okay, and let's continue with exhibit 119, which is the spreadsheet that so I will share it.
And Ms. Lynn, let's clarify what numbering system we're using. We've got 117, 118, and 119. We didn't identify when you started the case numbers for which you're representing. If you could state those in short form without listing them all, so that we have that for the record. And we're picking up from, I assume, 116, where we left off with those earlier in the hearing.
Sure, and these are for case numbers CWF 233, 318, and 409 through 441.
Thank you.
Absolutely. So I will go ahead and share screen again. So picking up where we left off, we're talking about the Hyatt Regency, and this is the spreadsheet you prepared for that property. And we talked already about this first scenario where you increased revenue amounts by a specific percentage. Now let's turn to the third and fourth scenarios, and that is in this third column. And for this third and fourth scenario, you kept the net operating income the same, but you made slight adjustments to the capitalization rate. Is that correct?
Yes.
Okay, and so in the before scenario, the capitalization rate is 7.25%, and here in the after, it's 7.2% in the low and 7.23% in the high. How did you derive these changes, which are a point, I think? How did you derive these changes in the capitalization rate?
Well, the capitalization rate is the relationship between the sale price and the net operating income. So it's a perception of investor risk, the upside revenue potential that the property may have in the marketplace. So recognizing that, it's reasonable with this project completed that there's going to be slightly lower investment risk relative to the before condition in the market. And again, just based on judgment, having looked at a lot of different sales and just recognizing the locational difference between this property and say other properties we've looked at down closer to the waterfront hotel properties, that the capitalization rate change most likely would be slight, not as significant. So again, it's just a judgment call, looking at the market, looking at market evidence, and based on my experience, how an investor would look at it within a range. If they had to look at capitalization range, would they have the same cap rate as they did before? I don't think so. I think they would reflect a lower cap rate range to reflect the enhanced revenue that's probable in the market, the investment risk, the more just a better investment amenity in the after condition.
And were there any studies or reports that specifically um, informed this analysis?
They're capitalization studies that CBRE puts out nationwide that covers a broad spectrum of property types. They'll show variations from from month, from quarter to, I think they're done quarterly, but they'll show variations from quarter to quarter that can be relatively small for different market sectors. Just kind of, again, it's just the perception of investment risk and how the investors are looking at the market. Also based on discussions with Mr. Lukens, is that kind of cap rate change reasonable? And we looked at elements like that and made a judgment call on it.
And so there's no model or equation that you're relying on for these adjustments?
No, there's no statistical modeling or equation that we're looking at. It's just what we're hired to do is make an appraisal judgment based on the parcel by parcel basis. And given this particular parcel's location and difference in the before and after, it's just an estimate based on how we think the market, a range of how we think the market would perceive a cap rate change.
And you testify that you believe these types of cap rate changes, and here it's 0.05% and 0.02%, that these are measurable in your direct testimony. When have you seen these types of micro adjustments in cap rates before?
Well, anytime you're looking at sales, there'll be slight differences in cap rate changes depending on the location of the property. They can be significant, they can be fairly small. So just looking at thousands of sales over many years, you see sometimes a small change in cap rate, sometimes a large change in cap rate. We're just simply trying to provide a reflection of how the market would look at this if they had to if their decision was based just solely on a cap rate change. Is it reasonable? It's going to be less. Again, trying to bracket that. Is it going to be 7%? No, that's probably too drastic a change. So just try to bracket it to where we feel it's reasonable based on the property's location and its investment quality and the difference that it would reflect in the market before and after the LID.
Can you give an example of when you've seen, can you give an example of a factor that has produced a cap rate change of 0.02% in the market that you've seen? So
well, I just think any investor, if there's a slight upside in revenue, they'll pay a slightly lower cap rate for that investment. So it's just again, it's based on judgment and based on looking at other sales. Cap rates, like I said, can range widely depending on the type of property, but they can also vary very little when you're confirming the sale.
and again, because these cap rate changes are based on your hypothetical that improvements are in place by October 2019, can you opine as to what point over the period between 2019 and 2024 you'd expect to see the actual incremental cap rate change for an owner that might be wanting to either sell or refinance?
I couldn't answer that. That's not an analysis that we've done.
Quickly, just going back to the scenario 1 and 2, could you just give, looking at this exact property, so the Hyatt Regency, you've said that you've looked at a lot of different sources that informed these percentage increases, and that it came down to a judgment call. Can you just name one study or report that helped you with respect to this property develop this special benefit percentage increase?
Well, again, my scope of services to the hotels was more on a review capacity. So, I know that Price Waterhouse, CBRE, Kidder Matthews, there were a number of sources that looked at. Mr. Lukens helped significantly in that regard, and helping, look at probable adjustments, and having more experience in the hotel market than I do to help in that aspect.
All right, going down to the summary section, which is down here, special benefit summary. So the property, the special benefit for this property ranges from 2,028,000 to, it looks like 5,090,000. Is that right?
That's correct.
Okay. And consistent with your prior testimony, you arrived at this figure as a matter of judgment. Is that right?
Yes, it's a reconciliation of the high and low ranges of the properties we looked at, and also to maintain proportionality with other nearby hotels that would have similar highest and best use.
Okay, and correct also that there's nowhere in the report that we can actually see the analysis of where how this reconciliation occurs. Is that right?
Well, you see it right in front of you. I mean, that's where the reconciliation occurs. Again, we haven't written a report that goes into our any detail, but that's why we did individual worksheets, just to show the reader how we arrived at these figures, because we aren't writing a report. We want to provide a summary of our thought process, so a property owner can have an idea of how we went about looking at the different investment risk elements, and location changes and other factors that influence value of property within the LID.
How would someone check your judgment against data?
How would they check it
Yeah.
against data? Well, they could look at comparable sales and see if the before and after values are supported by comparable sales data, which they certainly are. That's a check we looked at as a test of reasonableness, was looking at comparable sales. I think that would be your best check.
Do you know which comparable sales you looked at to check this property?
There were a number of sales out there. I don't have off the top of my head. There's the Alexis that sold, and Mr. Lukens testified to that the other day. I don't have them off the top of my head, but there's a comparable sales list out there that could be reviewed.
Okay, so let's just take the Alexis, because you mentioned that one. You would have had to make, because the Alexis sale occurred a little while ago, you would have had to make adjustments to that sale to account for the before conditions and the after conditions in order to make this comparable. Is that right?
Correct.
Okay. And how are those adjustments made?
Well, again, it would just be looking at it on the context of test of reasonableness, how it falls within the spectrum of what we see. Are those, would those kind of changes be reasonable from an investment standpoint in comparing the Alexis to property like this? And the Alexis probably isn't a great example. I mean, it's more of a boutique hotel, but the same kind of thought processes would be in play, where you would look at those sales within the test of reasonableness, and is this $3.57 million or $2,800 a room sale price reasonable given the before and after conditions that are prevalent in the market?
Right, but because there are no comparable sales in the after condition or the before condition, because both of those are hypothetical, all of the comparable sales you would use as a reasonable check would require adjustments to account for those hypothetical conditions. Is that right?
Yes, this is as in any appraisal. You would make adjustments if the properties had dissimilarities, such as location, investment risk, and things of that nature. So yes.
And so going back to my question about how someone would go about checking your judgment conclusion based on data, how would someone know how you made those adjustments to those comparable sales to determine that this one, to conclude that this?
Like I said, we didn't do a separate sales comparison approach where we showed the adjustments and whatnot. They were used mainly as a test of reasonableness to support both our before and after analysis, and somebody could look at those and look at what the price paid for room is, and look at the before and after conditions, and make their own determination of whether they think that's reasonable or not. I mean, obviously, the vast majority of the property owners downtown felt we were reasonable in our conclusions. There were very, other than the hotels, there were very few commercial properties that have protested the LID. So, they have the ability to hire an appraiser and review what we've done. There's been at least a year and a half or so, the hotels could have contacted us and say, hey, we think your values are off, and we would have been happy to sit down and talk to them and go through this process, and if there was factual information they had, we would have been happy to look at it. But this is the analysis that we made, and that's our opinion of what the market difference would be given the before and after conditions.
Okay, so you end up concluding a special benefit percentage of 0.49%. Is that right for the Hyatt Regency?
Yes.
And you previously testified that there's no margin of error in this report or for mass appraisals generally, no accepted margin of error. So looking at this, would it be reasonable for two appraisers to look at this information and conclude a special benefit percentage of 0.7%?
Well, I don't know. I mean, that would be somebody else's opinion. I mean, when we're looking at it, we're bracketing it and saying, well, it's reasonable. We're probably going to be somewhere between 5 million and 2 million, and looking at the property's location and whatnot. I mean, it'd be up to if the independent appraiser whether they thought it was reasonable or not.
Would it be reasonable to come to the conclusion based on this? Appraisers looking at this looking at this information. Would it be reasonable for an appraiser to come to a negative special benefit conclusion?
Well, I don't know, Ms. Lynn, what a reasonable appraiser would do. I did my work based on my best judgment and looking at how we see the market in the before and after conditions, and how somebody else, or for me to speculate on how somebody else would look at it. I just can't answer that question.
I'm actually not asking you to speculate how someone else would look at it. I'm more asking you if it would be reasonable for two people to come to certain different types of conclusions based on the data right in front of us right now. And so I guess a simpler way to ask this is, could one of your analysts have come to a conclusion outside of this range, and would that have been acceptable as a final figure in this box right here?
Well, it wouldn't be acceptable in my opinion. I don't know what basis they would have formed their opinion on or whatnot. So like I said, I mean, I did what I felt was fair and reasonable and proportionate with other similar hotel properties.
Okay. So this range is from about 2 million to 5 million, right?
Yes.
Okay. So if we were to change this room value right here, which is 365, to Mr. Gordon's stabilized room rate for this hotel, which is $222, that changes these special benefit amounts to be around 900,000 to ranging to 3 million. Is that right?
Well, you would also need to do that in the after situation. You know, your after room rates are going to change as well. And
right, but this spreadsheet does that for me actually, because
yeah, true. Yeah, it would have an impact. Again, we would need to look at that room rate, whether it's reasonable, look at it in comparison to other sales, and see if it provided validity to a market value estimate. But if you just purely input his number like that, yes, but that's not our appraisal work.
Do you have any reason to doubt the accuracy of any of the other numbers in this spreadsheet?
Well, other than their estimates, I mean, they're based on market information and talking with very qualified market consultants. So like anything we do, they're an estimate.
Okay. Does this proposed assessment for the Hyatt Regency include personal property?
Yes, we would, most sales that, most hotels that sell typically sell with FF&E, their furniture, fixtures, and equipment. So that market value estimate would have reflected that.
And so was all personal property in the lid assessed for all different types of property?
No, just the hotels. That's how they typically are sold in the marketplace.
And so would that explain why, let's say, for example, Perkins Coie did not receive a lid assessment based on its ownership of personal property located within the lid?
Yeah, I don't know. That's not my area of expertise in sending out notices. I just provide the market value estimates before and after the LID and provide that information. And that's what the assessments are based on.
And for when you're assigning a special benefit to personal property, did you calculate that benefit at the same rate as the real property in which it was located?
We looked at the properties as an economic entity, and furniture, fixtures, equipment, personal property is part of that economic entity. So we have a sales chart that breaks out approximately, if we had the information, what the personal property versus the real estate is. But because it typically sells with that in place, and talking to Mr. Lukens, it's often a negotiated factor of the sale price, but it's part of the bundle of rights that are sold in the hotel market. So we included them in our analysis.
So in effect, everything is getting the same rate, the special everything is being assessed the same percentage within that one legal entity, real property and personal property for each hotel.
Yes.
Okay. So, for example, a television in the Waterfront Marriott would be assigned a greater special benefit than a television at the Hyatt Regency because the Hyatt Regency received a lower special benefit percentage.
Well, I don't know if you could break it out by a TV set. Typically, like Mr. Lukens said, that the personal property is often something that's negotiated, and I'm sure there's other depreciation and other factors involved in it. So I don't think you could compare a hotel to one to a hotel to the other. It's part of the economic entity that's sold, and there are different room counts and other revenue bases that are relevant to each hotel. So it's just part of the bundle of rights that we're appraising.
So talking about that, you just mentioned depreciation. Is it reasonable to assign the same special benefit to personal property, which is mobile and highly depreciable, especially in hotels, as you do for real property?
Again, we're looking at the bundle of rights and how hotels typically buy and sell. We had some personal property information on some of the hotels and not others. In talking to Mr. Lukens, it's an area that's often negotiated through the purchase sale process and can vary considerably. So it's part of the rights that we valued both in the before and after the LID.
Mr. Gordon talked a little bit about this, but I'm not sure that you might have heard this. You might not have heard this testimony. Do you know the economic life suggested by the Department of Revenue to assessors in valuing hotel personal property?
No, I don't.
So does 5 years for televisions and 8 years for furniture and equipment seem right to you?
I don't know, Ms. Lynn. As I said, in talking to Mr. Lukens, he said these are often negotiated, and that's probably why, because there are varying degrees of ages of the different furniture, fixtures, and equipment that are relative to each hotel.
So assuming these are correct numbers, 5 years for televisions, 8 years for furniture and equipment, why would a personal property in place on the assessment date benefit from improvements that will not be in place until after or near the end of the useful life of that property?
Because we're basing it on the assumption as of a given date and time, not 5 years hence.
All right, let's take a look at another spreadsheet. I'll go ahead and keep sharing these spreadsheets because it seems to be helpful. We're going to look at Exhibit 120, which is the spreadsheet for the Grand Hyatt. Okay, so is this the spreadsheet that you prepared for the Grand Hyatt?
Yes.
And the address up here looks like it's 721 Pine Street.
Yes.
And it looks like you assumed an average daily room rate of $355 per night.
Yes.
Again, this is based on things like Expedia, Booking.com, and not based on actual data from hotels or star reports.
That's correct.
Are you aware that the actual room rates for this hotel in 2018 was $250?
Again, I have not seen that information.
But if you had, would that change your analysis for this hotel?
If I had time to evaluate it and see where it came from, and that if it wasn't a hybrid of other reports or how it was derived, and if it was credible, it would be a consideration in our analysis, sure.
Okay. So similar with the Hyatt Regency, if Mr. Gordon is correct that these room rates are pretty off, your analysis for this hotel might need adjustment.
Well, it could. Again, we would look at that information, and we'd also look at other sales. And if it reflected a value that was well below what other similar sales would go to, we may make adjustments to that. It would be a separate appraisal process that we would go through to determine what the benefit is.
And when you're looking at comparable sales, that's as a reasonable check, correct?
Yes.
Meaning you're not using a cost
In this
approach
case,
for the hotel.
in this case,
I mean,
in this case, primarily because we didn't do a separate sales analysis, but we looked at them as a test of reasonableness, what the conclusions came up with for our income approach.
And for hotels, it's typical to use an income approach.
Income approach and a sales approach.
But it appears you've used an income approach here. You've chosen to use an income approach here, correct?
We chose to do an income approach for most of the commercial properties and augment that with comparable sales. So this is typical of how we looked at how the market would most likely react in estimating a before and after value would be to do an income analysis and then also look at comparable sales to see where that fell within the spectrum of the property type you're evaluating.
Okay, but if I were to look at your final report and I were to try to figure out what approach are you taking with respect to hotels, it would say income approach. Is that right?
I would say income approach and direct sales comparison approach, but we're using the direct sales comparison approach more as a test of reasonableness to see if the conclusions derived from the income analysis reflect the buyers and sellers thought process in the market.
And where can we see this comparable sales data that you're using for each of these hotels as a reasonable check?
Well, I think Mr. Lukens provided a comparable chart as well as what we have in our backup data.
And was that chart provided with his declaration?
I don't know exactly. I think he provided one to us, and he may have provided one in the declaration. I can't recall.
And was that one single chart used as a reasonable check for all of the hotels?
Whatever hotels were relevant in the marketplace at the time would have been covered on that chart.
Was that provided as part of your final study?
It should have been in our the chart that he provided should be in our backup data. I know it should be because he provided it to us before finalizing our study, and then I know we have a hotel chart in there as well.
All right, so Let's do the same thing here. We'll change this $355 room rate to the stabilized room rate that Mr. Gordon calculated based on actual room rates from the hotel. So, and that was 240. Actually, sorry. Let's go back to 355. At 355, the special benefit range from $2,331,000 to $4,712,000. So about 2.3 to 4.7 million. We change this to 240. The range changes from 1.3 million to 3.2 million. So it does appear that changing room rate alone produces pretty significant change in using all of your data and all of your methods. Is that correct?
Yeah, assuming the other factors, assuming the other factors are correct. Excuse me a second.
So it's possible your other factors here are also incorrect?
No, I'm not saying they're incorrect. I mean, assuming that Mr. Gordon or whatever the hotel operating expenses showed were relevant to those.
Okay. It looks like this one has some, okay. Um, Moving over to scenarios 1 and 2, looks like the special benefit estimates here are 0.6% and 1.20%. Was your analysis here different than with the Hyatt Regency? Meaning, were there different studies and data that informed this specific percentage increase?
The same thought process as for the Hyatt Regency would have gone into this hotel.
Okay. Is that generally true for all of the commercial properties?
Yes, and it's based on our judgment and how we would look in the market, how other similar projects and other similar cities reacted to the various property types.
Okay. And you use these same percentage increases to increase room revenue and food and beverage revenue, but parking and other income is not included here, and that is because there is a separate parcel in this hotel for parking. Is that right?
Yes.
Okay. And for the third and fourth scenario, same thing. You change the cap rate. For these cap rate changes, was your analysis similar to your analysis with the Hyatt Regency? And specifically, are you relying on similar data and studies?
Same type of thought process.
Okay. Let's go to the next spreadsheet. And this is the Hyatt parking. This is Exhibit 121. And is this your spreadsheet for the Grand Hyatt parking retail parcel?
Yes.
And same address, correct? 721 Pine Street?
Yes. That would have come from the assessor's office. The physical address may be slightly different.
Okay. Have you visited this parcel, the exterior of the Grand Hyatt?
I've stayed there many times.
So just walking around, can someone tell that the parking and retail parcel is legally separate from the hotel?
Well, I think it would sell as a bundle of rights. I think anybody buying the property would buy it as an entity and not split it out. As I said earlier in my direct testimony, we have to look what we call as the larger parcel, and we looked at this property as being a larger parcel, whereas the market would buy it as an entity, but because they're separate legal tax parcels, we need to provide separate analysis, separate benefit and assessment estimates for them.
Okay. And it looks like this has 950 parking stalls. Is that right?
Yes,
And you're assuming that the Grand Hyatt is leasing stalls and is specifically leasing 457 stalls. Is that right?
yes.
And this 457 stalls is generating revenue at 80% occupancy, 365 days a week.
Excuse me, Ms. Lynn, I think can you go back to, this may be a separate legal ownership. I can't remember. It's been a long time since I've looked at this spreadsheet, but
Sure. What would you like me to do?
it was a separate legal ownership from the
Grand.
previous study. We would have been looking at this as a separate entity.
Oh, so are you saying who is the taxpayer?
Well, who's the property owner? So it looks like there's two different legal entities that own each of the properties. So we would be looking at them as two separate entities.
And you're looking at them as two separate entities because there are two, because
Separate legal ownerships.
separate
They're not
legal
the same
ownership.
owner as best as we can tell. This property is incredibly difficult to break out due to the nature of how it's set up. But the parking and retail is a separate entity, 7th and Pine LLC versus the Hedron LLC.
Okay. And so going back to parking stalls, so all 457 stalls are generating revenue at 80% occupancy, 365 days a year. Is that right?
That's how the math is set up, yes.
Okay. And so every hotel guest is assumed to be occupying a parking stall.
Well, no, we're looking at a 20% vacancy on parking for the 457 stalls, and then we're backing out
Right. Well,
expenses.
all right. So the 20% occupancy is because the hotel occupancy rate is 80%, right?
Yeah, correct. It's the same percentage.
Okay. So every hotel guest is assumed to be occupying a parking stall because you're using the same
If it's
occupancy rate.
yeah, at a stabilized rate, yes.
Okay. And then the non-guest parkers are, which are the monthly parkers, are occupying the remainder of the stalls at $320 a month. So that's just a little over $10 a day.
It looks about right.
Okay. And so for the hotel parcel, if you recall, in scenarios 1 and 2, you increased room revenue by 0.6% in the low and 1.2% in the high. And here you have it increased by 1.4% and 1.6%. And the same thing for the retail income. What is the basis for these percentages?
The same thought process goes into place. And you have a retail component there too, which would maybe have a little more desirability from the ground level nature of the retail there. Again, it's just a judgment call based on our perception of the market.
If you had been consistent among the different hotels, so would we have seen a similar percentage increase for the parking and retail income here, but for the fact that this happens to be a separate parcel with separate legal ownership?
Well, again, we're looking at this evidently because it is a separate ownership, and it's broken out into, as you can see up top, there's various ownership interests. You've got the convention center, you've got the hotel component, and then you've got the separate legal entity of the parking retail component. So for informational purposes, we kind of showed how unique this particular property is in breaking out into the different percentage ownerships. So in this case, we're looking at the Seventh and Pine LLC, the parking and retail, as a separate entity, and those high and low rates are estimates of revenue change before and after the LID due to where the property is situated.
I understand that, but it appears, I guess my question is, if this parking income and retail income had been part of the same parcel as the legal parcel as the Grand Hyatt Hotel, we would have seen the same percentage increases, correct? And those would have been 0.6% and 1.2%.
Potentially. Again, if you look at it, it's a separate legal ownership, and it's not. We're looking at it as a separate legal entity. So we've got a slightly different high-low range that we're looking at for this particular property based on its attributes.
Are you aware that the Four Seasons Hotel also occupies multiple parcels?
Yes. I think there are three separate tax parcels that comprise the Four Seasons.
And it's similarly those parcels, some of them have to do with parking and retail, some of them have to do with the hotel itself. Is that right?
Yeah, and I believe some of the parking, if I can remember, is part of the condominium development. So it's another unique, complex property.
And for that hotel, do you recall whether you also applied different special benefit percentages for those different parcels?
I don't recall.
And for the cap rate here, you started at 7.25% over here, right? Yes, 7.25% in the before scenario. Typically, wouldn't parking lots be capitalized at a much lower rate, for example, 4%?
No, I don't think so. This has also got a retail component to it as well. So, I think it's a reasonable cap rate.
Did it affect your analysis that the hotel parcel also is capitalized at 7.25%?
Yeah, it's just our estimate for this particular property.
And then you changed the cap rate to 7.13 and 7.15% in the high-low scenarios. Again, had these been one parcel and one legal ownership, this NOI would have been capped at 7.11 and 7.17% as with the hotel itself. Is that right?
Well, it's a separate legal entity. So we looked at it on a separate legal entity basis, and we ended up coming up with a different change.
I understand that it's separate legal entity, but you just testified also that you looked at it as sort of one whole to come up with the 7.25% cap rate.
I corrected myself on that. If you remember also that I remembered that it was a separate legal entity. So we did look at it separately. If you go back up to the top to the breakout of all the ownership and all the ownership interests, the convention center is also part of the ownership entity interest. So obviously we're not looking at it as one entity because we're not including the Washington Convention Center as part of our analysis. So the hotel was looked at as one entity, and then the Seventh and Pine LLC was looked at a separate entity because of the parking and retail components.
Do you think a buyer of this property would assume this increase in parking revenue coming in 2024 if they were purchasing the property today?
Well, again, we're looking at it as of a specific date and time. I'm not valuing it as of 2024. So this is our estimate of what it would be as of our valuation date.
And then going to the summary here, and it appears you conclude an overall special benefit increase of 1.49%. Was this influenced at all by the fact that your hotel parcel also, oh, I changed this. Your hotel parcel was at 1.5%?
We're just trying to maintain proportionality and looking at other similar properties. I think if you looked at other similar parking garages in the area that are nearby there, if they're broken out as a separate entity, they'd be fairly close to that change.
And so you might have, well, let me ask this a different way. Would you have a disproportionality issue if these two parcels, Grand Hyatt Hotel, Grand Hyatt Parking, had come to a different special benefit percentage? Would that have triggered a reconciliation internal
Well,
review?
the statutes reflect a roughly proportionate amount, and I think, obviously part of the parking element goes to the hotel. That would be part of the bundle of rights of this particular property, and part of it would go to the public. Again, that's part of the bundle of rights of the property. It's a separate percentage ownership of a larger entity that also includes the convention center. So, it was a unique property. We felt that that change was indicative of the market.
So there was no attempt, when you were looking at this, when you were looking at the Grand Hyatt Hotel parcel, did you look at this parking and retail parcel in tandem with that other parcel?
Well, no, we looked, because it is a separate legal entity. We had to value it on that basis. We can't assume two different ownerships are what they're not. And so, if they would have had the same ownership interest, then they would have been looked at as one entity. If they don't have unity of ownership, I can't look at them as a larger parcel, although they do have there is some parking use associated with the property, obviously by agreement with the hotel. So it's a unique, challenging property to appraise.
Sure. Are you aware that for the Four Seasons, those three parcels also came to a special benefit, an identical special benefit percentage conclusion?
I don't recall that, but it's been
If that were true, would that be a matter of coincidence? Or would that be
I just
for
think it would
proportionality's sake?
it would just be our estimate of how the market would react to the unique aspect of that ownership interest.
Okay, I am done with this. So we're actually going to hop into Exhibit 122, which is your declaration. And I'm going to pull that one up as well because I'd like to ask an interactive question about it. It's Exhibit 122 for those of you who are following along.
Ms. Lynn, I just want to check on timing with you for the amount of time you estimate for continuing with your cross with Mr. McCauley.
It's a good question. I'm hoping to be done by 4.
Okay. So does that match with the time allocation that you've worked out with the other objectors? Or are you over or under?
So with the breaks right now, I estimated 5 hours for Perkins of cross-examination time. And so I believe that takes, so I guess that would be more like 3:45 rather than 4.
But you're still within the same amount of time that you estimated earlier, roughly?
Yeah, correct.
Okay.
Okay. So you've testified that that to determine the lid boundary and to estimate special benefits, you and your team looked at over, quote, 25 studies and reports. That is in paragraph 13. And then you provide a link saying that these have been publicly available. So I just wanted to ask you if you could walk us through exactly where these are located. So here's the link. I just opened the link. And if you can see, there's a file tree. And I'm wondering, these 25 studies and reports, in which of these folders are these 25 reports? Is it this?
Yeah, they should be under the research file. It's just a separate file that says research.
I don't see a separate file that says research.
They might have renamed it for that. Try 2019 report info.
Okay, so I will do that. I can do that, although it might take a little while because it has to download. So I actually already downloaded this. And let me pull that up. Sorry, it's still. No, somehow I've lost it. Apologies. I will find it in 1 second. Okay. So this is the 2000. If this is 2000. This is what happens when you download the 2019 report info. You get
Yeah.
these. You get these three. Sorry.
Yeah. And then you go into each one of those and you'll see other reports that will propagate.
So there's three in here. Are these three that you relied on?
Yes.
Okay. And then
if
there
you
are
well, for
seven
instance,
in. Sorry.
then go back. For instance, if you go into the 2019 and other information reports, so there's 3 there, and then go into the 2019, then there's another 1, 2, 3, 4,
Seven.
5, 6, 7. Yeah. So
Okay. There's seven. And you relied on
7,
these reports as well?
yeah, we looked at all of that information.
Okay.
And then if you go back to previous reports, then
So there's. So I guess if you go back into previous reports, you actually get a lot more information. So you get a lot more than 25. I'm sorry.
Yeah.
So these are the 25. When you're trying to direct us to 25 studies and reports, this is the folder you wanted us to look at?
Yes, that appears where everything got put.
Okay. And then when you say 2019 reports cited in the complete report, these are the ones that actually appear in the final study?
It should be, yes.
And are these the ones that you relied on more heavily, and is that why they appear in your final study?
Not necessarily. We were trying to write the report in the context of a summary, and so there's a lot of information we would have considered, but just trying to instead of writing a 500-page report, we wanted to keep it summarized and concise. So we just limited the number of studies that we looked at. We didn't go into in depth of all the studies.
And how did you choose which ones to include in your final study?
Just based on ones we thought would show the most relevance in the sense of major park improvement projects in CBD areas that we could use for comparison purposes to the subject. Then there were another number of other studies that had streetscapes, and then there are other studies that showed that we didn't use or include in here that I think there was Toronto and some other studies that we wouldn't have even included in our backup data that we looked at. So there was a wide variety of information that we looked at.
But it's included in this folder? And in terms of the reports and studies that you're talking about in paragraph 13 of your declaration?
These are, if you clicked each one of those and then went into all the individual reports that are the sub-reports that are within each of those would be the prime amount. That would be the most significant reports we looked at for background that we have for background purposes in our file.
And what is previous reports? And I'll click into it so you can kind of see.
Would have been done previously.
And when you say previously, what do you mean?
Well, what I mean is like for the formation study.
I see. Okay. Do you typically look at underlying methods and data before relying on a study or report to ensure that it is reliable and relevant?
Well, we certainly formulate a good base of information within the Seattle market to have good reliability upon income, sales, a lot of confirmation of that data.
Okay, so is the answer to that, yes, we do look at the methods and data underlying the study or report to make sure it's reliable and relevant?
Well, we look at a broad spectrum because the property has so many different elements to it. We try to look at a broad spectrum of studies that have similarities to the project that we're comparing it to, so that we can cover all the unique aspects, or as much as possible, of the subject market elements in comparison to what's been done in other areas.
Sure, I understand. I think I'm asking a slightly different question. So let's pretend you're looking at one study, you're looking at the HRNA study. Would you typically look at the underlying methods that HRNA used in their data in order to ensure that that one study is reliable and relevant to your analysis? Like, and for each of the studies, would you typically do that?
Well, we would look at what their conclusions are. I mean, HRNA is highly respected and has done studies all over the country, so they have their own methodologies in determining things such as tourism and whatnot. So we would consider how they, and we did consider how they looked at tourism, for instance. That was one of the main components that we looked at for that study. There was a lot of other economic information in there, but we were hired to estimate the difference in value of the property and the impact of the property, the before and after on market value. So the HRNA study had a lot of information on it. You know, the tourism aspect was one of the ones we considered more prevalently in that report than some of the other economic study information they had, although it was helpful.
Ms. Lynn?
And would you
Ms. Lynn?
typically also then,
Ms. Lynn?
yeah,
Question. I think we were a little lax about introducing the last item that you were using that you went off of to make sure that that was preserved for the record. You indicated a exhibit number and then flipped through a bunch of folders on your computer. And we've got it on the visual record, but as far as the transcript describing what you did there, it might be a little problematic. And we've just gone off it, so it doesn't seem like we preserved that well. Did you identify that? Was that a specific exhibit number? Or how do we describe what you just did?
so what I did was I went into Mr. McCauley's declaration, and in paragraph 13, he provided a link to studies that he relied on. I clicked
Okay,
on the link.
So Mr. McCauley's declaration, which is exhibit 122, has a link in it. Okay. And you just gave a page number, or was it a paragraph? 13, did you say?
Paragraph 13.
Okay. And that's where we can find that link to the folders that you were moving through.
Correct.
Okay. Thank you. That should do it.
So you testified that, just summarizing where we were, you will look at underlying methods and data to the extent it's relevant to determine whether a study like HRNA is reliable and relevant to your analysis. Will you also typically make adjustments if the underlying data or analysis differs from the market or the project or the properties you are looking at?
The studies were mainly used for background purposes to see how the market was functioning in the various elements that are attributable to the subject LID. So we would from a background purposes, when we're looking at a property in the Seattle market, we may use that study as background information to help inform us to make adjustments.
Okay, so you did a parcel by parcel approach. How is this background information from each study incorporated into your parcel by parcel approach and your analysis for each parcel?
Well, it's just again, we're looking at the project as an entity of 6 components, and those 6 components have a lot of different attributes to them, as we've mentioned earlier. And these studies have different elements of similarity to different parts of the 6 project elements that we're looking at for the LID project. So we tried to look at as many different studies that showed, for instance, streetscapes.
I understand that. Sorry, I'm gonna, because I think you might have misunderstood my question. So how is the information from each of your studies incorporated into your analysis for each property, given that you did a property by property approach?
Well, again, it's used to inform us. So when we go in and do a parcel by parcel analysis, we have some ground to base decisions on. So there's, we didn't break out each study and try to do a direct comparison with the subject project elements, because no one property was identical to the subject. So that's why we were trying to look at elements, and then within that use the background information to help us better understand how the market's reacting to these types of improvements, changes that are undertaken through the construction of these types of open spaces and streetscapes and things of that nature.
So maybe you could just take me through your analysis for one property, and that would help me understand. How about one of the condos? About how you, let's say you're trying to figure out the before and after value for one of these condo buildings. How are you incorporating information from each of these 25 and more studies into your analysis for that particular condo building?
Well, the studies that would be most indicative of that would be ones that deal with the relationship of residential properties to open space. They provide a range of what they saw in the market for various different elements of open space. And then we also would look at, streetscapes. We have studies there. So we just as we did with any worksheet we did, we would break it down into a range and value in the before, and arrive at a market value conclusion based on the fact the viaduct's gone and Alaska Way is constructed, and do the same mental process in the after and arrive at a market value conclusion.
So the best you can remember, exactly which studies informed your analysis for, let's say, a condo building?
Well, the Crompton study was utilized. There was a local, I think it was Land Conservancy study that was done on parks. There were a number of other studies that were done, proximity studies that were done, involving different areas of the country and park improvements. So there's a pretty good spectrum of information relative to the residential market and its impact on open space and green space and walkways and bike lanes and things of that nature.
And so, and again, the best you can remember, what are the exact studies and reports you relied on to inform your hotel analysis?
Well, again, my scope of services for the hotels was more of a review process. I would remember different studies we put in our market research at the end of our report, that we had studies from CBRE, Kidder Matthews, I think Price Waterhouse, and some others. And again, relying on Mr. Lucan's background and knowledge in doing hotel valuations.
Would you have also considered HRNA, which estimates an increase in tourism?
Well, that's something we looked at just to see if these types of projects increase demand for tourism, and that's something we considered in our analysis.
And your final study cites.
And I would also like to say, I mean, that also affects the retail market as well as the hotel market, and so it's not just specific to the hotel market.
Understood. And your final study not only cites to the HRNA report, but it has a short summary of it. Is that correct?
I believe in the context of our report.
Okay.
Yeah, we have HRNA study on our background information that people could review. And I believe we do have a summary of it in the context of the report.
And correct that you relied on this report to estimate the economic impact of projected increased tourism as a result of the LID improvements?
It was one of the elements we considered, yes.
And this is in your final study at page 45, which is C17. But for ease of for those of you who want to follow along in the final study, but I'll just summarize. You write that the HRNA study estimates that there are currently 8 million annual visitors to the existing waterfront, and concludes that the waterfront improvements will potentially add 1.5 million net new visitors, generating an estimated 191 million in new annual visitor spending. Is that right?
That
Does it
sounds,
sound correct?
yeah.
Okay.
Yes. Yes.
I think you already went over this, but the HRNA study is not just analyzing the lid improvements, it's analyzing all the waterfront projects. Is that right?
Yeah, it analyzes some elements that are not in the LID. I think it includes Pier 62 and 63 and the aquarium. The aquarium would be there both in the before and after. There's some elements that Columbia Street, I think Seneca, and some other improvements that it does include that are outside the LID. And then like the Coleman Dock, the DOT jurisdiction elements of the project, it excludes. So it covers most of the main components, and then it covers most of the main components in the LID, but also includes a few others that aren't.
Okay. And is there any analysis in the HRNA study of visitors who are coming to Seattle for reasons other than to visit the waterfront lit amenities?
Oh, sure. I think they're looking at a capture rate of about 1.5 million people that they can attribute to the elements of the LID or close proximity to the elements of the LID that are within that visitor group.
And so it's your understanding that 1.5 million people per year are going to visit Seattle for the sole purpose of visiting the waterfront lit amenities? For the primary purpose of visiting the waterfront lit amenities?
That's their estimate. Yeah, that is their estimate. Yes.
Sorry, you cut up a little bit there. Are you saying that's their estimate? Yes.
Yeah, Ms. Lynn, I just got a. Can you hear me? I got my connection. Hey, Mark, something's.
Yeah.
We'll hold for just a
Can
minute
you
while Mr. McCauley gets reconnected. We'll hold until you get reconnected.
I'm all plugged in and everything. I don't know what else I could.
Okay, Mr. McCauley, let's go ahead and
Yes.
repeat your answer. This is part of the process of being in a remote hearing sometimes. Repeat your answer to the question, please.
Yeah, no problem. If Ms. Lynn could please repeat the question, that'd be great.
Sure. So it's your understanding that HRNA is estimating 1.5 million new net visitors to Seattle annually, and those visitors are coming primarily to visit the waterfront lit amenities?
No, she cut out again.
Okay, Ms. Lynn, repeat the question. We'll take a break if we're not able to get McCauley back, but his connectivity is going between poor and medium, so he's not completely out yet. Ms. Lynn, if you can repeat the question one more time, and Mr. McCauley, try to capture the question so that we don't have to have her. She's repeated it several times, and you had it at one point, you gave an answer, now she's repeating it again. So we don't want to keep this ball rolling down the field. Repeat the
Mr.
question.
McCauley, can you hear me?
Yes.
Okay. So it's your understanding that the HRNA study estimates that 1 million new net visitors will come to Seattle primarily to visit the waterfront lit amenities?
They estimate 1.5 million in their 2019 study, I believe.
Did you use this information at all to inform your special benefit increases in the spreadsheets?
Yes, it showed that most likely there'll be an increase in supply for hotel rooms, increased tourism for retail. And, you know, and it was consistent with other studies we looked at Boston, New York, and so forth. That projects like this create an additional tourism flow.
Okay, and did you use this information to help you determine residential condo assessments?
This information would have been primarily for looking at properties that are property types that rely more heavily on tourism, such as hotels, retail. If a condo had a retail component to it, it would have been more relevant to that.
Okay, we're going to look really quickly at Exhibit 123, which is the 2019 HRNA report. And if you'd like, I can just, would you like me to share screen again?
Sure, if it's easy for you to do.
Sure. So this is this the study that you relied on?
Yeah, I can't see the far right, but if it's the 2019 study, it would be the correct study.
Okay. And do you know if there's an underlying report other than this summary PowerPoint?
That is what I have reviewed.
Okay. Let's go to slide 83. So HRNA estimates that the total visitors to Seattle as a result of all the waterfront projects base is 8 million. And this is a straight average from data from these large iconic parks in cities like San Francisco, New York, Chicago, Boston. Is that right?
Yes.
Okay. And then the next slide is slide 84. It says HRNA then estimated the share of regional versus out-of-town visitors and how much time these visitors might spend in the park. And then it has a note at the bottom. It says the distribution of visitors, percentage regional versus tourist, is based on comps from Highline and Hudson River Park. Do you know where Highline and Hudson River Park are?
Yes, they're in New York.
And is there any indication that the tourism market in Seattle is similar to New York City?
Well, I talked to Olivia Moss, who's with HRNA, about the study and about how they came up with the capture rate of the 1.5 million visitors, and they said it was the amount of visitors was based on numerous cities, more so than what's shown there, and then the capture rate of 27% was based on which is, I think, that Longwood tourism study that was done in 2016. So they compared tourism to a variety of other cities. From what she said, more so than just New York. It would have been, I think, back to the other slide you looked at, it would have been other wide variety of similar parks that have been done, Boston, New York, Chicago, Toronto, and parks of that nature that they would have applied it to the amount of tourism. She said they didn't, they looked at other it was similar to what we did. They looked at other similar park projects and compared them to the Waterfront Seattle project and made an estimate based on that of the 1.5 million visitors.
Understood. So this distribution of percentage regional versus tourist, that's based on parks from outside of Seattle, but the distribution of day visitors versus overnight is based on local data, this Longwood tourism study. Is that right?
Yes.
Okay. Let's turn to Exhibit 124. I'll just go ahead and So this is a study called The Economic Benefits of Seattle's Park and Recreation System, done by the Trust for Public Land. Um, have you ever seen this before?
Yes, it's in our background information.
And so did you consider this study?
Yes, I just mentioned that I did in looking at the residential market, the condo market. We looked at that, Crompton's report. There were a number of other studies that were in our background information that covered a broad spectrum of other similar projects that we used.
Why was the HRNA study summarized and cited in your final study, but this one wasn't?
Well, again, we're trying to summarize what we did, and the relative to the residential market, we thought the Crompton study was more relevant, more highly used in the market. So even though this is in Seattle, we didn't put it in the report, but we had it in our background information. So it's something we considered.
Okay. So let's go to page 3, which is really page 5 of the PDF. Are you aware that Trust for Public Land, so let's just call it TPL, are you aware that TPL's estimate of the economic impact of the whole park system on the Seattle economy is $30 million?
Well, I believe that was in 2011.
Correct. Okay. So you're aware of that?
Well, that's their estimate in 2011.
Okay. And HRNA estimates $191 million impact due to increased tourism solely from the waterfront lid components. Is that correct? In
Again,
2019
that's
dollars?
their estimate. That's their estimate, comparing it to other projects that have similar amenities to the Seattle Waterfront project.
And did that strike you as a little odd that HRNA is estimating impact from increased tourism due only to the lid components that is 6 times greater than impact on tourism from all of the existing parks in Seattle?
Well, again, I mean, like you're comparing a 2019 study where the relevance and the background of of each study may vary a bit, and you're looking at how vastly the market's changed over that period of time. We were more concerned looking at the HRNA study. It's just the amount of tourism it would create just from a demand standpoint. Recognizing that it is an estimate, and it's subject to variations. It's like something we do. It's an estimate. It's not an exact science. So we recognize that as far as our thought process goes when we're comparing it to the Seattle market.
Sure. And I understand that this is a 2011 study, but did you try to make any adjustments to HRNA's estimate of 191 million, which is based largely on data from cities like New York, to take into account this data, which is showing in 2011 a 30 million net income from tourist spending from all existing parks in Seattle specifically?
Well, as I said, we recognized it's an estimate. It included elements it included project elements that aren't part of the LID as well. So we recognize that and recognize it is an estimate, and it's drawing from other different larger markets and some smaller markets. So in the context of that, we didn't do a specific adjustment, but we recognize that the relevance that it's subject to the variance.
Okay, let's look at page 9. So this is page 9 of the TPL study. Are you aware that, so it says, we determined that approximately 3.44% of King County tourists visit Seattle primarily because of the city parks, and this is a broad group that includes suburban day visitors to the Filipino festival, an overnight traveler to the Hemp Fest, family traveling. It seems like even a bike on Gilman Trail. Are you aware that that 55% figure? So recall that in HRNA study, they projected 55% of visitors would visit primarily because of the waterfront lid. Um, the 55% is vastly different from this 3.44%. And do you have any idea for the reason for this difference?
No, other than they're two separate studies, one done in 2019 and the other done in 2011 under different market conditions. So I don't know other than that why there's that big a difference.
And how do these two studies inform your analysis, given that they're coming up with pretty different conclusions, and given that they're based on uh, different types of data, one of them being primarily local and one of them being primarily national?
Well, again, I mean, the 2011 study we're looking at here was used primarily for the condominium market. I think they reflect about a 4% increase in residential property values that are within 500 feet of the park amenities, and then they go out 2,000 feet. So it was somewhat similar to what Dr. Crompton was saying. And that's the reason why we included his study and not this in the report and used this as background, is that his was much more detailed and more widely accepted in the market than this local study.
Okay, why don't we turn to Crompton's to discuss Crompton's study then? So you've testified that you relied on his research for background. Um, did you
Yeah,
use
just as we did this report.
Sure. And did you use the information from Crompton's report to inform your special benefit increases in the spreadsheets?
Yeah, again, it was used as a tool to reflect how the market was reacting to park amenities, park-like amenities that were prevalent throughout the LID improvements. So it was a good source of information in that respect.
And you've also mentioned that you use this study to inform your residential condo analysis.
Yeah, it was used as background information to see the range of impact that Dr. Crompton was seeing in the market. So it wasn't the only source we used, but it again, we try to bracket our benefit estimates based on studies that are out there to review, and our knowledge of the market and the data we've collected in the local market, which is a significant amount of data we've collected for the local market relative to condos, apartments, retail, office buildings, you know, the unique aspects of the market, the historic properties. So we have a large abundance of research for the Seattle market as well.
And just focusing a little bit more on Crompton's research, your declaration explains that it would have been inappropriate to rely solely on his study because the lit improvements contain a mix of parks and streetscape amenities and include both commercial and residential properties. Is that right?
Yes.
Okay. I'm going to pull up Exhibit 102, which is your deposition. And this will be really quick. I'm going to navigate to page 179. And it says, I'm asked, we're talking about park-like improvements. And so you're saying Pike Pine, they're more like streetscape amenities. Without Pier 58, and I ask, without Pier 58, are the waterfront lit improvements more accurately characterized as street beautification? And the answer is, well, I think Pier 58, the promenade, the overlook walk, would combine into park-like amenities, then would Pioneer Square and Pike Pine corridor. And I said, it's those three together? Yes, they would be the main park-like components that we considered. So then I asked, so when you're drawing boundaries around a park, those are the core park elements that you're thinking of, correct?
Well, yeah, Ms. Lynn, we're looking at the project as one entity. So, you know, park-like amenities are part of it. Streetscapes are part of it. You know, the Overlook Walk is such a unique amenity. It's hard to put it into, you know, a certain category. So I think I was just trying to describe the, you know, the general differences in the market, and that's why we looked at a number of different studies that had various elements of the market attributes.
Do you agree with your testimony that the more park-like elements of this lid are Overlook Walk, Promenade, and Pier 58?
Yeah, I think they're more park-like than, say, the streetscapes on the Pike Pine Corridor or Pioneer Square.
And are you aware of the difference between parkways, and greenways?
Well, I think it just gets into semantics when you're looking at this. You know, that's why we use it for background information. We don't get into the minutia of looking at it as one giant park, or you know, it has unique market elements that you know, are difficult to quantify, like in a word. But that's why we looked at other different studies in different areas that have different amenities. Like we looked at Dr. Crompton's studies that show the relationship primarily to the residential market on how parks are impacting market value. The Land Conservancy 2011 study shows a similar reaction. So, you know, again, it's looking at a broad spectrum of elements, and not trying to just say this is a giant park or a parkway or.
Sure.
Yeah.
So I understand that the semantics can be different, but are you aware that research treats parks, parkways, and greenways different for the purposes of valuing property value increases that are proximate to these three different types of amenities?
Well, the studies. That's why the studies are used as background information, because they have elements of similarity to the subject project.
And you testify that you are looking at all three components together as a whole when you're analyzing special benefits?
Well, I think if for instance, if you look at the operations of the management agreement that was reached, I think they even used the phrase that all of the 6 components are treated as a park or park amenities, which, you know, I think differs from the market. But you know, again, that's why we're trying to utilize different studies that have similarities to the subject to use for background information to draw comparison to our analysis and our conclusions of value.
Okay, so I'll just ask my question again because I'm not sure that I got a response. All of the components are valued together as one for purposes of your special benefit analysis. And so my question to you is, do you disagree with Dr. Crompton's testimony that looking at these all together as one, as you did, this is more like a parkway?
Well, we used his information for background information, so I don't how he wants to paraphrase something or look at something. He didn't do the study I did. So
I'm asking, do you disagree with his conclusion that
well,
the components together are more
I don't
like a
agree.
parkway?
I don't agree or disagree. I just say we used his study for background information as best we could to see the relative differences as one component of the LID improvements.
When calculating distances using the maps that your GIS experts provided to you, did you measure as the crow flies or via travel routes?
Well, we looked at it both ways on a block basis, just on a distance basis. A lot of the studies, they had a lot of difference in block length and things of that nature. So the impact of the area also was looked at on a physical basis, as I mentioned, looking at Denny Way, I-5, 4th Avenue, the Safeco Field area, the Waterfront area. So there were a number of different elements that went into that.
So when you say we looked at it both ways, in what situations were you looking at it as the crow flies versus via road distance?
Well, it's not necessarily as the crow flies. It's just that some of the when you look at other studies, the blocks are difference in length. They're variance that way. So, if you due to the unique configuration of the LID, we just used our judgment as we got further and further away to where we felt the special benefit wouldn't be measurable anymore, and where it would be more general in nature, and that's where we drew our boundary.
I understand that blocks can vary in distance, um, but I guess I'm asking, in what situations are you looking at distance via a travel route, like a road route from one point to another, versus in a straight line from one point to another? Because you said you looked at distance in both ways, and I'm just wondering.
Well, some of the studies dealt more in distance, and some dealt more, or some of the studies we looked at were more block orientated. So there was no precise study that had this exact distance that we felt the project elements would we could go and say, aha, this is an exact distance or an exact number of blocks from this that says this is where your boundary is. So again, we use the studies for background information, and then using our own judgment, we do a parcel by parcel analysis until we get to a point where we feel, the special benefit stops and the benefit is more general in nature. Yeah, LID boundaries like this are challenging. They're based on judgment. If we're doing a utility LID, the boundaries are quite easy because it's typically just where the utility services can service. So you have a very easy boundary when you have a challenging project like this, or like a road improvement project that's benefiting a large area. The LID boundaries are more challenging to estimate.
What exact research did you rely on regarding streetscape improvements and their impact on property value?
There were a number of studies done. New York had a number of examples where I think they looked at 5 or 6 different areas of the city where they did street softening and sidewalk enhancement and things of that nature.
Are you talking about the New York DOT study that's cited in your final report?
Well, I don't know if it was, I can't remember if it was cited in the report or if it was just used for background information. And there were other studies that talked about that element, as I recall, that are in the background, in our background information on the website.
Do you recall whether that research indicated that property value increases are greater or less as a result of proximity to streetscape improvements as opposed to parks?
Well, as I recall, that a lot of I think it was the New York study, and again, it's been a number of months since I've looked at that study. I think they related it more to retail sales activity and things of that nature to show that there were positive attributes to it. There could have been other market value examples. It's been a long time since I've read through all that, but I know there were a number of studies like that we looked at.
Did your analysis differ depending on whether a project component was a streetscape or a park improvement? For example, is a block from the promenade different from a block from the Pike Pine improvements?
Again, it's looking at the project as one entity, and if a property was situated, say closer to the Overlook Walk and the promenade, it would most likely have a higher benefit than, well, it would have a higher benefit than one at 8th and Blanchard or 7th and Lenora that is further removed. So it just depended on the specific location of the property and how the market would react before and after the elements of the LID on the property's property value.
What research specifically did you rely on in order to extend the lid boundary Actually, I'm not even going to ask that. You testified that you took into account the potential loss of the view amenity in the after condition, for example, due to a large influx of trees at the ground level for condos. Um, but in your testimony on direct, you noted that there were also a fair amount of trees already in the before condition. Do you recall that testimony?
Yes, I mean, it would just depend on where you are. If you go back to your visual aids that you used when we first started, you know, there's still trees in the before, and there are more trees in the after. If you're along the promenade area, it would just depend on where you're at.
And did you make any calculation or judgment that the addition of trees in the after was a larger disamenity than in the before condition, or did you consider them to be roughly equivalent?
You know, as best we could, we recognize. I mean, there's some aesthetic enhancement. There's probably a little, depending on where you're at. There's probably a little, you know, more blockage, but it would just be depending on the property and where it was located. There were, you know, there's a variety of other elements we're looking at, so it wasn't necessarily just isolated. It just, when we're reconciling the value of a property, you kind of go through the considerations that you looked at from the before and the after. So issues like that, issues like parking, the before parking, and then the after, if there's parking loss, you know, that's just, again, it's looked at on a parcel by parcel basis, and we're reconciling our conclusions like we've shown in other worksheets that we've looked at. It's part of our thought process. Okay, how is the market going to react to this? Or, you know, we are losing some parking. You're gaining a lot of pedestrian connect corridor activity, increase in tourism. Depending on where you're at, you might have good proximity to the Overlook Walk and the really unique amenities that's gonna create in the market. So those are the types of considerations we just used on a parcel by parcel basis. And typically the things such as trees, parking, and those types of elements were just considered in our reconciliation process.
And so if you're doing, if you are assessing, or if you're analyzing parking loss, for example, on a parcel by parcel basis, where is that analysis in your spreadsheets?
Yeah, we didn't do a separate parking analysis. As I said.
But you analyze it on a parcel by parcel basis, is what you said?
Correct.
So I'd like to know, where can I see the parcel by parcel analysis of parking?
Well, as I said, we didn't do a separate parking study. We analyzed the impact on parking if it was relevant, or the impact on parking loss if it was relevant.
And where can I see that analysis?
Well, it would just be within the reconciliation of our conclusions in the before and after on a particular worksheet. So that.
And where can I see that?
We didn't do a particular parking study to say that, and there's $1,000 lost to parking or whatever. We didn't break parking out as a separate element. In the before, some of those properties would have had parking. In the after, they didn't, but they had a beautiful promenade. They had walkways. They had greater trees and desirability in the market. And so just reconciling the before and the after, we just made decisions. We were kind of, yeah, there's some parking loss. That's a detriment. Well, they have an increase in tourism. They have an increase in aesthetic appeal. How does that interrelate? And so those kinds of thought processes just go into our judgment on our parcel by parcel basis.
Sure. So, but there's no way for me or anyone else to know what that parking analysis looked like on a parcel by parcel basis.
Well, you wouldn't, because we didn't do it. We didn't do a separate parking study. So
we did analyze. I'm saying you have analyzed it on a parcel by parcel basis, but there's no way for me to see that.
Well, you can see it in the context of the amount of benefit we came up with. I think if there was no parking loss, a lot of the Pier 55, 56, the Ivers area, they probably would have had a higher benefit amount, but we didn't specifically itemize that difference out. It was done more through our reconciliation process.
So Dr. Crompton also talks about the diminishing value of additional units of benefit from a park if you've already got a waterfront. in existence. Did you review that portion of his study?
Well, he went through some discussions of the viaduct and diminishing returns or whatever. I mean, I read through it. I disagree that there wouldn't be any benefit, or it would overshadow any benefit. I think one of the things we've gone at great length to try to be real clear about and honest about and reflect in the market is in the before condition, you do have a viable waterfront. And in the before condition, we're recognizing the viaduct has been removed. And so to a large degree, that's why you don't see these big, huge 10, 15% increases in value, because they just wouldn't be relevant just due to the difference in what's being done between the before and the after. So we try to be very, very careful and really try to relate that in our report to the reader to let them know that, yes, there is a viable waterfront in the before, but you really have a unique, compelling, aesthetic waterfront in the after, and the market will react to that.
Let's switch topics a little bit and talk about the maintenance ordinance, which you've testified to a couple times. You testified that you considered this ordinance when determining special benefits for properties in the LID. And so I'm wondering, what increase in value was attributable to this relative improvement in sanitation and control of crime and homelessness?
Well, I don't think we said that I considered it. I considered it, I think, in the context of that it showed approval for the for the LID and the formation of the LID, and it showed market acceptance of what we did in the formation study was accepted in the market. And you had a large number of property owners that had their preliminary assessment, and they were making an investment decision based on our figures, whether or not they thought the waterfront would increase their property or their value to that extent. And a large percentage of them agreed that it would, and then they reached an agreement with the city on the operation and maintenance of the waterfront.
So you did rely on this ordinance when determining whether or not the park improvements would provide positive value increase to nearby properties.
That reflected the market's perception that the project formation, the before and after values were relevant, that they were being accepted in the market. So it was just something we looked at that a number of property owners agreed, but one of the elements that was there when we were doing the formation was this issue of operation and maintenance of the park. So that led to your next question, so I'm sorry.
Sure, I'll just read out loud. Your paragraph 24 of your declaration says, park improvements with significant investment in operations and maintenance provide a positive value increase to nearby property. Then you have a sentence about Tom McCall Waterfront Park, and you end that paragraph with, in my professional opinion, it was reasonable to rely on the city's assurances that it would appropriately fund and maintain the waterfront LID improvements. So my question is, did this maintenance ordinance help inform your conclusion that the park improvements would provide a positive value increase to the nearby property?
Yes, I think any well-informed, knowledgeable purchaser of property, if they were looking at the before condition when the elements would be more of a transportation corridor versus how it's spelled out in the agreement in the after, where there would be a lot of management and upkeep of the park and more authority to control various elements of security and things of that nature in the park that I think a typical well-informed buyer or seller would consider that a positive amenity.
So did this go into, did this help inform your special benefit increases in the spreadsheets?
It was a consideration that we considered, again, when we're looking at the difference between the before and after values.
And let's stop there and take a break. We'll take a short break till 3:10. I'm back in 10 minutes at 3:10. Thank you. Return to the record. Before you start, Ms. Lynn, I just want to get us caught up on exhibits. In my notes, had you down for 120, 121, 22, 23, and 24. Were there other exhibits that we were going to admit at this time?
I believe that is it. Yes, thank you.
Any objection to exhibits 120, 21, 22, 23, or 24?
No.
Exhibits 120 to 124 are admitted. I also want to check with you all on timing. I trimmed a little bit off our last schedule. I think we're proceeding well within what you've all laid out for yourselves and what your needs are, but I want to try to meet that with making sure that you have the time you need, and check to see if there is any problem for parties to participate through 5:15 today. We can add another 15 minutes to the end of our regular day. I've spoken with my legal assistant. We can stay a bit later. We can also convene earlier tomorrow at 8:30 a.m. That's right, Thursday. I keep thinking we're been hearing all weekend. First, for this evening, is there any objection or a problem for a party if we stay convened to continue through 5:15 p.m.? All right, hearing none, we will continue from this break through 5:15 to pick up some extra time. And is there any objection or complication for a party if we start at 8:30 a.m. tomorrow, Thursday, instead of 9 a.m. as scheduled? All right, thank you then. We will start our hearing at 8:30 a.m. on Thursday, the 25th. Thank you. Ms. Lynn, please proceed.
So I just have a couple more questions about this maintenance ordinance. So you did not adjust the special benefit amounts to account for the risks associated with disamenities such as crime, homelessness, and unsanitary conditions. Is that right?
Well, again, I mean, in the before condition, those elements are prevalent. In the after condition, there's a maintenance agreement which helps in that element, so that in reconciling our values, that's an amenity that we would have considered in the after condition that would be prevalent in the marketplace.
What exactly does this maintenance ordinance add in terms of the city's obligations to maintain safety and crime and homelessness and unsanitary conditions? What does it add on top of the city's obligations that already exist in the before condition?
Well, as I've seen in other market areas such as Portland that has a good management program, it's just more of a positive market perception in the real estate market and the investment of real estate.
And did your appraisal quantify the risk that the parks will not in fact be maintained as promised?
Well, we based them based on that our after condition when we were reconciling based them on the operations and maintenance agreement.
Okay. Let's switch topics a little bit. So the final study is intended to comply with mass appraisal standards. Is that right?
That's correct.
And the purpose of compliance with USPAP is to ensure credible results and that the users of the appraisal report, and so that users of the appraisal report have confidence in the results presented. Is that right?
Well, yes. I mean, and it's also done under state statutes that a parcel by parcel analysis is done so that you can create a spreadsheet that shows what your valuation conclusions are before and after, and what that value difference is reflecting the special benefit.
And you testified that USPAP is published by the Appraisal Institute. In fact, it's published by the Appraisal Foundation. Is that right?
Yeah. Yes.
And you previously, you talked about these individual worksheets and the the individual worksheets. Let's talk about those. You previously claimed that those were proprietary and confidential. Is that right?
Well, when we first started, there was some concern there, and then I decided just it was fine to just let them be in the record.
And so they were not part of your final study. Is that right?
The worksheets,
Correct.
yes, they're part of our backup data that summarizes our value conclusions.
But they are not actually part of the physical document that is called the final study and that was provided to property owners initially.
No, we don't. We just summarize our conclusions within the format of a spreadsheet.
I'm sorry, I'm going to ask that one more time. So the spreadsheets are not part of your final study, correct?
They're not included in the report. No.
Okay. And how would a reader of your final report have known that these spreadsheets were prepared?
Well, I think we mentioned in the report that that individual spreadsheets are prepared on each property, and the supporting documentation is retained in our files.
Do you know where in your final report that is?
I don't, but I know we talk about the retention of all of our background supporting information in our files. That would be in the transmittal letter, I believe.
Your transmittal letter does talk about the 2 lengthy spreadsheets that are included as part of your final study.
But it also should talk about that the supporting documentation is retained in our files.
Okay, and so this reference to supporting documentation is how a reader would know that you had also prepared individual worksheets?
Yes.
Okay.
And again, I thought we said that in the context of the report that we may not have. I can't remember.
I don't think you did, but we'll figure that out later. Are you aware that on April 14th, 2020, the hearing examiner questioned the city's attorney regarding your claim of confidentiality?
I don't recall that. Again, we ended up putting the worksheets into the record.
And that was the following day on April 15th, the city withdrew its claim of confidentiality, is that right?
I don't know the exact dates, but
Did you ever have a conversation with the city's attorney about withdrawing your claim of confidentiality?
Yes.
Yeah, I'll object to the extent that we're getting into attorney-client privilege issues, but I suppose I'll see what the question is.
Okay, I'll actually back up a little bit. I'm going to read from the April 14th hearing transcript, and this is hearing examiner Vansel speaking. He says, but as objectors point out, it's the appraiser's process is what's in question. And so if he's obscuring that process without any clear reason, that in and itself can speak to the validity of the process. Do you agree that it is your process that is at issue here?
Well, again, I mean, we put the worksheets into the record, so any relevance to that is gone. They're in the record.
I understand that. My question is, do you agree that it is your process that is at issue here?
Well, the process of the worksheets not being put into the record was, from I understand, the question, and then they were put into the record.
Correct. I'm actually asking more about your mass appraisal process. Do you agree that it is your mass appraisal process that produced the final report that is at issue here?
I don't know. I can't read the hearing examiner's mind. My understanding of the issue is to whether or not to put the worksheets into the record, and we decided to do that.
Oh, so we're leaving the worksheets aside right now and talking about something different. So apologies if the topic change was too abrupt for you. I'm now just talking about your mass appraisal methods. And I would like to know whether you agree that it is your mass appraisal methods that are being discussed here in this hearing. I think the obvious seems like that's a straightforward question.
The report that I prepared is a mass appraisal report. So that would be, if you're talking about my report, that would be what we're talking about.
And it's not the process of the objectors experts that's at issue, is that right? Because as you point out, objectors appraisal experts are not the ones performing the special benefit study here. Is that right?
I'm the one that performed the special benefits study, correct?
Okay. Do you still maintain your methodology is in fact proprietary?
Well, I think that we have some unique analysis aspects that back when we first got into this, that we were a little concerned that would be sent out onto the internet and that they'd be exposed to a lot broader spectrum of users than just those that specifically should have it, because they're providing evidence rebutting what we're trying to refute what we said. So we had some concerns in that regard, and then we just let them go and decided to put them into the record.
And has your methodology ever been subject to peer review?
Oh, certainly.
Let's turn to Randall Scott's report, which you've testified about. Are you familiar with Randall Scott's report and testimony regarding USPAP standards 5 and 6?
Yes.
And are you familiar with who Randall Scott is?
No, other than what I've seen of his appraisal review.
Let's pull up Exhibit C24, which is Standard 5. And if you'd like, you want me just to share screen again?
Please.
Okay. So this is Standard 5. Correct that Standard 5 requires mass appraisals to develop a model structure that conceptualizes the relationship between characteristics that affect value and to calibrate that model to specify how those individual characteristics affect value. And we'll walk through each of these. I'm more just trying to set a stage for what Standard 5 is. So why don't we just actually walk through these? Standard 5 includes a list of 7 items that a mass appraisal should include. So if you look at item 4 says developing a model structure that reflects the relationship among the characteristics affecting value in the market area. So you've testified that your mass appraisal method is a parcel by parcel approach rather than a statistical model. Is that right?
That's just a fact that it is a parcel by parcel analysis.
And wouldn't a parcel by parcel analysis simply be amassing thousands of single property appraisals as opposed to being a mass appraisal?
Well, it's more of the context that it's done in. We're not preparing individual appraisals. We're doing an abbreviated analysis to comply not only with USPAP, but also with state statutes.
But if you're doing a parcel by parcel approach and I understand you're in the context of a mass appraisal, meaning you're doing a lot of these, but if you're doing a parcel by parcel approach, wouldn't that approach require you to be compliant with standards 1 and 2?
We are. We're identifying properties to be appraised. We're defining the market area. I mean, read the report of consistent behavior that applies to properties. We're identifying characteristics, supply and demand. Again, read the report. It's in the addenda or the back of the report, our market data study that affect the creation of value in the market area. We're developing a model structure that reflects the relationship among the characteristics affecting value in the market area. We're calibrating. We're going through and doing intense review and internal review of our model structure, which is the parcel by parcel basis to determine the contribution of the individual characteristics affecting value. We're applying.
So let's just go back to the question. I want to make sure I understand your answer. So you're saying that these appraisals are governed by standards 1 and 2, which govern direct appraisals, and that you are in compliance with standards 1 and 2?
Oh, definitely, yeah. There's a broad range to do a mass appraisal. You could do some statistical analysis, regression analysis, or what we do is totally acceptable by doing a parcel by parcel analysis. We're identifying the properties to be appraised. I don't see how you could say we aren't. We're defining the market area of consistent behavior that applies to properties. We're doing an income approach, a cost approach, or a direct sales approach where it's applicable. So yeah, we're certainly complying with 1 and 2.
And so for each residential condo unit, can you point to where I can see your compliance with standards 1 and 2?
Well, they're again, we're identifying the property. If you look at the spreadsheet, we're identifying the properties to be appraised. They're all in the Excel spreadsheet. We're defining the market area of consistent behavior that applies to properties. So again, just going through the spreadsheet, that information's there. All of the backup information that we have relevant to sales is within the backup data that we have for the project. So we have sufficient information where if we're required, we can prepare individual appraisals of each condominium property if we were required to do so.
You've testified previously that a direct appraisal would not have been economically feasible for this mass appraisal, and you're testifying now that in fact your parcel by parcel approach did comply with standards 1 and 2, which govern direct appraisals. How is that consistent?
Well, with condominiums, we just didn't prepare worksheets. I mean, we just summarized them just due to the mass amount of 5,000 some condominiums and the commonality of a lot of those properties. We just didn't prepare individual worksheets for those properties like we did with the more complex commercial properties. But we have everything we need in our backup data to comply with USPAP and to meet these requirements.
And so is in fact your approach and a mass of direct appraisals sorry, let me back up. Is in fact your parcel by parcel approach and a mass of direct appraisals?
Say that again.
So is your parcel by parcel approach really just a lot of direct appraisals?
Well, it's a mass appraisal, and it utilizes limited techniques such as Gordon uses in doing his limited restricted report. I mean, we're just summarizing our conclusion in a large group of properties, and we're doing it a couple different ways. One, by preparing worksheets on the more complex properties. One, reporting our findings within properties that have more commonality, and we're basing it on market-based acceptable studies such as direct sales comparison approach and the income approach, or the cost approach if it's more of a special purpose property.
So you believe for that every single property in the lid, you've complied with standards 1 and 2?
Yes.
And if I could just subject and ask, are we talking about standards 1 and 2 of USPAP, or this sub 1 and 2 on, up at the top of this page?
We're talking about standards 1 and 2 that govern direct appraisals.
Okay, and are those an exhibit? They're in front of the
They're
witness?
not an exhibit, but I can submit them if you'd like. I think that Mr. McCulley is likely very familiar with standards 1 and 2, as they are the principal governing appraisal standards for direct appraisals.
But I noticed in answering your questions, he's referring to and reading into the record 1 and 2 here underneath standard 5. So I just want to make sure he's understanding the question.
Yes, I thought you were talking about standards. We're talking about mass appraisal. I thought you were talking about standards 1 and 2 that are applicable to standard 5. That's what we were talking about. Now you're saying you're talking about something else?
Okay, so let's back up. I am talking about something else. I'm sorry. Let's back up. I asked you about the parcel approach, and I asked whether or not that is an amass of thousands of single property appraisals, and if so, whether or not these appraisals would be governed by USPAP standards 1 and 2 that govern direct appraisals, and whether or not you are complying with standards 1 and 2 which govern direct appraisals.
We're complying with the standards 5 and 6 governing mass appraisal. And in the context of that, we have to have sufficient information available within the context of that study to prepare individual appraisals of the property, like a limited appraisal, like Mr. Gordon did. So yes, then we would have to comply with the other USPAP standards 1 and 2 you're referring to once we wrote those reports. But our whole compliance for mass appraisal is meeting standards 5 and 6, which we've done.
And so in your parcel by parcel approach, are you required also to comply with USPAP standards 1 and 2 governing direct appraisals?
Well, we have to have sufficient information in our file that enables us to prepare individual reports that would comply with those. If we have to have that, we have to have that level of information in our files that would allow us to prepare individual reports. And we do. So if we were to prepare an individual report, then we would be dealing with USPAP's other aspects. But we're dealing with USPAP standards 5 and 6 and dealing with mass appraisal. And that is a requirement of this, or how we've always looked at it, that we have to have sufficient information in our files to prepare individual appraisal reports. So it's a significant amount of data and backup and supply and demand and all of the factors that go into complying with standards 5 and 6.
Ms.
Okay.
Lynn, I don't
Yes.
know if you plan on coming back to standard 5, but if you're referring to an entirely different standard, it'd be helpful if you took that off the screen, as it is confusing to know whether you're talking about subsections 1 and 2 of standard 5 or standards 1 and 2 as independent USPAP standards.
Okay.
That may be, and I leave it to you whether you want to introduce USPAP 1 and 2 or not. I'd agree that the witness seems familiar with them, but for conversation's sake, if you don't have us all looking at one standard, if you're not referring to it, that might help.
Sure. So is it your testimony that for your parcel by parcel approach, which was your approach for your mass appraisal, meaning instead of doing a statistical method, you did a parcel analysis for each parcel within the lid, that these are governed by standards 1 and 2, and that you are in compliance with standards 1 and 2, and those are the standards governing direct appraisals?
We're in compliance with mass appraisal requirements, which are standards 5 and 6, which govern mass appraisal. And we have to have sufficient information in our files that if we're asked, we can prepare individual appraisal reports that would then satisfy requirements, the other requirements 1 and 2 that you're talking about. Because we're not preparing a complete or even a limited appraisal assignment appraisal. We're complying with mass appraisal. So there's a distinction there.
Okay.
Do you understand my answer?
Sure. So you are in compliance with USPAP standard 5 and 6. And one of those, like you said, one of the criteria is developing a model structure to reflect the relationship between the characteristics affecting value. So can you explain what exactly is driving the percentage increases in your hypothetical before and after scenarios in the spreadsheets and otherwise with the condos?
Well, again, I mean, the same logic applies as it does to the commercial property. We're bracketing the entity that comprises the condo project building and making adjustments based on that. And we're looking at the values within those condos and just saying, well, they're going to relatively, based on the condo's location and its proximity in the market and before and after the improvements, it's reasonable that they would experience when we go through and do the before and after a generally similar or roughly proportioned difference in value. And that's where that percentage comes from. It's the
Sure.
the difference between the before and after value.
And so Randy Scott explained that a model might, for example, say something like land plus building equals value. Do you agree with something like that? Like that might be an example of a model.
USPAP has, I think, a broad spectrum of ways you can do mass appraisals. You could do a statistical analysis. You could set up formulas. I don't know. I don't think he has any experience in doing special benefit studies or complying with state statutes, which we have to, as well as complying with USPAP. So
Sure.
it's a different element than maybe what he's thinking. I don't know.
Sure, but you've got you agree you've got to comply with USPAP standard 5 in addition to case law and statutes, right?
And we do. We
Okay, so
standard
going back to
5 and 6.
criteria 4 and regarding this model structure, basically what criteria 4 is asking you to do is identify factors that are driving property value increases in your analysis.
And
So
that's
that would be
exactly
something
what we
like
do.
tourism or proximity to the park. And so I'm asking you, can you just name the factors that are driving the property value increases and where I would see that in your report?
Well, look, just read the report. I mean, we talk about that, benefits created due to the aesthetic change in the area, the proximity to the elements, the increase in market rent, market vacancy changes, capitalization rate changes, and things of that nature. So that it's spelled out in the report, and then it's summarized on an Excel spreadsheet, and then it's further exemplified for the commercial properties on individual worksheets.
Okay, and so the factors would be something like you said, proximity to the park improvements. That's something that might drive property value increase. And criteria 5 asks you to calibrate that model structure to determine the contribution of these individual characteristics. So for example, you would, for each factor that is creating value, so for example, the proximity, where's your explanation of how much value that factor contributes to the special benefit estimate? So if the factor is increased tourism, where's the explanation of how much value that factor is contributing? If your factor is proximity, where's the explanation of how much value that factor is contributing?
We don't break it out like that, and that doesn't mean we're not complying with USPAP. We don't break out the individual components as they vary. They can vary from parcel to parcel. So we are just looking at the market value of the property based on the definition of market value before and after, and we're doing it for each parcel within how it does. It's better than trying to artificially break out how much tourism, how much proximity is. The market just doesn't function that way, and so we're not trying to do that. We're trying to reflect the market as it functions, and that totally complies with USPAP, and it totally complies with standards 5 and 6. I mean, I've been doing this 30 years. I've done over 120 or something special benefit studies, all under this same methodology. They've got several of them have gone through the court system, and this has been approved by the court. So I don't know how else to answer the question.
Sure, we'll pull up Exhibit 126, which is Advisory Opinion 32. And I'll go ahead and share screen because that seems to be something people like. So are you familiar with advisory opinions generally?
Yes, that's just what they are. They're an advisory opinion.
Okay, and so they're adopted by the Appraisal Foundation, which is the same institute that publishes the USPAP standards, and they explain what the standards mean when specific questions arise. Is that right?
Mm-hmm.
Okay.
Yes.
And so if you scroll down to page 152, there are a few illustrations here with respect to mass appraisal standards. And the first one, or actually let's go to the second one. The second one says, an appraiser has completed, actually I'm gonna make it a little, an appraiser has completed a mass appraisal for ad valorem taxation. I know that's not what we're doing here, but using a mass appraisal model. There is a special use property for which it has been determined that the mass appraisal model is not appropriate. This property will be appraised as an individual property. What development standards apply to the appraisal of the special use property? And then it says in the answer that standard 1 would apply because the subject is an individual property, not a universe of property. So my question to you, is, does that suggest that if you're doing a parcel by parcel approach and you're looking at an individual property and not a universe of property, that standard 1 would apply?
Well, in our instance, I think we're compliant because we're looking at a universe of properties, and we do have some special purpose properties, but they're within what's allowable within the methodologies under standards 5 and 6. Where if you read that, they allow the income approach, the direct sales comparison approach, and the cost approach. And in those instances, we're using the cost approach. So, you know, we're complying with standards 5 and 6 and doing that.
It appears that you should be complying with standard 1 if you're doing an individual property. Is that right?
Well, it's an individual property within the context of many properties. So we're complying with standards 5 and 6 in mass appraisal, and I don't really agree with this advisory opinion in this context, because if you read standards 5 and 6, that it's allowable to use different techniques. So just because it's a special purpose property, I don't see it as being something that would be adverse to being outside the standards 5, the standards 5 and 6 of the mass appraisal.
You mentioned John Gord's restricted appraisals, and you said something like, well, you know, when we do individual ones, we could end up doing a summary, just like John Gordon's restricted appraisals. Let's look at illustration number 3, which says, an assessment appeal is in process and an appraisal of an individual property is being conducted as part of that appeal. Which development standards apply? So that's kind of what's happening here. And it says standard 1 or standard 7 would apply because an individual property is being appraised rather than a universe of properties. So for John Gordon, who's appraising an individual property as opposed to a universe of properties, standard 1 applies. Does this also suggest that anytime that it's not so much about whether or not you're looking at a special use property, it's more about whether you're looking at an individual property as opposed to a universe of property? And that is what determines what standard applies. Is that right?
In my opinion, the special purpose properties, the stadiums and churches, and they're part of the universe of properties we're appraising. So I don't think they need to fall outside of the standards 5 and 6 of the mass appraisal. If I'm doing or asked to do then a limited restricted report on a particular property to rebut, say, John Gordon's reports, then the same standards that John Gordon applied with in doing his limited appraisal assignment, I would need to meet those same standards in doing a limited appraisal report, but I haven't been asked to do that, so I haven't done that.
And so I'm not sure you completely answered my question. It's more that if you're taking a parcel by parcel approach, it means you're looking at each property within the lid separately, and you're not looking at them all together as a universe of properties. So wouldn't that suggest that standard 1 applies?
Well, we're looking at them as a universe of properties in the context of doing a parcel by parcel analysis, because we've got to maintain proportionality. We've got to maintain consistency with how we're valuing one property from the other. So, you know, I disagree with that. We're just using a different technique. We're not using some statistical analysis or regression analysis or something like that. I think the techniques and the methodology and the proportionality relationship that we use and the internal review we use is much better and more accurate than doing some sort of statistical analysis or trying to pull apart various elements that you suggested, such as proximity and things of that nature. So you know, I think our methodology totally complies with the use pack requirements 5 and 6 that we're supposed to comply with.
Illustration 4 says an appraiser is conducting a mass appraisal for ad valorem taxation. I realize this is in the lid context. A property record card is produced for each property. Is each property record card considered a report under standard 6? And the answer is no. The property record card is not the mass appraisal report. It is only a portion of the information and analysis supporting the mass appraisal. So does this suggest that your individual property worksheets are not considered the mass appraisal report?
Well, in the context that we're looking at them, they're considered as one universe of properties that we're doing, and it's in the context of the local improvement district that has been formed. And so the local improvement district has formed a defined area, and we're not doing ad valorem taxation. So you're comparing something from what an assessor would do to something that I'm doing, subject to state statutes and other requirements that aren't, and we're not doing an ad valorem taxation. So, yeah, my worksheets comply with the elements of 5 and 6 as they're a universe of reports that are done that show proportionality amongst the various ownerships within this defined LID boundary that's covered by state statutes.
Is it true that illustration 4 suggests that whatever model structure you have and whatever calibration you have done should appear in the report itself and not in a property record card?
Again, you're looking at something that's dealing with ad valorem taxation. I'm looking at a limited at a local improvement districts that's subject to state statutes. This is an advisory opinion on ad valorem taxation, not an advisory opinion on special benefit studies for local improvement districts.
So is your testimony that this this concept that your compliance with standards 5 and 6 must appear in the actual mass appraisal report, this concept does not apply in the LID context?
All I'm saying is that the methodology that I'm using, that are shown in the Excel worksheets, which summarizes our findings, that are supported by the backup data, that are supported by the worksheets, that show proportionality, cover a universe of properties within a defined legal area, within a defined legal boundary, legal LID boundary. And there are state statutes and case law that apply to the doing appraisals of those properties. And they comply, our analysis complies not only with that, but with USPAP standards 5 and 6 for mass appraisal.
Okay. I think that's all I have for right now. I think my colleague Jerry Lutz, I believe, has called in and has a few questions for you. Jerry, are you on the line?
Yes, I had to unmute myself and now I'll turn my picture on, I hope. And only for a second, because Megan, I'm hoping that you can also share that Excel spreadsheet for everyone.
So I've also got to circulate it to the group.
That's good. I'm sorry.
Which is it spreadsheet for Jerry that you would like me to circulate to the city and the hearing examiner?
Yes, spreadsheet for Jerry in the latest email because it kept getting one typo in it. So it should say 18.54% in line 12, column B. Did you find it?
I'm looking at it. So it should say 18.54%. Is that what it should? That's
Yes, in
okay.
line
Yes,
12,
I have it.
column B. Okay, great. That is it.
All right, I will share screen with this spreadsheet and let Jerry take over.
Thank you.
And just to clarify, this is an item that is not in the pre-shared exhibit list. Is that correct?
Correct.
Okay. And
That
so,
is, yes.
and so you're emailing a copy of it now, and we're all seeing it on share screen.
Yes,
Thank you.
I just emailed it.
Thank you.
And in addition, just to complicate things, Mr. Examiner, I'm going to be using information from a PricewaterhouseCoopers report that requires PricewaterhouseCoopers permission to use as an exhibit or publish, which we're seeking but don't have yet. So I'm fairly confident Mr. McCauley is familiar with it, and I'm going to be reading information from it that is incorporated into this spreadsheet. But we're not in a position yet to file it as an exhibit. We're hoping to get that permission in what I guess would be the ordinary course of seeking that permission from PricewaterhouseCoopers. Mr. McCauley, good afternoon. And I'm going to try and make this brief, but one of your contentions during your testimony is that your special benefit of total of $447,908,000 is so far in excess of the special benefit percentage assessment that are being made against the property owners that there's really a very comfortable margin of error in your analysis. Is that a fair summary of your contention?
No, I'm not saying there's a comfortable margin of error. There's a difference between the $346 million total cost and ultimately what we came up with as the sum of the total benefits attributable to the market value as of October 1, 2019 that we estimated.
Okay. Well, let me ask this a different way. When you've calculated your total special benefit, you've made a number of assumptions and you've attributed them essentially to analysis that would be consistent with eminent domain analysis. And that includes ignoring construction disamenity between October 2019 and when the improvements are delivered in 2024 as one example. A second is you're ignoring permitting risk, construction risk, economic risk, and the last is that you're not required to do any sort of present value analysis. You simply assume that everything is done, up, and finished in October 2019. Is that a fair assessment?
Yes, Mr. Lutz. As I've said many times, that the scope of my services is not to discount anything from that 2024 back to a present value. The scope of my services was to estimate market value of the project in the hypothetical before conditions and the assumptions that the six main elements that comprise the LID improvements were completed as of October 1, 2019. So any discounting from 2024 back to some present value is totally outside the scope of services and the scope of my assignment and wasn't done and wasn't considered.
Okay, well, let me ask you now as a hypothetical. Assume that the law of LIDs requires you, in fact, in this situation, to take all those matters into account. How would you go about doing that?
Well, it doesn't, and I'm not going to speculate on what that would be. It's not something I did. It's not something I've ever done in 30 years of doing an LID, as being asked to value something in the future and net present value it back to the present. You know, think about that. I mean, over 120 LIDs over 30 years. I've never ever been asked to do some sort of look like this whatever it is you've put up here. It's irrelevant to what I did.
Well, I'm asking you as an expert, as a hypothetical, to talk about how your analysis would go about analyzing net present value of improvements to be delivered in 5 years.
Well, again, it's irrelevant to do that in the context of this study, and I've never done it in the course of my career, so I'm not going to speculate on anything like this.
Well, it's not a speculation; it's a hypothetical question for an expert, which I'm allowed to ask you.
Well, okay, ask. I'm not going to answer it because I don't see any relevance to what I did with what you're showing here.
All right, so let's just assume that you're legally incorrect and that this is in fact a requirement of forming and assessing charges for an LID for improvements that have not yet been entitled and will not be delivered for 5 years. Have you ever done an appraisal that did an LID assessment for improvements that are not yet entitled and will not be delivered for 5 years?
The last one we did for the city of Pasco would probably be the most comparable. Again, it's probably going to take them 2 or 3 years to construct that road, and we closed out that LID a year ago. That would be the most similar one I can think of.
And did they have permits?
Again, I can't remember exactly how far along in the process they were.
All right, well, let me ask you a different question. When you are looking at doing a present value analysis independent from an LID for real estate, for something that's not yet built and is not yet entitled, would PricewaterhouseCoopers land valuation reports be a relevant, reliable document that appraisers would typically look to?
I don't know. Just it would depend on what we're doing and whether that information was relevant. There are a lot of other sources that may be looked at as well.
Okay, and are you familiar with a CORPACZ report? I'm probably mispronouncing that. KORPACZ. It's a component of PricewaterhouseCoopers.
Yes, I've heard of it.
Okay. Is that a source of information relied upon by appraisers?
Well, again, I mean, it would just depend on what you're talking about. I mean, what are you appraising?
Okay, I'm going to do a present value analysis of your $447,908,000 project on the assumption that it's not yet built and it will be delivered in September 2024. So first of all, I will read you what the report says about forecast value change. And this is for Q2 2020. So it is in the, there's some COVID information in here, but it says over the next 12 months, surveyed investors hold mixed opinions regarding value trends for national development land market. Their expectations range from -40% to +5%, with an average expected value change of -6.9%. This is far below where it was 6 months ago, parentheses, +2.3%, close parentheses, as well as 1 year ago, +3.2%, close parentheses. So what we've done is used the 6 month ago reported forecast value change and incorporated that in, you'll see, columns B through G, line 7. And as a result of that, using that 2.3%, the $447,908,000 current present benefit escalates to $501,849,980 as of 2024. So it's an increasing amount. The next item is construction impact. So you've assumed you don't have to consider the disamenity of 5 years of construction. We have instead assumed somewhere between 2.5% and 5% a year. So applying your practice of pick a low and a high and pick the middle, that was a construction impact of 3.75% each year for 5 years. Does that seem like a reasonable assumption about construction disamenity if you were required to consider it?
I have no idea, Mr. Lutz. You did this. I didn't. I would never do anything like this. I've never been asked to do anything like this. And all the years I've been doing LIDs, it's an irrelevant exercise as far as I'm concerned.
Okay, so if that turns out to be wrong, your appraisal goes out the window. But let's just continue this.
Mr. Lutz,
Yes.
I just want to check with you. Ms. Lynn was coming forward as the representative for your folks, and usually I don't have multiple attorneys coming in for parties. I wouldn't allow Mr. Lee or Ms. Thompson to step in for the city, for example. Now, Mr. Filippini's doing this witness. So Ms. Lynn had indicated she was going to wrap up about 3:45, 4 o'clock. She did, right on time. I've got a witness who's not really able to answer the questions on items that I can't see. How long amount of time do we anticipate spending with this witness that maybe could be coming in through your own witness by declaration and response? A line of objectors that have a right to get in, and they're ready to go.
Absolutely, Mr. Examiner. I basically had 2 more questions.
All right, let's get through those.
And so what the Cord Pat's report also says is that free and clear discount rates including developers profit range from 10 to 25% and average 5.2% this quarter. This average is 70 basis points lower than 6 months ago. Without entitlements in place, certain investors will increase the discount rate between 100 and 1,500 basis points, an average increase of 338 basis points. So I'm using the lower discount rate of 15.2 rather than 15.9 as a starting point. I'm increasing that by 338, meaning 340 basis points. That results in a discount rate of 18.54%. Would you agree with that math?
I don't agree with anything you're doing here, Mr. Lutz. It has no relevance to what I did and my benefit study.
All right. And so if I apply, would you be surprised that the net present value of the $447,908,000 present value you have calculated with all the assumptions that disamenities, discounts, and risks are assumed away, that the net present value of that $447,908 million benefit using these data from the Corpet's report of PricewaterhouseCoopers is $159,250.942.
And I'll just object, Mr. Hearing Examiner. The questions are incredibly compound and complex, and I'm having a hard time tracking them.
Mr. Lutz,
So
the response to the objection?
I can ask 3 questions.
I mean, I'm in the same mode. I'm not able to follow it because you're reading stuff I can't see. And again, you're asking a whole hypothetical that, again, you could present through one of your responsive witnesses in a declaration that lays it out very nicely, and I could follow you.
And Mr. Examiner, that's fine. This is a demonstrative exhibit, and we will submit it in a responsive declaration.
Any further questions? Ms. Lynn or Mr. Lutz, any further questions?
Mr. Lutz has none and turns it back over to Ms. Lynn.
Thank you. Ms. Lynn, I don't know that your microphone is on, or perhaps you're not speaking. I can't.
Is that better?
It was on, it's just not yet. All right.
So just going to admit exhibits 123, 124, 126, and 132.
Okay. Let's do that. Any objection to exhibits 123? Well, let me ask first, actually, what's the plan for the other exhibits that were not used?
Yeah, I was gonna ask if you have a preference there.
We've had even in my regular land use hearings, it's not uncommon to allow things to come in by explanation of an item. This is a broad open record. I recognize objectors need an opportunity to get in what they want. I don't want a document dump, but we've just got a few documents here. If you believe they're relevant, you'll be referencing them in your cross response documents. You can, for the sake of keeping our record clear with exhibit numbers, I would allow them to be admitted. If you're not going to use them at all, then we just leave a gap in the record. Any objection to that? The city could raise that now and let me know if that's a problem.
Mr. Vansel?
Yes.
This is Vic Moses. In doing our coordination, if one of our objectors was submitting an exhibit, we asked others not to resubmit the same exhibit, so we didn't just flood your office with extra documents to look at.
Great.
And for exhibits that were already in the record, we didn't submit them because we were under the understanding those would be provided. So our understanding was that somebody was going to take our submissions and kind of compile them into a composite list of documents. And so even though Ms. Lynn may not be using one of those documents, it's possible one of the other objectors may be using them. I don't have a list of each document they're using in front of me.
All right, I understand your point, and that's well taken. I think that's helpful. Again, this is about trying to maintain some sense of order and clarity for the arguments you'll be raising and the record. I don't plan on developing a composite list. As we indicated, we're doing a list of exhibits for under each case number, and in the city's case, we'll stick with that. But for the sake of clarity, I think it's behooves us to keep all of the exhibits together that are identified by the objectors that are presented so far for cases 233, et cetera. And so that would be those would be exhibit numbers 123. And Ms. Lynn, if you can remind me the highest number that you have there.
132, which is the Mr. Lutz's exhibit that just came in.
Okay, and we have already admitted 130. So is
Correct.
there any objection to exhibits 123 through 132, accepting 130?
I do object to 132. That was a spreadsheet we were just going through. I don't believe a foundation was laid adequate to admit it at this point. The witness had never seen it before, didn't know what it was, and there were quotes coming in and describing it from a source that we haven't seen and may not be able to see. So I would object to admitting 132.
Okay, accepting 132, exhibits 123 through 129, and 131 are admitted. 132, is there, Ms. Lynn, did you want to make a response, or Mr. Lutz, before I rule on the objection?
This is Jerry, Mr. Examiner. As I said, when I ended the testimony, we will anticipate introducing it through a declaration of an expert, and at this point, just consider it demonstrative. Okay,
we will. I don't need to rule on it then. It was like everything that we've put on the screen so far. It's been purely illustrative. They're not the objectors are not seeking to admit it, and therefore there's no need to make a ruling. Thank you very much. Anything further from the group of cases represented by Perkins Coie, 233, et cetera?
Nothing further from me. Thank you.
Thank you very much. Appreciate getting to this point. Our next objector is Scott Edwards. Mr. Edwards, I believe you're ready to go with your questions for Mr. McCulley.
Yes, I am. This is Scott Edwards from Lane Powell, representing the objector CWF 0314. So I'm planning on starting with the city's exhibit C17, which is the final report. Would it be beneficial? I probably got about 10 pages within there that I want to focus on. I can share my screen if that would be more convenient for people.
Yes, thank you for asking, Mr. Edwards. I think it seems to be working well for us to do share screen. We haven't crashed our system yet. I've been told by my legal assistant it doesn't foul anything up for us on the recording end. So I'm going to trepidatiously allow the screen sharing as much as we can because it does seem to facilitate things.
Okay, well, let's hopefully is everybody able to see my screen now?
Not yet.
Not yet. Okay, I clearly am not very competent on this then. Well, I guess I have to hit the share button.
There you go.
Yeah, okay. So this is, as I had mentioned, Exhibit C17 introduced by the city. You'll see that they're numbering over there. Actually intend to start on page 3 of that document. The highlighted portion makes reference, and this is describing the before without lid existing situation. It says, there is poor connectivity between the Puget Sound shoreline / Alaska Way vicinity and the higher elevation city streets, Western Avenue, due to topography, historical street layout, and other issues. Do you see that, Mr. McCauley?
Yes.
What is the elevation differential between Alaska Way and Western Avenue?
Yeah, I think there we're just referring to, and trying to get through the Pike Place Market area, very steep inclines and stairs that and difficulty, the connectivity difficulty getting through Pike Place Market area. That will vastly improve with such amenities like the Overlook Walk and Union Street connection and things of that nature.
So, what is the actual elevation gain between Alaskan Way and Western Avenue?
I don't know the exact elevation change.
And the reference due to topography, that's referring to the steep grade between those two streets as you move east from the water?
Yes.
The historical street layout, what is that referring to?
Just the way the streets are currently situated. Just a comment on it.
Is there going to be a change to how the streets are situated?
No, I think we're mainly referring to here is the connectivity improvement that will occur.
Well, this is describing the before condition and the poor connectivity due to, and you've got two things specifically laid out, and then the last item says and other issues. What are some of the other issues affecting poor connectivity between Alaskan Way and Western Avenue?
Yeah, I don't recall specifically what we're talking about there. Could deal with poor lighting that is difficult to get around at night or things of that nature. I don't recall specifically what we're talking about there.
Okay, and then the following sentence is the one describing the after condition. It says, with the lid project completed, accessibility to the waterfront from nearby areas, including the Pike Place Market, downtown business district, and Pioneer Square will vastly improve. Do you see that?
Yes.
So what are going to be the vast improvements to connect the waterfront to the downtown business district?
Well, you'll have the Overlook Walk. There'll be many different ways that you can get down to the new promenade area from the Overlook Walk. A lot better signage and connectivity routes through Pike Place Market up to the downtown Pike Pine corridor area.
Can you describe what you mean by many different ways to get down?
If you look in the addenda, there's an exhibit that shows the before and after access points and how they differ. And that would be, I would just refer you to that.
Okay.
There's a map. I can't remember if the map's if we put the map in the report or if it's in the addenda, but there's a map that depicts the access point differences in the the Pike Place Market area.
And I apologize, I'm not sure what's happening with this blurb going over, but I wanted to also call your attention, moving gears a little bit. At the end of your discussion with Ms. Lynn, There was some conversation around reference in the report to what was retained in your files. I've highlighted in blue this half sentence: supporting documentation is retained in the appraiser's files. Is that the reference that you were remembering with respect to what is in the report about supporting documentation being retained?
Yes, I believe.
And can you describe a little bit what the nature of the supporting documentation is that's been retained?
Have you not looked at the backup data file that we provided?
Okay. I have not. I have not received a backup file, but if I'm now going to the link that Ms. Lynn had referred to, and all these materials that are on the Seattle Clerk's website, is this the information that you're referring to?
Yes.
Okay. The if we go through all of this information, we see 34 different links, and as we saw with one of them, within each of those links, there's a number of files and various content. Is that correct?
That's correct.
Are the individual spreadsheets that were used for determining the values of the roughly 1,050 commercial properties anywhere in any of this information?
No, they've just been provided to those people that have appealed their assessment for the purposes of this hearing.
If we go back now to the report, I apologize. I want to still be at the bottom of page 3. Go down just a little bit. Near the and in page 3 here, this is part of the cover letter. You had described it as when you were on direct examination with Mr. Filippini earlier. Is that correct? And I apologize for not being very competent here, trying to deal with the photo images of the three of us alongside. But what I'm doing is focusing at the bottom of page 3 of Exhibit C17. There's a reference to the variety of different types of properties that are located within the LID boundaries. Do you see that?
Yes.
And would it be fair to say that the impact of the LID improvements differs for different types of properties? In other words, high-rise office buildings are impacted differently than high-rise condominium structures, et cetera, et cetera.
Yeah, there are some differences, yes.
Okay. What are some of the main differences?
Just the market's perception of what the before and after values would be based on the highest and best use of the different types of properties.
What are some of the factors that impact the different market value perspective for different properties?
Well, for instance, the office market most likely would be a little less impacted by it. It would be a nice amenity for them. The retail market would be impacted a little bit more with the increase in tourism and the potential for revenue increase in sales, things of that nature.
So the increase in value attributable to retail properties is generally a result of an expectation of increased sales volume resulting from the construction of the LID amenities. Is that correct?
Yeah, that and increasing the investment desirability of the building, the market appeal of the building in the marketplace.
And isn't the market appeal of a retail property the volume of sales that it generates?
That would be one element, yes. I think is there, the aesthetic appeal, um, having just a better relative location in the market.
So a pretty building that generates $1 million of net revenue is worth more than an ugly building that generates the same $1 million of net revenue?
Well, I think the investor would like a more aesthetically pleasing area to have either one of those buildings in.
Was the aesthetic of the exterior of the commercial properties one of the factors that you looked at in determining what the range of rent increases or decrease in capitalization would be after the construction of the lid improvements?
Yeah, to some degree, when you're appraising any property, the elements of the existing improvements, if they're an example of the highest and best use of the site, would be considered.
Let me move on to the next page. The first full paragraph because the beginning of that is the continuation of the prior paragraph describing different types of properties. It says special benefit to affected properties is derived from enhanced relative location provided by the lid improvements. Can you please describe what that means? What is the enhanced relative location of a property provided by the lid improvements?
Well, elements such as the overlook walk, the promenade, things of that nature tend to enhance the relative location of the property in the marketplace in our opinion.
I still don't understand what you mean. If we've got a property that's 2,000 feet away from the promenade, what is its enhanced relative location?
Well, I just think it's a market factor where the market would perceive the proximity of that property to the waterfront as a positive amenity.
And what's the percentage of rent increase that the market would give for that perception?
It would vary depending on what type of property it is and where its location is relative to the before and after conditions.
So if we move down to the next paragraph, there's a reference to areas A, B, C, D, and E. Do you see that?
Yes.
Are you familiar with those area concepts?
Yes, we originally derived those going back, I think, to the feasibility study, just to as kind of a basis from moving from the waterfront towards the I-5 area or towards the east.
Okay. And you indicate that properties within those areas experience different degrees of special benefit due to variations in proximity to the above project elements. Does that mean, for example, that area A is in different proximity to the improvements than, say, area E?
Well, there's some overlap there. I mean, we'd originally set those up just kind of as a descriptive element to show the various areas.
So which area a particular parcel in no longer affects the degree of special benefit?
Say that again, please.
So are you suggesting that which area a parcel is in no longer affects the extent of the special benefit received?
No, as I said, we were just using those areas for informational purposes, just for descriptive purposes, to inform the reader. They were just used in that context.
Okay. So is it true or false that properties within Area A have a different proximity to the waterfront amenities than the parcels in Area E?
Well, again, there's some overlap there, and I believe Area E comes down pretty close to the waterfront from the Pike Pine corridor in that area. So there's some overlap in those areas.
Move down towards the bottom of the page here, and again, I'm changing topics, but I want to try to move through the document sequentially. With respect to the before valuation in your special benefit study, there's been a lot of discussion around the impact of the removal of the viaduct and the improvements to Alaska Way. As I read this last sentence, am I correct in understanding that it's describing the assumption of the removal of Alaska Way as obviating the need to take into account a change in view when determining the difference between before and after values?
Well, no, we're just specifically saying that both in the before or without condition and the with condition, that the viaduct is no longer there. And so
well, but I mean, you're also saying specifically any view amenity enhancement created by removal is not considered, right?
Correct.
You're not having to worry about whether or not a property's view got enhanced as a result of the removal of the viaduct. That's the main purpose of assuming that it's done. Am I correct in understanding that?
Yes, that in the before, the viaduct is no longer there, so there's no view obstruction. And in the after, the viaduct's no longer there, so there's no view obstruction.
And so for a property that did not have a view obstruction, that hypothetical wouldn't have a material impact on the before value calculation, correct?
Well, it may. If there's no view and obstruction, yeah, no, the impact in the before wouldn't have been reflected in the market.
I'm going to move on now to page 5. And again, I have highlighted the piece I want to focus on. It says, the recommended final assessments are reasonable and proportionate to each other. And you testified earlier today that proportionality between the different parcels is one of the key things that you were concerned about, correct?
It's one of the key factors in the statutes that we have to comply with when doing our study.
Okay, and then at the end of the sentence, it talks about that those values are based on consideration of highest and best use, with values derived from comparable sales data. Do you see that?
Yes.
And is this indicating that all of the 6,000 properties within the lit area were valued on the comparable sales methodology?
Where the data was available, the sales were utilized. The vast, the 5,000 condominium units, yes, all of those were analyzed on a comparable sales basis. The vast majority of the downtown property consisting of Belltown, the downtown core, Pioneer Square, we had sales data for the vast majority of those properties. There were some special purpose properties that there was no comparable sales data.
Isn't it the case that all of the commercial properties, the roughly 1,050 commercial properties, were valued using the income approach rather than the comparable sales approach, and that the comparable sales data was only used as a check on reasonableness?
Well, yes, and this is one, you're taking one statement out of a large report where we talk about utilizing the income approach consistently throughout the study. So, that's one context in the whole report.
Right, and I'm taking you now to page 8, where this reflects I think what you've just said, that the comparable sales approach was primarily used for the retail for the residential properties, with the income approach. Actually, let me back up. I've maybe jumped ahead a little bit, but here we're talking about. It does indicate that you've also used the income approach. I want to focus on this second sentence. The primary reason the market reflects increased value due to the project is enhanced location, improved pedestrian connectivity, and higher market appeal created by the waterfront improvement amenities. In the income approach, this is reflected in increased rents and lower vacancy levels, higher capitalization rates as lower perceived investment risk. Do you see that?
Yes.
So, earlier today, you were taken through some of the individual spreadsheets that were used, and we saw high and low percentage rent or room rates, and high and low valuation or capitalization rates. Are those changes in those two levers the way by which the increase in market value was measured in your study?
Yes, those were the factors we saw in the marketplace and in other study areas we looked at. And obviously there's an interrelationship between the sales comparison approach and the income approach, in the sense that the overall capitalization rates are derived from the income approach. So there's an interrelationship there relative to the comparable sales.
And there are no studies that specifically quantify the expected percentage of rent increases or the expected percentage decrease in capitalization rates that would be tied to any particular type of enhancement that might be a component part of the lid improvements. Is that correct?
A number of the studies that touch on varying degrees of, say, office rent or retail sales increases, things of that nature. But no, there was no specific study on, say, capitalization rate changes that we utilized. It was primarily based on our judgment, looking at the property and the before and after condition, based on all of the other studies we looked at, and again, our judgment and the information obviously we had, and the extensive information we had obviously in the Seattle market area.
Okay. And you didn't start with any type of formulary or methodological approach to applying either rent increases or capitalization rates to the various commercial properties. Is that correct?
Well, if you look at our backup data, we've got extensive comparable sales sheets that reflect various ranges of capitalization rate for, say, historic properties versus apartments versus
that's not the question that I asked. The question is whether you used a specific method or formula. So for example, did you say, okay, starting immediately adjacent to this amenity, the rent increase is going to be assumed to be X, and for every so many feet away, we're going to reduce the high and low of those assumptions. You didn't do anything even conceptually like that, correct?
Well, I don't think anything like that would reflect the market. You've got to look at each property on a.
Well, haven't you indicated that proximity to the amenities is one of the key things that the market looks at?
Yes, and it may change from parcel to parcel depending on the type of use, the desirability of the investment, things of that nature. So, you know,
So how do you make the determination of how the market will consider those things? If you're not using some type of standard rule of thumb that you're applying as you get further away, could you have a situation where, you know, immediately adjacent, you've used 1% rate increase, and further away, you actually use a higher rate, even though, you know, the general perception would be that further away, there would be less of a benefit?
The purpose of our study is to estimate the fair market value of the properties. So that's more reflected in the proportionality that you see from the before and after values, where you'll see that type of consistency when you're looking at proportionality on the before and after market value estimates.
Isn't it true that the after values are a direct result of how high or low your percentage increase levers are?
Well, they'll vary depending, and again, looking at the different scenarios based on market rent, vacancy change, capitalization rate change.
But let's walk, so if you make an assumption that the rent is going to increase 2%, you're going to get a higher after value than if you made an assumption that the rent is only going to increase 1%, correct?
Well, again, I mean, it would depend on
is that true or false? It's a straight up, okay.
Typically, that's true, yes.
Give me a situation in which increasing the rent in an income approach would result in a lesser increase in value.
Well, if some assumption was made that rent's going to go up and it would increase the investment risk so much in the property that the capitalization rate would be higher, it could create a lower value, but it's typically not the case.
All right. So even though it's typically the case that the further you get away from the amenity, the lesser the impact of a potential rent increase is, you did not use a specific methodology to set your assumptions, but you instead made individual determinations for all 1,050 plus commercial properties?
That's correct.
So it's possible that you could have similar properties right next door to each other that had different assumptions made about rent increases, for example.
What we're reflecting is the market, and it would depend on the type of property and the type of space you're talking about.
Is it possible or is it not possible?
Well, it's certainly possible. You know, you could have two similar retail buildings next to each other, and one has a real high level of build out and would command a higher market rent, both in the before and after, than the adjacent property, which needs a lot of tenant improvements, and therefore in the before and after it would still reflect the difference in rent change, but the rent amount would be different.
Okay, well, let's distinguish between different rent amounts and different percentage increases in rent. A different rent amount is talking about different starting points that gave you your before value, but your after values were calculated based on assumed percentage increases. Isn't that true?
That was one of the ways we looked at it. We also considered vacancy. As you got further and further out, there may have been no rent change, but maybe a little vacancy change and a very small capitalization rate changed. It just depended on where the property was located at and the type of property and how we felt it would be reflected in the market, both before and after the LID.
As a result of your individual judgment on each of those 1,050 parcels without any specific consistently applied methodology, correct?
Well, we're applying a consistent methodology in that we're looking at each parcel as it exists in the marketplace based on its highest and best use before.
So we've got two properties right next door to each other. You've determined that both of them are occupied at their highest and best use. They are the same type of property, whether they're both high-rise office buildings or both large retail establishments. What would cause you for immediately next door properties that are very similar to each other to make a decision that you're going to apply a different percentage rent increase estimate to calculate a future value?
Well, there may be some differences again in build out, in the appeal of the property in the marketplace.
And where would a reader of your report be able to discern that that was the basis for your having made those different decisions?
Well, part of a process like this is hearings and appeals to what we do. So property owners that would like to appeal can ask questions like you are to try to gain that information. We don't do individual reports on each property.
Okay. Let me kind of try to maybe reframe us a little bit. Isn't the basic question that's being asked with respect to coming up with a special benefit amount is how much more would an investor pay for a specific piece of property based exclusively on the lid improvements and on no other considerations? Is that correct?
Yes, it's the market value difference in the before condition compared to the after condition. That measurable difference in market value is the special benefit.
And so the key thing that we're trying to isolate here is the increase in value that is specifically and exclusively attributed to the lid improvement, not differences in value that are attributable to other factors, correct?
Well, those other factors would be relevant in the before condition. So yes, we're looking at what changes occurred in the after. And in this instance, it's the 6 components that comprise the local improvement district.
And the method by which you measured that so-called special benefit, the difference in an amount that an investor is assumed to be willing to pay if the property had was benefited by the lid improvements, was computed by looking at ranges of potential value change attributable to a range of rent increases, a change of occupancy rates, and or a change in capitalization rates, correct?
Yes, both of those methods were applied both in the before and after to derive an indication of what the market value difference would be. Those were also then compared to comparable sales to as a test of reasonableness to the conclusions. And also the sales were used to derive capitalization rates for the various types of properties.
So all of the comparable sales that were used resulted in actual transactions that were not impacted at all by the after characteristics, correct?
There were some sales that occurred after the LID was formed, so there would have been some knowledge in the marketplace of anticipation of the LID improvements, but no, I mean, obviously the LID improvements weren't constructed at that time, so they would have had a preliminary assessment and been aware of the project, but it wouldn't have fully been realized within the context of the sale price.
So they would know that the product, the parcel was subject to the cost of the future assessment, correct?
Yes, and that future assessment amount was then based on an estimate of the market value change during the time of the formation study.
And a number of those before or those comparable sales were several years ago, correct?
Well, our study was in October 2019, and we had a number of sales. So
Went back to it's 2017 and some even earlier than that, correct?
we had a number of sales in May of 2019.
Did you also have sales in 2017 that were used?
Yes, we looked at sales as far back as then for the final, and even further back from then when we were doing the formation study.
And all of those sales didn't even take into account at that time the before improvements that were part of your analysis, correct?
Not in the formation study, no.
And by when you say not in the formation center, you're meaning I am correct in what I said, correct? You're agreeing with me, or are you disagreeing with me?
No, I'm agreeing with you, and they wouldn't have known about the project during they wouldn't have known about those elements of the before condition in the formation.
I'm going to now jump ahead to, and I'm going to try to pick up the pace here. This is just the table of contents, and there's been reference to two different spreadsheets. I just want to confirm that this S1 to S13 to 13 and S1 to S79 are those two different big spreadsheets for the commercial and the residential properties that basically follow right after the table of contents here.
That's correct.
And then if we go down to the, I'm not sure why I'm having difficulty scrolling here. Oh, here we go. I've got in the wrong bar. So if we go down further, there's an area here that right in the middle talks about these different areas, A to E, and the different neighborhood descriptions. Is there a correlation between the various areas and the neighborhoods?
No, they overlap. But again, when we originally started doing this study, we set up those areas just more for a observational, informational view of the LID boundary area. So there's really no relationship between those and the neighborhoods. They overlap.
Okay, I'm moving now to page 116 on the document, and about the middle of the page, there's a statement that's been highlighted. Typically, properties closer to the waterfront improvements experience the highest overall increase in market value. Hotels and retail properties reflected slightly higher special benefits in most instances, depending on location relative to the lit improvements. Do you see that?
Yes.
So is that suggesting that the properties closest to the waterfront kind of have the biggest special benefit, and then the next highest grouping would be hotels and retail properties?
Again, depending on their location.
Okay. Can you explain more clearly what you mean by depending on location, since you apparently don't mean proximity to the improvements?
Well, I do mean proximity to the improvements, but when you get out into the Denny Triangle area and areas like that, the benefit decreases considerably. So there may not be a lot of difference between the property up in that area because of the influence from the LID becomes less and less as you move further out. And as you move further into the waterfront, hotels like the Marriott Waterfront Hotel, the Four Seasons, and hotels located closer in proximity to the promenade and the elements of the waterfront improvements would reflect a slightly higher increase in value than, say, an office building that's that's located nearby.
Okay. I apologize but I'm tremendously confused right now because I feel like I've heard at certain points in time that there's not a linear relationship between proximity and impact on value, that it depends on other factors, and therefore you can't just think about proximity. And I've heard at other times that proximity is the primary driver. Which of those is true?
We look at proximity as well as other factors of the property.
What other factors?
Well, it's use, its location to the improvements. Like I just said, that an office building that's next to a hotel may experience slightly less benefit than the hotel due to the operation of a hotel in conjunction with the types of improvements that are being constructed.
But a hotel closer to the improvements is going to have a higher benefit than a hotel further away from the improvements. And the same is true for an office building, correct?
Yes.
And hotels are going to have different relative benefits for amenities than office buildings, than retail, than sports stadiums, and so on for each of the 10 or 12 different types of properties that we walked through earlier?
Yes, each property is looked at individually, parcel by parcel basis.
But you didn't then make a determination that, say, for office buildings, here's the linearity that we're going to use for rents as we get more proximate or further away from, and we're going to use a different standard for retail or apartment. You simply use no standard at all for any of them, correct?
We didn't use any like linear approach like that. I don't think it's really applicable to the market. I mean, each property is going to stand on its own merits and its own physical factors, and to use some sort of linear to say they're all going to increase X for proximity and X for aesthetics and X for location. It's just, in my opinion, that's not reflecting the market. And so we do it on a parcel by parcel basis based on our judgment.
I'm going to move now to page 122. We're describing before situation for the Pine Pike streetscape area. And it's saying it's going to assume that westbound vehicular traffic is going to end at the entrance to Pike Place. As I read this, and then it also describes the eastbound as continuing as the current situation. I read that and it seemed to infer that in the after there's going to be a change in the traffic direction on Pike and Pine. That's not true, is it? There's not going to be a change to traffic direction. It's going to be the same both in the before and after.
Yes, Mr. Edwards. Just LID is not about any street improvements. Both in the before and after, the Pike Pine street would be the same.
Okay. I'm going to jump now to page 153. And specifically as I go down, there's a reference here to a New York City Department of Transportation report titled The Economic Benefits of Sustainable Streets. Do you see that?
Yes.
Is that the report that was being discussed earlier today?
Yes, I believe so.
And if I go to the next page, on page 154, this discussion of a New York City NYC DOT study, it's referring to the study that we just saw cited on the prior page.
Yes.
It said, and you specifically call out a particular case study found that within the first year, there was it says sales prices in the study area went up 18%. What does that mean? Is that talking about the sale price of properties in the study area?
I would have to go back and look at the context of the report when they seem to be talking about it, and it's been a long time since I've read this, so I mean, I'd have to go back and look at it, but it appears they're talking about the sale prices of property in the study area went up 18% and then even higher within the second year.
There'd be a material difference if they were talking about sales prices of property versus the volume of retail store sales at stores. Is that correct?
Correct. And in my thinking, that study, I think, dealt more with, and this dealt more with the retail sale price increase, not the sale price increase of the property, is my recollection. But again, I'd have to go back through.
Yeah, well, we will be looking at that study as soon as I get off of this page, and it will reflect that your recollection is correct, that it was talking only about retail sales at stores and not about selling prices of property. But
that could have just been a misprint there. We should have been clearer than to say sale of retail price sales or some other clarification there.
Or retail sales.
Or retail sales, yeah.
And so, but your next thing.
Excuse me, Mr. Edwards,
Yes.
if you read the next sentence, I mean, we do say one of the test neighbors had a drop of 17 in sales, and we should clarify that. Yeah, yes, I agree.
Okay, and then right after that piece, it says these figures, I presumably referring to the selling retail sales volume changes, indicate an increase in value due to the project of 5% to 14%. Did that come from the study, or is that your calculation?
I don't recall.
If I were to tell you that the study doesn't purport to make any opinions about value increases, would that help refresh your recollection?
Yes, then we would have been inferring those retail sales into an income analysis and what probable range that those types of retail sales would reflect in the market.
And would that be part of the supporting materials retained in your backup files, the calculations on how you got from volume of retail sales to property value increases?
Well, they'd be reflected in other studies that were done for various other cities for comparison purposes.
So you looked at studies that converted retail sales volume increases into value increases?
I don't know that specifically, but some of the studies did increase market value differences from various elements of the improvements.
But aren't you here saying specifically that that this increase is tied specifically to sales volume increases, correct?
Yes, what we're saying, if the revenue is increasing in that level, that it'll reflect an approximate increase in value from 5 to 14%.
And that's basically a formula based on certain assumptions about the capitalization rate, correct?
Yeah, there would have been an internal estimate we made if it in fact is not, if it's not in the report as you indicate.
Yeah, and would you have saved that?
We probably just referenced it here. I don't know if we have a specific analysis saved in the backup file relative to this study or not.
Okay. Did you use this study to make determinations about percentage of rent increases or capitalization rates that were used in the 1,050 plus individual spreadsheets that you used to come up with a special benefit estimate?
Well, again, they were just used for background information to provide a a basis for how the market's reacting to different types of elements within the LID area.
I'm going to jump now to what I had told you I was going to, and I thought I'd have this set up a little. So this next, do you reckon, this is our exhibits, a CWF 0314 Exhibit 9 that was circulated yesterday afternoon. And obviously my computer doesn't like having so many different big things open today. So you bear with me for just a minute here. I had this open earlier when I was preparing. I am still trying to be finished, Mr. Hearing Examiner, by 5:15.
Thank you.
My first question is going to be, do you recognize this as a copy of the study that we've just been talking about? Obviously, you're going to. And you'll see here, it's called The Economic Benefits of Sustainable Streets, the New York City Department of Transportation.
That looks like the similar study that we utilized that's in our background file.
Okay. And for some reason, my share screen is right where I want to go to try to get to the next page. So if we go here, now this is page 24 of that same document. And I would point out to you that here we're looking at the 18% first year, 48% second year, and the range of 7 to 22 with a year of -9%. Is this the specific case study that was referred to in your report?
Yes, this is one of the case studies that we used for background information.
Okay. My computer is unfortunately mad at me for having so many things open. Wanted to start, back up a little bit. So this is case study number 2, St. Nicholas Avenue and Amsterdam Avenue. And it's hard to get it all on the screen. I'm going to represent to you before I show you the deal at the bottom, that the green reflects the particular project, and that the mauve or purple or whatever it is reflects the 3 areas that were used as a comparison. Do you see that?
Yes.
And so they were comparing the results, immediately, 2 blocks north and south of a 2-block area, and immediately 1 block east of that same area.
Yes.
And as I say, it does, the green and the purple are what I reflect there. And here's a description of the project, and it talks about directional changes to the St. Nicholas Avenue, as well as a segment of West 161st Street. That's not the same type of changes that are happening anywhere within the Seattle lid, correct?
No, I mean, the Seattle lid is more about, the enhancement of the sidewalks, the public space area, adding more area for restaurants to have tables outside and things of that nature.
And then I want to take you up here as well, where it says this project was selected for study due to its unique nature as a hyper-local retail hub. Most businesses along the project site directly serve the surrounding community and do not generally serve a regional clientele. Would that be accurate to say of all of the commercial and retail space within the Seattle lid?
Well, I think you have a lot of tourism coming in, so they serve more than a local clientele.
So it's looking at something different. This particular study is looking at something that's materially different from the Seattle LID project, correct?
Yes, Mr. Edwards. I mean, a lot of the studies we looked at, we knew we weren't going to find exact examples of what was being done for the variety of different improvements within the LID area, but there is some level of comparison here that we would have felt, you know, reasonable to look at and see how the market's reacting to.
Okay, I'm going to take you now to the page 5, which is part of the executive summary of that study. I'll note on the left there talks about their goal being to develop a new metric and specifically measuring changes in retail sales, specifically reported sales for street level retail and restaurant food service businesses. Do you see that?
Yes.
And the retail involved in the LID is more than just that, correct?
Yes.
Okay. And then it goes on in describing their methodology. They filtered out the tax data so that they only got tax returns where the address filling out the return was the physical address of the particular store, and concluded that as a result, they're basically only picking up local mom and pop stores and independently operated franchises. Do you see that?
Yes.
And again, that's not the only type of retail that's involved in the waterfront LID, correct?
That's correct.
Okay. I'm going to move now to my next exhibit, which is Exhibit 1. And if it's okay, I'm going to actually, to try to prevent some of this, exhibits 1 through 5 are each printouts of pages or from the Seattle Waterfront website. So I'm actually going to move to that website instead to make this a little bit easier. But Exhibit 1 is a printout of this page, again, the landing page. And I note that there are 12 different projects under this Explore Seattle Waterfront that kind of defaults to the Alaskan Way project. As we scroll down on this a little bit, we see something that's all color-coded. That's reflecting specifically the Alaskan Way components of what is otherwise outlined in the depiction here. Is that correct?
Yes. Is something new or something that is in our backup data? Or
this is on the seattlewaterfront.org's web page as we speak today. I mean, we're looking at it live right now. I printed it out yesterday.
Okay.
So,
do you know what when was this compiled? You know, is it 2020 or is it 2000?
I don't know specifically, but when we move to the next one, we'll see that it's been there for a while.
Okay.
Yeah. The main thing that I want to focus on here is we've got 12 different projects that are linked here. Only 6 of them, as my understanding, are part of the LID. And that's one of the things I want to confirm with you. The LID specific ones would be the Park Promenade plus Bike Path, Overlook Walk, the Water Pier 58, Pike plus Pine Renaissance, Pioneer Square, and Union Street. Is that correct?
That's correct.
Okay. And yeah, I'll just note it, as you click on any one of these, you get taken to a page that's specific to that particular project. And then you'll see how the highlighted, or the colored in area within the boundaries changes to highlight the specific project. Do you see that?
Yes.
And down below, there's a kind of a timeline of status. I'm going to now go Exhibit 2 that we've submitted is this page here, the Pike and Pine Renaissance. And you'll notice how the outline has stayed the same, but the areas that are highlighted have changed. And now instead of there being anything down on the waterfront, you see these two little bars coming up from the bottom of the image of at Pike and Pine Street. Do you see that?
Yes.
And there's dotted lines, two different dotted lines. One is straight, and the other one has a lot of curves in it that point towards the waterfront. Is this reflecting that the physical connection between Pike and Pine and the waterfront is not actually part of the lid improvements? So there's nothing being done between First Avenue and a little bit west of Western with respect to the lid improvements?
Well, the overlook creates new connections to the waterfront from the terminus area of the Pike Pine corridor. So I don't know what if this study is anything that that I looked at. I don't remember the squiggly lines, but like I said, there's in the addenda there's a before and after map that depicts the different access points that are derived from the Overlook Walk connection to the Pike Pine corridor connection.
Okay, and what's the scope of the Pike Pine corridor streetscape improvements that are part of the lid?
Like I said, primarily, landscaping, providing better sidewalk area for.
No, I'm really talking about the geographic limits of it. It's starting at First Avenue and going east. How far?
I believe the LID goes to 9th.
Okay. As we're looking at the next page of the document, it's illustrating the Pike Pine Renaissance project. And I note that the lines don't stop at 9th Avenue. They go all the way to Minor and Melrose. And then there's some dotted lines that seem to go a little bit further and would connect Pike and Pine. Do you see that?
Yes.
Are you familiar with what's planned for east of 9th as part of the Pike Pine Renaissance project?
Oh, probably a year or better ago, I met with the Steve Pierce, who's the engineer on the project, and he talked some about elements a little ways out off of 9th, but they were outside of the LID. So I believe there are going to be some additional landscaping and enhanced lighting in the area between 9th and like Minor, but there again, it's outside and not part of the LID.
What is the budget for the Pike Pine Renaissance project?
I don't recall specifically the dollar amount for that specific improvement.
Do you recall how much of the cost of that is going to be charged to the lid?
Not off the top of my head, no.
Okay. This is now, I'm clicking on the link to portfolio, and you'll notice this document is dated November of 2019. So basically contemporaneous with when you finalized the lid study, correct?
Yes, we delivered it to the city in November of 2019.
Okay. And this refers to the Pike Pine Renaissance Act 1. Do you see that?
Yes.
And under the budget, it shows a total budget of $37 to $40 million.
Okay.
Do you see that?
Yes.
And it indicates that basically half of that $40 million budget, $20 million, is going to be charged to the lid.
Okay. Yes.
Okay. Can you help me understand why a portion of this project is being treated as part of the lid and not the rest of the project, and this is the one of 6 elements that is not physically contiguous with all of the other elements?
That is just how the LID components were structured, and and given to me to value.
Did that impact your analysis of how different parcels within the lid boundary were benefited by the lid improvements?
Well, again, we looked at all 6 components as one entity. So depending on where the property was located within the context of the LID boundary, the difference in value or benefit would have varied depending on that location.
So are you suggesting to me that a property that is adjacent to Pine Street but 2,000 feet away from the waterfront would be treated as the same proximate distance to the improvements as, say, something that is, 400 feet from the waterfront, and 400 feet from Pike and Pine?
Well, again, it would depend on the property type and what type of highest and best use it was.
But I mean, isn't it factually true that the market is going to value proximity to Pine differently than it values proximity to the overlook or to the promenade or any one of these different, each of these different features? They're not going to be viewed the same in the marketplace, correct?
Correct. I think if you're close to the overlook walk and like on 2nd and Pine or 1st and Pine, and you're real close to those amenities, you would have a higher benefit than you would say at 6th and Pine being being further away from some major LID improvements.
And Mr. Hearing Examiner, I see that it's 5:15 now,
Yeah.
and I probably have about 10 to 15 minutes more. I had been hopeful that I was going to finish within your time frame, but it doesn't look like I was successful on that.
That's not a problem. Let's pick up there at 8:30 on June 25th. I do want to check with everyone who's been with us today for this hearing date. How has the tech gone? I mean, and I don't need positive response. I need negative. Please note for me and note for the record any issues you've had with the tech, with utilizing Zoom as a remote platform, reception on your end. I note for the record that Mr. McCauley broke out about sometime between 2 and 3 when he was being questioned by Ms. Lynn, and we did have to ask that the question be re-asked and then the answer provided. Otherwise, things have seemed to have been working from the end of the hearing examiners. Anybody else need to note anything to bring to my attention with the record with regard to a remote hearing forum?
Mr. Moses, I had trouble downloading one of Ms. Lynn's documents. I'm not sure why. The others seem to download just fine. Other than that, a comment that staying in share screen mode with the 3 speakers, you, the speaker, and the questioner on the side is much preferable from my point of view anyway, to flipping back and forth and trying to deal with documents separately. Having it all on one screen is much easier to deal with.
Understood. I'm not able to accommodate that as I need to be able to visually evaluate both counsel and the witness, but I do appreciate that we've had an opportunity to have more share screen and see the documents when they're being directly used. When they're not in use, I do need them to be continued to be removed so that we don't have them occupying space when they're not under use. And if you can work out the exhibit accessibility with Ms. Lynn, that'd be appreciated. I note that I've had some connectivity as well, but I'll be on my end, I print them out as part of the hard copy record so that I can access them. Anyone else have any issues with the tech for the day? All right.
Other than having difficult, slowly opening that one document, everything's been working fine for me today. I did have the same observation you did, that there was that one point in time where the Ms. Lynn and Mr. McCauley were phasing out, but that was very temporary.
All right. Thank you, Mr. Edwards. And yeah, a little bit of delay. Honestly, the delays I've seen are not any worse than I've seen with counsel flipping through a notebook or finding an exhibit from their associate behind them or something along those lines. So we seem to be proceeding well enough. I do want to note that I think that we do have some exhibits that you've got for the record. Do you want? I guess we'll wait for that. We could do that on the 25th.
Yeah, I was intending to just move the admission of all of them at the end of my cross-examination, but
Let's do that then.
okay.
All right. And then I do want to note, just I'm not sure how everyone's been proceeding. I do see some websites being referenced here by Mr. Edwards. It seems like he's got all the pages coming in as separate exhibits, which is good. Because I want to note that for anyone that may be seeking to do this, I've seen it in the past, and again, I haven't seen it here yet, but I just want to warn anyone that providing a link to a website or a database is not sufficient to make the entire website or the entire database part of the record. If that's something you're seeking to do, you need to bring it to my attention. Generally, even large documents, unless they're obviously central to the case, like Mr. McCauley's report, only the segments of large documents or databases that you're actually referencing as part of your case will be entered into the record. But I just offer that as a heads up in case anybody was thinking they might do that. I haven't seen anybody attempt it yet. With that, we will conclude for the day, and appreciate everyone's participation. I think we're making good progress. I appreciate the arguments that I'm hearing, and the representation has been good. We will reconvene June 25th at 8:30 a.m. Thank you.
Thank you.
Thank you.